ಆಕ್ಚುಲಿ ಇದು
on submission. This is matter related to Milord the divorce between Mohammedans. Milord, he has had approached this honorable court challenging the order of IA. Milord, he had given the wrong address in the of respondent for purposefully, Milord. My Milord, and obtained a stay. That's saying that notice is served and he has not represented. Milord, after informing in trial court, I appeared for this honorable court. Milord, and last occasion, that is on 13th 12 2024. I appeared and submitted that the wrong address is given. And Lord, this honorable court was pleased not to extend the interim order. And he had not appeared in that on that day. Lord, on 10th this month, he had moved at 2:30 without informing or serving copy on me. Lord, and I extended the interim order. Lord, I'm seeking for, I'm seeking a recall of that order. You kindly have it on day after tomorrow.
Got it.
Great.
List 3, la? List 3 we will call this. First you call it adjournment something. Yes.
Next week, I will intimate at the site.
Learned counsel for the respondent seeks time. Same is granted. Call next week.
Please.
My lord, list number 2, my lord.
No, second list. First list.
36 use asking 36. Yes, asking
36.2.
serial number.
36.2, my lord, for adjournment. Connected time for applying, my lord.
You're ready now.
Need time to deposit Saturday amount.
36.2 you're appearing for
For appellant, my lord.
appellant, claimant. The other two is filed by whom?
Insurance company, we have filed up.
What about 36? Who has filed that?
36 one for owner appeal, my lord. One more.
Okay, owner, insurer, and the claimant.
Please, no.
Request of the claimant. Call this matter after 2 weeks.
Please, no. Please.
Is number 51, my lord.
Paper appellant counsel, my lord. I left next week, my lord.
At request of learned counsel for appellant, call on.
Serial number 50, my lord. I am for appellant, my lord. Last week's time, my lord.
At request of appellant, call this matter next week.
Much obliged.
Call on, Madi. Next week andre agalla. Call on.
My lord, serial number 54 minutes. I'm for the respondent. I have informed the other side week's time.
Appearing for the appellant in 54.1 year. They are seeking adjournment. Kindly have it on next week.
Request of you're for whom?
Respondent.
Yaru claimant, insurance owner, who?
54.1 only, I am the owner of the vehicle.
Claimant.
There are two appeals.
Request of the claimant, call this matter on.
See number 53, my lord.
Hmm.
For the respond number 1 in this case, I left the next immediately.
At request of respondent number 1, call on.
My lord, serial number 35, my lord. My lord, 35. My lord, this matter is connected with the MFA 7555/24. Filed by the claimant, my lord.
Call along with. Call this matter after 2 weeks.
My lord, 60. In this case, the connected appeal filed by the claimant is pending before division bench. Pending before division bench. I will take necessary steps. 2 weeks may be granted.
At request of respondent counsel, call after 2 weeks.
59.
Much.
59. I have it for appellant.
At request of appellant, call after 2 weeks.
Serial number 61.
At request of appellant, call after 2 weeks.
My lord, page 3. My lord,
Yes, Anita.
my lord, kindly, my lord.
This is a matter pertaining to which is this court hall, madam? Court ಟೋಟಲ್ ಗೊತ್ತಿಲ್ವಾ? ನೋಟ್ ಅಲ್ಲ. Total 25 matters. ನಾಳೆ ಬರ್ತಾರ ಅವರು?
Yes, my lord.
ತಗೊಳ್ಬೇಕಲ್ಲ ಮಾತು. First thing, when some other matter is coming up, you should ask when the whole lordship is coming, when the ladyship is joining. ಅದನ್ನ ನೀವು ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೋಬೇಕಲ್ಲ. Await service of notice. Hold on. Put it next week.
For respondent this matter.
Yes, you are not taken.
Respondent, I filed Wakalat today.
Who are you?
I'm for respondent, representing respondent. I filed Wakalat today.
What's your name? Name.
SB Siddheshwara Swami.
Advocate name. What's the case number?
Serial number 2, CP 493/24.
The name is Siddheshwara.
SB Siddheshwara Swami.
HB Siddheshwara. Registry to show the name of learned counsel. Shri HB Siddheshwara Swami. The cost list. All after 2 weeks. Umesh.
My lord, I appear for the.
Madam, you are for? All right. Yes.
Well, I appear for the petitioner, appellant, my lord, in one of the matters.
Non-filing of charge sheet. Who has to file that charge sheet copy? Appellant, you have to. Mr. Umesh, you have to file.
No, my lord, the other side is supposed to serve a copy, but subsequently they have served me, my lord. They have given the copy, my lord.
Copy served.
Yes, my lord, it is given.
You have served copy. Learned counsel for respondent. You are the insurance, you are for claimant? The copy served to the insurance company.
Yes, my lord.
For the insurance company acknowledges the receipt of copy.
2 weeks since, my lord, I have undergone
Copy
an
of the charge
operation.
sheet.
Yes, my lord.
No, you are ready to argue. Mr. Umesh, are you ready to argue?
My lord, I have undergone an operation, my lord, 2 weeks since any date, my lord.
Go before the regular court. Call next week. Date code.
2 weeks, my lord.
Respondent number 2, I am seeking dispensation and filing memo. The owner of the vehicle.
My lord, date I could not hear, my lord.
R2, no?
R2 get. R1 is not Sriram Insurance. Shivanagowda.
Learned counsel for the current files a memo seeking dispensation of notice to R2. Memos accepted, notice is dispensed. Notice at the risk of appellant. Call on.
Case of my lord.
Jagadish. Week's time is granted. If needful done, issue notice to R1.
R1 notice may be dispensed.
What is the compliance?
Compliance.
I am for respondent number 2, my lord.
Compliance. Notice to R1 is dispensed at the risk of appellant. Memo is accepted. Complaints ಏನಿದೆ?
Complaints.
ಏನಿಲ್ಲ? Judge. ಎರಡು ಪೇಜ್ ಜಜ್ಮೆಂಟಲ್ ಮಿಸ್ಸಿಂಗ್ ಇದೆಯಾ?
ಮಿಸ್ಸಿಂಗ್ ಐತೆ, ಹೌದೌದು.
If you have a copy, you don't have copy certified. I'll list it next day. You can argue on that day, you place it.
Please, my lord.
Yeah, when do you want, Mr. Shant? When shall I post this? Monday, next week ಹಾಕೋಣ, Monday, 20ನೇ
ma'am.
ತಾರೀಕು. On that day, you get ready to argue.
Please,
You
my
will place that, we'll dispense with that.
Please, my lord.
List this learned counsel permits, you will comply with the objections, call this matter on 20th
Please,
January.
my job.
ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು TCR? ಹೌದಾ?
Only income.
All right, all right. All.
There is a mistake in the date of, regarding the date of the accident, my lord. Actual date of accident is,
Mistake by you or the
no,
tribunal?
it is in the judgment itself, my lord. In the para number, in the, this one issues, third line, my lord, it should have been 3/12/2019. Instead of that, it has become 3/1/2019. That is the only mistake. So I have filed an application for dispensation, my lord. That extent again.
What about R1 and R3 of trial court not made party?
They are not necessary party in this case, my lord. So I have written,
Who are they?
pardon, my lord, 1 second. Respond number 1 is the party I made. And to manager, my lord, they are already represented.
You are
and-
appearing for,
and chairman.
you are appearing for corporation.
Yes, my lord. So they,
So respondent number 1 and 3, who are they?
they are the manager, KSRTC Davangere.
Driver idare.
And the chairman, both are all represented by the managing director of this one, KSRTC.
Manager, madam, driver. And R3, one is a driver. And R3 is the internal security fund.
Yes.
Oh, officer. So you're on the,
Panel.
no, the liability you're questioning or quantum?
Yes, my lord, liability.
All right. The objection raised by the registry is overruled. What is the order passed now?
Your lordship may kindly help on that. Next week, my lord. Income is taken on higher side and also regarding the negligence. Your lordship may have it for admission in next week, my lord.
All right, list this matter for admission.
Will take steps R3, my lord.
To R3, no?
Yes, my lord.
2 weeks' time granted, if needful done, issue notice to R3.
My lord, in this case, in serial number 5. Yes, file an appeal, my lord. Let him undertake to file wakalat for R1, my lord. R2 and R3, I will take steps.
I will undertake the
Adರಲ್ಲಿ
authority.
you have taken notice.
I will take notice.
So learned count, you will take notice for whom?
Respond number 1.
R1 in 82-32-23, my lord.
Learned counsel Sri Nayak Krishna Venkatraman is directed to take notice for R1.
And R2, R3, I will take steps.
No steps to be taken regard to R2 and 3. Follow on.
Please.
If needful done, issue notice to responding.
My lord,
2
Yes.
weeks' time.
press weeks time, my lord, to file wakalat, my lord. They have
2 weeks is granted. You
Please,
file.
my lord.
Next, Harish.
I'm for applying.
Huh? Elli? Registry to delete the name of learned counsel H.C. Betsur from the cost list. R4 ga? Why?
My lord, I am appear for appellant, my lord.
One nimsha. You are for R4.
Or for Reliance General Insurance Company Limited, my lord.
party is there,
But
I have not received the appeal memo, whether Reliance company is party or not, I am not aware.
So-
But London told that Eastport is ruling the party.
I think they have told.
ನೀವು ರಿಲಯನ್ಸ್ ಅಪೇರ್ ಆಗ್ತೀರಿ ಮತ್ತೆ R4 ರಿಲಯನ್ಸ್ ಇದೆಯಲ್ಲ
The appellant shall be copy on me.
ಕೊಡ್ತಾರೆ ಬಟ್ ವೈ ಯು ವಾಂಟ್ ಯುವರ್ ನೇಮ್ ಟು ಬಿ ಡಿಲೀಟೆಡ್
ಅಲ್ಲ, ನಾನು Eastport ಅಂತ ಬಿಟ್ಟು
ನೀವು ಯಾರಿಗೆ
We are for R2 my lord. Court of
Court. Yes, and ಅದು ಬೇಡಮ್ಮ. Copies to be served to learned counsel for respondents in serial number 6. Serial number 6. Serial number Satish.
Yes, my lord.
ನೀವು ಕಾಪಿ ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ.
Copy serve ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ, both advocates.
ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ, ಇನ್ನೊಂದು ಕೊಡಿ.
Acknowledgement ಇದೆ, ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
Okay. Yes, Harish. 2 weeks time granted. If needful done, issue notice to R1. R2 serve ಮಾಡಿಲ್ಲ. Copies to be served to R2. Shivanegowda. Same 2 weeks time granted. If needful done, issue notice to R2 and 3.
In this case, respondent and have filed for enhancement of the compensation.
The term was not served.
Copy served your last
ಯಾರಿಗೆ?
insurance company in my appeal.
This is the 4806,
Hmm.
for R2 dispensation I have filed,
Who's R2?
owner of the vehicle.
Owner.
Yes, my lord.
New claim, new your insurance company.
Yes, my lord.
So you are now seeking shifting liability,
And not liability,
only quantum.
only quantum.
And notice to R2 is dispensed as he was placed ex parte before the tribunal and no liability is fastened. And liability is fastened on the insurance company.
In my case, 84 days notice served.
You'll take notice in his case.
Copy served your last.
No. How many respondents in your case? That's pretty much.
Only.
777.
Only 2 respondents.
2 respondents.
Who's the second respondent? You need, which respondent? Copy is given to you.
Copies given to me.
ಹೇಳ್ಬೇಕಲ್ರಿ ನೀವು.
Quotes.
Which respondent?
Yes.
Insurance company.
Wasting the time, sir. Be quick so that you assist the court. Learned counsels, GS Marilla is directed to take notice for R1. Notice to R2 ಏನ್ ಮಾಡ್ತೀರಾ?
Dispense your last.
Is dispense at the say of appellant claimant. Memo is accepted. Memo ಕೊಡಿ.
And 84
Delay of
days,
orders on IA1.
and 84 days delay.
Delay
your
of
last.
delay of 84 days is condoned. IA1 of 24 is allowed. Copies to be served. Yes, next. Process fee. 2 weeks time granted if needful done, issue notice to R1. Next. Memo for this. Notice to R2 dispense. Memo is accepted. Stays granted is call this matter after 2 weeks.
Needful done, please, madam.
Needful done, huh?
Please.
The council submits needful is done, a registry to verify if in order, issue notice to R1 to 4. A week's time,
Minor objections, my lord, with the permission of court. Right now, we will comply the office objection, my lord.
learned counsel is. Where is the main matter?
The MFA 1243/224, my lord.
That's not listed today.
No, not listed, my lord.
And what's the point in doing it now? I'll permit you. Learned counsel for the appellant is cross objectors permitted to comply. The objections during course of the day, call this matter along with
MFA 1243/2024.
after 2 weeks. Girish,
Minor office objection, only provisional law is not stated correctly in the appeal memo.
Yes, my lordship, for the major daughter and son, maintenance awarded by the family court.
Hmm.
That has been challenged before your lordship under section 125 of the CRPC.
Hmm.
Petitioner got married with one
Have you
Kamalamma.
paid the court fee?
I paid the court fee, my lordship. Only 3 objection, only provision
That
is not
counsel
properly
for the
mentioned.
petitioner submits he has paid the court fee registry to verify. The other two objections shall be complied during course of the day. Yes,
And the impugned order which is in page number 38, my lordship, in page number. They both are attaining majority at the time of filing the petition for seeking maintenance, though the family court is awarded the maintenance of rupees 10,000 each per month towards the educational expense from the date of this petition till the completion of education or become finally independent, whichever is earlier. And also for the second petitioner, 10,000 per month till her marriage or become finally independent, whichever is earlier. And the petitioner, the respondent got married with Kamlama out of their wedlock. These 2 children are born.
Hmm.
Subsequently, there is a different opinion among the spouses. They got divorced from each other by filing the MC petition. Thereafter, he got married with another woman. And after lapse of 2 years from the date of his decree of divorce in the year 2020, and female child is born out of their wedlock. And his net salary is 20,818. And both the petitioner as well as his first wife is working as a teacher in the government school. And both they have having a responsibility to maintain the children of the petitioner respondent as well as their first wife. And though they are independently, they are attaining majority. They filed the petition for seeking maintenance. They are not pursuing any studies and any education. First petitioner, the son is now working in Zomato company, and the daughter is also not studying.
so both of them are children, huh?
Both of them are children through first wife, and both are
What
attaining
happened to
majority.
the first wife?
First wife got divorced, my lordship.
She's there, available.
This there, she is alive, my lord.
So these two have attained majority as on
As on the date of filing the suit, it kindly peruse the cast title in page number 18, my lord.
19 and 18 years.
As per section 125, it is not entitled for the maintenance for the persons who attain the majority. And it is only they have entitled, they have to prove that they are incapable of maintaining themselves.
What are they doing?
Now he is working in a Zomato company.
Yaro,
First son, no.
how many children are there?
My lordship,
How many children from the first wife you have?
2 children, my lordship.
The Zomato Yaro,
Zomato first wife, Master Manohar,
he's working.
he is working.
So this was the material produced and argued.
I have not produced any material. As
The
per the
court will come.
information gathered from the party, now he is working, not pursuing any study, my
What
lord.
about the second petitioner?
Second petitioner, she is not pursuing any education, my lordship.
ಮತ್ತೆ ಅವ್ರು ಯಾರು ನೋಡ್ಕೊಳ್ಬೇಕು ಅವ್ರಿಗೆ?
It is the responsibility lies on both the parents, my lordship. Now,
Pay 5,000. ಬರ್ಕೊಳ್ಳಿ. Heard.
and also I produced some of the document, we have additional document. Through second wife, we got a female child, and he has to maintain and also I produced the salary certificate of the first wife, which is in page number 60,
Consider.
my lords. The 10,000 till they are attaining till they are completing till they are financially independent.
Issue notice to respondent. Orders on IA. 2 of 25. In order 41 rule 25 ಹಾಕೊಂಡಿದ್ರು. RPFC ಅಲ್ಲಿ. Correct the compliance ಮಾಡಿ.
ಮಾಡ್ತೀನಿ.
There shall be stay of the execution and operation of the order dated 5/12/2024 passed by the Principal Judge Family Court at Chikmagaluru in criminal miss number 8 of 2023. Subject to the condition the petitioner deposits and pays 5,000 rupees to each of the respondents till next date of hearing. Till further orders are passed by this court. So whatever you have now argued, it was not placed before the.
Now I have placed before your lordship that wife is also
Sir,
earning.
my simple question.
Yes, I am not placed before that court that.
How that court will know? This court will have to decide that.
Yes, ma'am. But they are already attained the majority at the time of institution of the petition before the family court.
Doesn't mean
Now-
that you should not maintain your children.
Allah, they have to claim they have to file the petition under section 20 of the Indo Adoption and Maintenance Act, my lord.
See that will
Not
continue.
under the section 125. That is my contention, my lord. Not under.
April
section-
1.
Huh?
They are not your children.
That I admitted that they are
Take the
not.
amount, let them come, we'll
Allah,
dispose of
the
them.
Meager amount of 10,000 is too excessive, my lordship is dying.
What is
salary.
your job?
I'm a teacher, my lord.
What is your salary?
20,000, sir. I'm drawing salary is 20,818, my lord.
Net salary.
Yes, my lord. Net
What's the
salary,
gross?
drawing salary, my lord.
What is the gross salary?
Gross salary is 50,000, my lord.
Pay the 10,000, nothing will happen.
At least on 6 to 70,000 because wife is also earning, she is drawing salary more than 50,000, my lord.
We'll consider that. All this you have not placed before the court.
I have placed before regarding the wife avocation income,
Call
I have
next
placed
matter.
before the court, my lord.
My Lord Counsel appearing for the
Prashant.
petitioners, my lord. My lord, your lords may be pleased to allow the petitioners to withdraw the petition.
Make one second. In this case, family domestic violence, I have paid the 2,000 each. That has been admitted by the,
There is one more proceeding.
yes, my lord. Under
In
domestic
that also
violence
there is
act.
some order passed.
Yes, my lord.
How much?
2,000, that has been admitted by the,
To each of them.
each of them, my lord. That amount has to be deducted, my lord.
This amount has been?
2,000 each.
Ah.
That has been admitted in the cross examination by
All
the.
right, now this proceedings is still pending.
This is over, my lordship. This proceedings is concluded. Now he is paying 2,000 each to the children's, my lordship. In the domestic violence is filed by the children's.
Apart from this, this
Apart from
amount,
this, apart from this. order.
inclusive of that amount, or called inclusive of any amount ordered in any other court including the domestic violence, the criminal missive number 8 of 2023.
Criminal is 59/2012, my lord.
Huh?
59/2012. 11.
The domestic violence case number?
59/2011.
All right, 59/2011. Okay, inclusive that you pay only 5,000 per child, per children. You want to withdraw, Mr. Counsel?
My lord, my lords may be pleased to allow the petitioners to withdraw the present petition
Ah.
with liberty to file as per the terms of the memo, my lord. The petitioner and the respondents have amicably settled the matters, and one of the conditions of the respondent is to withdraw the present case before the settlement, my lord. In
The
case if
counsel
she,
for the petitioner has filed a memo seeking withdrawal of the petition as the matter has been settled.
my lord, yet to be settled, my lord,
All right, matter is agreed to be settled. Accordingly, this
on
petition
15th, my lord, Jan 15th.
is withdrawn. Dismissed as withdrawn. Reserving liberty.
Yes, ma'am.
This matter was last posted on 8th minutes of this month. A memo minutes was already filed. Minutes, I submitted saying that minutes memo has to be moved before the registrar. Minutes, accordingly, I moved a memo on 9th of this month for clubbing of this matter along with the MFA
All
matter.
right, when is that MFA now posted?
Minutes, MFA is admitted. That's why minutes, even they have moved the matter, even I have moved the matter.
Any
Since
date is
matter-
given?
Minutes,
Any
there is
date?
no date. It was minutes, that day minutes, there was no sitting. Hence it was urgent, that is before vacation. Minutes, now this minutes memo will be placed before the Honorable Chief Justice to take orders on administrative side. However, minutes, 9th, this file was minutes placed, was sent to the board branch. Hence, file could not be taken. I'm told minutes memo is sent to the branch for clubbing.
My lordship, if I'm allowed to make one submission, I want to file my objections to that memo of clubbing that they have filed, if I may be allowed to.
1 minute. What is the objection you have?
My objection is, my lordship, the MFA is a totally different subject. Right now, they've come before this writ petition, filing the writ petition for the execution case court's order with pertaining to the GPA, which has got nothing to do with the MFA. In the MFA, they have not taken the stand regarding the GPA. So clubbing the matter is only to procrastinate the case. They don't want to bring the original GPA before the Honorable Court. They didn't bring it before the trial court. And that's the reason why the family court has passed a thorough order specifying why it is asking the petitioner to produce the original GPAs. If I may be allowed to take, I have filed my counter to this writ petition. And in that I have clearly
The
mentioned.
prayer in this case? What's the prayer, your prayer here?
Minutes, Lordship, may hearing the matter on merits, minutes, Lordship may kindly pass it over minutes. Kindly minutes.
What is your prayer? Read the
Minutes,
prayer.
please, minutes, to set aside the order passed by the executing court on IA number 4 minutes filed under order 16 rule 2, summoning the bank manager
In which proceedings?
in execution minutes 16 of 2022.
In the, what is the main proceedings?
OS number 1 of 2022.
Well,
uh,
OS 1
12 of 12 minutes.
Was 1 of 2012.
Please, page
Sir.
number 98 is the operative portion of the order, 97.
Suit was filed for some declaration
Declaration, please.
and injunction.
Settlement, yes.
What is the
Yeah.
order in that suit?
Minutes, now it's partially allowed, minutes.
Where is
page-
that order?
Page number 97, running page number 97. May I read minutes? Suit filed by the plaintiff against the defendant under order 26 rule 8, rule 1 of CPC partly decreed. Registered settlement deed dated 12/10/2011 bearing so and so before the office of sub-registrar Mangalore executed by the defendant on the basis of the GPA dated 26/10/2007 being GPA holder of the plaintiff is declared as null and void and it is not binding upon the plaintiff in respect of the suit schedule property. The defendant is hereby restrained from alienating and creating charge over the suit schedule A property in a manner either in person or through his representative as to effect of the rights of the plaintiff over the scheduled property. Further, defendant is hereby directed to hand over the original GPA dated 26/10/2007 and 2/4/2011 in favor of the plaintiff forthwith. Against which minutes, there are two MFAs filed, one by me and one by the party in person. Now, my lords, this decree came to be executed. In that, my lords, I filed IA number 4, which came to be rejected, against which this writ petition is filed. Hence, my lords, in July itself, my lords, I filed the memo for clubbing.
Hmm.
My lords, since my lords,
All right, you filed that.
My lordship, if I may be able to make the submission, I just want to assist the court in understanding the facts of the case. There was a settlement deed fabricated.
Not hearing the main matter. You want to file objection.
Yes, my
You
lordship.
file it.
Yes, my
It will be
lordship.
taken. You give a copy to him, file it in
Please.
the registry.
Yes, yes, my lordship. I'm
Learned
serving a
counsel
copy.
for the learned, counsel for the petitioner is present. Party in person. Srimati Nisha S. Kumar is present. She intends to file objections to the application filed for clubbing of the matter. Copy is served to the counsel for petitioner. Same may be filed before the registry. List this matter next week.
please.
In the meanwhile, it is up to you if you want to move the division bench for whatever orders. If it doesn't happen, next week I will hear the matter and pass orders.
Please.
Or you can argue this matter.
My lordship, I'm serving.
No, you file it in the registry.
Registry. Much obliged, my lordship.
Noted, copy is served, you file it in the registry now itself.
Right, my,
It will come on board.
yes, my lordship.
Please.
If a date can be given for the 21st, if possible. I have a matter on 20th before the Chief Justice. I can appear on 21st before my lordship.
All right.
If the 21st. date.
21st. Come on, 21st.
Much obliged, my lordship.
Please, my lords, there was undertaking given she will not precipitate with the matter before the executing court, my lords, till date. In fact, last occasion also it was noted in the order sheet. Lordship may kindly, my lords, in case if the party in person,
Not precipitate the.
the
execution.
matter, since I have, my lords, this writ petition is
No,
for.
the order is what with regard to only that GPA is not binding.
Yes, now she has filed execution, my lords,
For
and a
what?
warrant was issued. Initially, there was undertaking
Petition for what?
of the decree passed, my lords. This 91 of 2012, my lords, that decree was passed, against which execution came to be filed. In that application was
What is
filed.
the execution? What is being executed?
The decree which was passed, my lords,
The decree is only not binding.
not binding, please.
Other
Mean-
execution in it.
ಇಲ್ಲ, GPA,
Execution is pertaining to the two GPAs to hand
two
over the two
GPAs, to
GPAs.
hand over the,
Hand over the GPA.
please,
Yes, my
please,
lordship.
which
The
is not in,
originals. Which till the 21st, it will not be.
Undertaking given by
please,
party in person continues till next date of hearing.
obliged.
One humble request, my lordship. I have a serial number 62 today. A matter with regarding to my maintenance, my lordship, On the last occasion, it had come it's on the last of the list. It had come at the time the court was rising. If today it can be taken up at 2:30 after lunch, I'll be highly obliged. When I'm coming all the way from Bombay, I think.
Now, we'll see. You mentioned at 2:30.
Yes, my
We'll
lord.
try to take it up.
Yes, my lord. Much obliged.
Please.
Just, Mr. Counsel, just to make yourself available after you finish work
Please,
at 2:30, if
Please.
possible, we will take up the matter.
please, please,
If you need time, we'll grant it.
Please.
I'll hear at least something from her,
please,
because she's coming from Bombay.
please.
Much obliged.
My lord, appear for the petitioner, my lord, in this matter. My lord, there are two office objection. One was with respect to payment of 100 rupees. That has been complied with. Only the cavator, I'm told, has not been served. He is not here, my lord.
Lokesh
I
Kumar.
could get this.
Is what is the urgency?
My lord,
Urgency.
my lord, it may be taken up on any other day, my lord.
So the first objection was court fee that is paid.
Adu kattidini.
Then at counsel, Sri Shailesh submits, for the petitioner submits that the court fee is paid and is ready to furnish copy. Kottidara kodbeka?
Alla kodbeku. I didn't have
the
his
copy to
address.
be served to respondent, caveator, who's not present today. Hence call this matter on. Or address is registered.
Alla ನನ್ನ ಹತ್ರ ಇರ್ಲಿಲ್ಲ. I'll take it from the court record.
ಕಳಿಸ್ಬಿಡಿ next.
I'll get it.
Or you want to serve, wait for next time also, you can. Yes, Mr. Srinivas. Compliance, third time.
My lords, my colleague has told he has complied the matter. I'm not sure if they raised additional objections. I'll just look into the matter, my lord.
Annexures to be attested, that is all.
I'll just look into the matter, my lords. 2 days time might be.
Anything interim you are seeking?
No, my lords.
All right.
Nothing.
Council, that's the only
They-
one. Annexures to be attested.
Much obliged.
In this matter,
Okay.
there is another appeal, my lord.
ಕೊಡಿ ನಂಬರ್ ಕೊಡಿ.
Kindly may become.
ನೀವು ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಾ? Whom are you appearing?
ನಾನು ಕ್ಲೈಮೆಂಟ್ ಅಪೀಲ್ ಫಸ್ಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಫೋನ್
Which number, madam?
18
Claimant. Family court matter ಇದು.
ಸಾರಿ
Serial number ಏನು ನಿಮ್ದು?
18 ಇತ್ತು.
No, you have a wrong. Just check the cost list.
Yes, yes.
Notice, issue notice to the respondent.
Yes,
Meanwhile, counsel to rectify the objection. All right. Who are you appearing here? In section 9 Hindu marriage. You don't know.
My lords, I'm proxy counsel in this matter. I am not aware. Don't have the file with me as of now.
Meanwhile, the petitioner is permitted to take out notice to respondent along with regular service to the respondent appearing before the family court, or an alternative to the counsel representing the respondent before the family court.
Much obliged, my lords.
Rajshekhar. Rajshekhar.
For the petitioner, my lords.
Hmm.
My lord's office objection with regard to serial number 1 is para number to be stated correctly. I will comply with office objection during the course of the day, my lord.
Counsel is permitted to do the needful during
serial-
course of the day.
Serial number 2 and 3 may be overruled, my lord.
Serial number?
2 and 3. Court fee has already paid, my lord.
All right. The serial number 2 and 3 raised as objections by the registry is overruled. Next.
My lords,
As court fee is paid, ma. As court fee is paid.
my lords, meantime interim order may be granted, my lord. I'll make a submission, my lord. My lords, in 2004.
No, you rectify the objections. What is the first para number to be stated correctly in the WP and an affidavit? Yes, what is your case?
My lords, husband has filed MC petition before, in 2014, husband has filed MC petition, my lords. It has ended with compromise petition, my lords. And both the parties agreed that the petitioner are agreed to pay 4,000 rupees for every month, my lords. After that, respondent has filed MC petition seeking for the dissolution of marriage, my lords. The matter got decreed and the court has directed to pay 10 lakhs permanent alimony, my lords. Challenging the said order, I have preferred the MFA, my lord. So stay has been granted to that MC case, my lords. And this honorable division bench has directed to pay 5 lakhs deposit, my lord. So in order to comply with office objection, the office objection and the deposit, my lord, the respondent herein have preferred execution petition for the first case, my lord. It is ended with a compromise, my lords. So it is not maintainable.
In the MFA, which you have questioned that
My lord, after that compromise ended, MC petition is ended with a compromise petition, my
in
lord.
which case?
MC number 61/2014, my lords.
The earlier MC 460 of 19 is also by the same parties?
No, my lord. After the compromise petition, the respondent herein has filed MC 460, my lord. For that, we have challenged that or the same order and the stay has granted, my lord, by this honorable court.
So initially, before
460, my lord,
Ah.
MC number 61/2014.
2014?
Yes, my lord.
So that is ended in a compromise?
Compromise, my lord. For that order, the respondent has filed execution petition.
What was the compromise in that?
Compromise, my lord. As per the terms of the compromise, the parties are agreed to join each other and continue the matrimonial relationship. Further, the petitioner are agreed to pay the sum of 4,000 for every month to the minor child.
So decree was drawn. The compromise was accepted and decree was drawn.
26/3/2014, my lords. After the respondent has filed dissolution of marriage, my lords, in MC number 4.
So restitution of conjugal rights was ordered based on the compromise.
Yes, my lords.
So based on that, the execution is filed, is it?
And now the respondent has preferred execution petition, my lord.
Based on the earlier compromise.
Yes, my lords. So before the execution petition, the respondent has already filed MC petition 460/19. For that, we have preferred MFA, and in the division bench as stay the proceedings of MC number 460 2019, my lord. So now the
Why was the second petition filed when you already entered into a compromise?
My lords?
Why was the second petition for
That
divorce filed?
Filed by the respondent, my lord.
How can he file when you have already settled the matter? And you started living together?
No, my lords.
Did not live together?
I have no instruction regarding it.
Prafulla Flavia Miranda is filed, that is the, now divorce petition is filed by the wife.
My lords?
Divorce petition is filed by the wife.
Yes, my lords.
So you are appearing for the husband.
Yes, my lord, I'm for the husband.
So in the divorce petition, also it is allowed.
Yes, my lord, it is allowed.
So that is now before the MFA court.
Yes.
What is the order passed? In the MFA court, some orders granted. Stay.
Yes, my lord, stay.
You are
Then
directed to deposit.
Deposit 5 lakhs rupees, my lords. I have deposited, my
You are
lord.
deposited.
Yes, ma'am.
All right. So now this execution, you have come up with the, against the order of the execution.
Execution.
So what is the order in the execution?
Execution petition. The objection of the judgment debtor is hereby rejected and the judgment debtor is directed to make a payment of the execution amount without filing. Order passed on 25th November 2024, my lord.
So here that the earlier matter will pale, it will become insignificant in view of the subsequent divorce petition being allowed.
Yes, ma'am.
What is the amount that is claimed in the execution petition? You have deposited that 5 lakhs?
Yes, my lords, before trial court, my lords.
Order Learned Counsel for the petitioner. Subject to compliance of the objections. There shall be stay of further proceedings in execution. Petition number 51 of 23. Pending on the file of the first additional family court Mangaluru. In MC number Bantama, in MC number 61 of 14. MC number 61 of 14. Execution petition Bantala. Arising out of MC number 61 of 14. File of first additional family court Mangaluru. Full stop. The submission of learned counsel till next date of hearing. The submission of learned counsel for the petitioner of depositing rupees 5 lakhs. As per the order in MFA number.
MFA number 3978/23.
3978 of 2023. Is noted. All right. Follow on. Notice agidala, issue notice. Issue notice first round.
Much lords.
Petitioner. I appear for the respondent. During the last date of hearing, there was a direction for the respondents to keep the children present.
Direction for respondent to
keep the children present, my lords. They had flown to Calcutta, my lords, on 7th.
The children are present, my lords.
During the last date, even the tickets were also placed on record. Not for an interim custody, my lords, to take the children to Mangalore, my lords. Father is residing in Mangalore. Children are residing in Bangalore, my lords, with mother. Since there is school vacation, Christmas vacation, my lords, I have sought for interim custody to take the children to Mangalore, my lords, during vacation.
all right. Now where is the child?
The respondent and the children are present.
Tell that girl to sit down somewhere.
My lords, if I may, my lords.
Sit down, sit down.
If I may, my lords.
What is the order you are questioning?
My lords, as of now, my lords, there is no order that has been passed, my lords. I have made application, my lords. Same was not considered.
Where is that order?
My lords, that is precisely my objections to this, my lords. They have sought a writ of mandamus against the private individual, my lords. The applications, my lords, are
Next year, my lords, page 17. This is the order sheet, my lords. I made an application before the family court, my lords, under the family court, my lords, seeking for an interim custody of the children during school vacation. My lords, I have, my lords, I was not allowed to take the children to Mangalore for about last 1.5 years. In 2020, my lords, it was the date of separation. Subsequent to which, my lords, children were going and coming to Mangalore. They were allowed to go. However, my lords, in 2023 end, my lords, to be precise, in the month of October, all this litigation started, my lords, because the mediation that was going on, which failed, due to which, my lords, all the litigation started coming up. Subsequent to which, my lords, it's been almost 1.5 years. Children were not allowed to go to Mangalore. My lords, also, my lords, with the father, there is an aged grandmother also. She has also not visited the grandchildren for almost 1.5 years, my lords. Now that it is school vacation, so I made an application before the family court My lords, same was not considered, my lords. During the last date, objection was filed. Two of my IAs were infectious in nature, my lords. Also, my lords, I had sought for another visit to Mangalore in the month of February 2000, Feb 16, 2025. Next month, my lords. However, my lords, now the next date is on February 18th. That IA is also infectious in nature, my lords.
Before the Mangalore Family Court?
No, my lords, in Bangalore, before the Bangalore Family Court.
Now the matter is pending where?
Bangalore Family Court, my lords.
Was it transferred?
Please, it was transferred. It was
From
transferred.
Mangalore.
Please, please, please.
So the matter is pending before Bangalore Family?
Before the Bangalore Family Court, my lords.
The petitioner is from which place?
My lords, petition is from Mangalore, my lords.
And respondent?
Respondent is from Bangalore, my lords. She was in her matrimonial home previously, my lords. In 2020, they separated. That is when they shifted to Bangalore, and the children are residing in Bangalore, my lords, now.
So legal separation has not happened?
Legal separation has not happened, my lords. To and fro cases are pending, my lords. I have been
living separately.
Please,
Yes,
my lords.
sir.
Since the date of separation, my lords, I have been paying 2 lakhs of interim maintenance. I have given a 4 BHK house to stay. 24 lakhs of fees per annum for both the children is being paid from my end, my lords.
Where are they studying?
My lords, in Canadian International School, my
In
lords.
Bangalore.
Please.
Mother is also staying in Bangalore.
Father, please, my lords.
Mother
Please,
is
please. Mother is staying in
Bangalore
Bangalore.
along with the children.
Please.
And father is in Mangaluru.
Father is in Mangalore, my lords.
All right. So you made some application before the family court for visitation?
Please, my lords, I made multiple.
It has not been considered.
It has not been considered. As on date, my lords, it has not been considered. Next date is on February 18th, my lords. Next month.
How old are the children?
My lords, son is 13-year-old, daughter is 11-year-old.
Where is your application?
My lords,
The family court which you made? Section 12, page 41.
Annexure B, my lords, page 25.
What is B1 then?
That is the petition, my lords.
Huh?
Next year, B at page 25 is the petition, not the
B1
application.
application, but I'm not hearing the main matter.
If
So your
Please, my lord, it's
application
B1,
was
my lords,
travel
41.
to
Sorry, my
Mangalore and
lords.
stay with the father during Christmas vacations from 23/12/24 to 4/1/25 and other school vacation. Now children are in which class?
My lords, probably 7th, 8th, my
Yes,
lords.
you know, children are in which class?
8th and 6th, my lords. 8th and
ಬರ್ಕೊಂಬರಲ್ಲ argument ಮಾಡಲ್ವಾ?
Illa, if I may come on the singular point, my lords, if my lords may please take page number
So first
18, my lords.
8-year-old is a boy?
No, they are 13 and 11 years old, my lords.
13-year-old
13-year-old is the boy.
Son
Eighth
is
and
13-year-old.
sixth standard, 8th and 6th standard.
Please, please.
Age ಹೇಳಿ?
13 and 11.
and 11 months.
Boy and girl.
Please.
Vikram, Sudhir Pai and Tanya.
Please.
13 and 11. All right. Yes.
My lords, I've been paying interim maintenance, my lords, from the date of separation. In 2020 was the date of separation. That is when, my lords, every single month I've been paying the maintenance of rupees 2 lakhs. Also, my lords, school fees of rupees 24 lakhs I've been taking care of every month. I mean, like every year, my lords. A 4 BHK residence is been given to them, my lords, to stay. They have been staying in that residence, my lords. All the other expenses, apart from this expense,
So
is
now
been
your
taken care.
grievance is the family court has not considered this application.
Please, my
Please,
lords.
that is not
my
their
lords,
prayer, my lords. Their grievance is to direct this honorable court to send the kids to Mangalore, my lords. That is not their prayer. Lords, may please take their prayer.
my lords.
They've sought for a
Technically,
writ of mandamus
IA
against
that
the.
I have, my lords, IA that I have filed before the family court is infectious now. Such being the case, my lords, I have no
They
other
have,
option but to
they
come
have
before this
sought
honorable
for
court.
the, they have
I'm a
sought for the,
biological father, my lords.
the prayer may be seen. They seek and writ of mandamus against the respondent, my lords. Now, my lords, let me have my lords on the merit of the matter as well. If my lords may please take page number 20 of their own petition, my lords. Page number 20.
Why do you go before the family court and urge all these matters?
Please, the direction of this honorable court may be that the matter may be disposed in a time-bound manner, and I am cooperating with that, my lords.
My lords, day after tomorrow is the last date, man. 16th, the schools are reopening. My IA itself is infectious, my lords.
That is why you go file fresh application. before the family court, you cannot file a writ of mandamus against a private party
Please.
here. There's no order passed. Your grievance is whatever IA you have filed has become infructuous. It is no orders are
Family court
passed.
is not been considered. I mean,
I
my
will
lord,
direct
during the
the
last date, my lords, during the last date, they had filed 7 to
Hmm.
11 applications seeking for the rejection of the plaint. That was filed after all the IAs were filed, my lords, after all the objections were filed. Just because my IAs are not supposed to be considered, that is when they are filed, my lords. Even before your lordship also, your lordship has directed them to keep the children present on the 8th, my lords. On 7th, they leave to Calcutta, knowingly that the petition is being filed. Petition was filed on 26th of December, my lords, 2024. On the very same day, after filing of the petition, my lords, tickets get booked to Calcutta. I am just bringing it to your lordship's notice.
Urge
my
all
lords.
these things before the family court. I will direct the family court to decide your application
Please,
expeditiously.
please, my lords.
All right? You want to say something?
No, we've actually cooperated, my lords. Our objections are on record, and I may just take my lords to page number 20. The petition may be the reason why I'm just bringing my lords to this notice is at page number 20, they filed a detailed memo in the guise of the same application, my lord. They filed a detailed memo seeking an interim custody of the two children. What happens to that memo, my lords? I filed my detailed objections and the memo is rejected. That order may be seen on the same page at the bottom. Memo filed by the petitioner seeking interim custody of the children is hereby rejected. It was a detailed argument, my lords. I have placed my reasons as to why the memo may not be entertained, and the family court has passed. So this petition may be disposed of. Directions to the family court saying that the matter may be disposed in a time-bound manner, and I will abide by that, my lords.
My lords, my IA will be infectious, my lord. It is only 2 days that is left, my lords.
What do you want now?
My lords.
What is it that what relief you want?
Some direction for the children, at least for a matter of a day, my lords, to
Petition,
visit
first of
Bangalore.
all, is not maintainable. You go before the family court, file whatever application you want. That court will consider. No order is passed. What is that order you're questioning? At the most, this court can direct expeditious disposal. That's all. You're not questioning any order of the court. Are you questioning? You're seeking a direction to give the children to you. I understand your
IAs have
concern.
been held infructuous, my lords, because the family court was not considering. My lords, I was helpless. That is the reason I have approached this honorable court.
So apart from this GNWC, anything else is
My
fine?
lords, DV Act is pending, my lords. 498 days was filed against me. I have challenged it via 482, my lords. Hearings are complete, my lords. It is pending for orders, my lords.
What is the respondent doing?
My lords, the respondent was previously working. Now that she is a housewife.
She's a
not been
housewife.
working.
She's a housewife, my lords.
You're paying maintenance
Of which is 2 lakhs every month.
to all three of them.
Please. School fees has been paid separately, my lords.
My lords, they're also on the ground that we've not let the petitioner meet the children. Now, my lords, the birthday of the son was on the 11th of this month. The father himself has met the child in the lobby of the building where they're residing. We've not denied the father from meeting the children at all, my lords. They've come on the wrong grounds. Let them urge all that in the family court, my lords. We will expeditiously answer that point of view.
Permitting the father to see the child.
Yeah, please, my lords.
May I make one submission? With my lord's kind leave, I am representing the petitioner in this matter.
Is along with you?
Please, my lords, please. Senior, my
I'm
lords.
sorry, my lord, there are some difficulty in logging in. Sorry.
Yes.
My lordship, can you recollect what has happened in this matter? On last occasion, my lord, we have pointed out how the family court has been lodging into the matter. If your lordship could kindly see the order sheet. My lord, IA number 1 to 9. My lord could kindly look into, my lord.
So your IA 6, 7, 8, 9 are to be considered.
Consider. And if at all my lords could kindly look into, when we have filed an application for the with a direction to take the child to the native place, my lord, for a specific period, and my lord, after that period, my very application will become infructuous as those were become infructuous on earlier occasions. And now also, my lord, on 6th, there was the matter. So far as IA number 7 is concerned, my lord, that is for one day for a function we wanted to take on 16th of February. The court, the family court, my lord, posted the matter on 18th. 18-2, wherein, my lord, after the ceremony, there is no point in, my lord, the court giving such a date. And this has been happening since the date of filing of the application. So far as all the IAs, my lord, every IAs are becoming infected without there being any fruitful order being passed.
That's correct. Now, learned counsel for the petitioner and the learned counsel for the respondent. The minor children, Ibru idara maklu?
Please.
Minor children.
I request for 190 here, my lord.
Namely, Master Vikram Sudhir Pai and Miss Tanya Pai are present before the court as per the direction of the court. Full stop. Petitioner's grievance is that he had filed interim applications IA number 6, 7, 8 and 9 before the learned family judge at Bangalore. In GNWC 99 of 24, the same was not considered, and therefore he was unable to have visitation rights or custody rights which he sought for. Hence, he has filed the present petition seeking a writ of mandamus. Full stop. I'm afraid the petition may not be maintainable as no order is passed. And in fact, it is the grievance that in view of non-passing of the order by the learned family judge, petitioner is deprived, petitioner or father is deprived of seeing the and visiting the minor children. Full stop. It would be appropriate for this court to direct the family court to decide application IA number 6, 7, 8 and 9 in accordance with law expeditiously and pass suitable orders. It full stop. It is the duty and obligation of the family court to decide applications filed for interim custody bar visitation as expeditiously as possible so that the applications filed do not render the same infructuous without any visitation rights being provided to the father timely. Full stop. Under the circumstances, this petition is disposed of with a direction to the learned family judge to dispose of the application IA number 6, 7, 8, 9. When is the next date of hearing?
My lords, 18th of February, my lords.
6, 7, 8, 9. So now the school is already started?
No, my lord, it is on
Reopening is on 16th.
16th is the date. So what would be my humble submission to the lordship is another 2 days, my lord, at least if I can take them to Bangalore, because the grandmother of the children, my lord, 3 days they have not, she has not.
Party shall appear before the family court on the 24th of January. Appear on 24th of January
Please,
for the family court.
please, please.
You argue the matter. You have filed
Please.
objections
I file my objections, Mala.
on 24th of January and shall address arguments on which day the learned family judge shall pass suitable orders with regard to visitation on merits upon hearing the parties as well as the minor children, as well as interaction with the minor children. All right? Ordered accordingly.
Grateful minutes.
Of the family court, my lords, at Bangalore. The petitioner and respondent are married for 13 odd years. In fact, they'll be completing 14 years. They've all along lived in Pune. The child was born there, admitted to the school there. However, the respondent just recently removes the child all of a sudden without there being any issue, comes to Bangalore, which he gets to know only later. By then, he has paid the admission fee, tuition fee, everything for the child. Now she seeks an admission in Bangalore and admits provisional admission is sought in Bangalore school and the child is going. Now I file, after I receive the notice in GNWC, I come to Bangalore, file an application. The husband files an application saying this petition is not maintainable because the ordinary resident of the child being Pune, it is only the court at Pune that has the jurisdiction to decide the custody petition. Your lordship is also well aware of the said fact. However, that petition comes to be dismissed. And the court is now proceeding on a day-to-day as if 2-3 days time, because she has filed an application for a direction to the school in Pune for transfer of certificate, transfer certificate. And that, in fact, it is there today, my lords. Being aggrieved by the order, rejecting my application for rejection of the petition and to be sent back to the court at Pune, I file an order 7 rule 11. First, may I place before your lordships 2 judgments of this court, my lords? Of course, in Ruchi Maju, the Supreme Court has held regarding the jurisdiction. Based on the same thing, if I may just...
This is a compliance, madam.
My lords? My lords, that is just index is not signed and one minor objection which will be complied during the course of the day.
Okay, now what is the order you're questioning?
My lords, order is
Of rejection of your
that the child
application?
is admitted here. Yes, the child is admitted in Bangalore, so this court has jurisdiction.
They'll have to be considered.
My lords,
That will have to be considered. What is the interim order now you're seeking?
that I sought for a rejection of the petition in GNWC, filing order 7 rule 11. However, the court says, no, this court has jurisdiction and rejects my application. That is the order that is challenged before this court, my lords, at Annexed J. The court says the child is admitted in Bangalore, so this court has jurisdiction.
All right, we'll hear the other side. But no
Let's-
notice has to go.
All right, because only because the court is proceeding. I'm seeking for a stay. my lord. If I may come to the operative portion, my lords, the only thing that has said that the court
What is the
says
stage of the matter before the family court? What is the stage?
stage is, the wife has filed an application seeking the direction to the school in Pune for the transfer certificate to be given to the school in Bangalore. Because the Bangalore school admission is only provisional in nature. The father has not given consent. The child is already admitted in Pune. And she has been doing extremely well. The parties were extremely happy. In fact, he's ready to take them back also. What is the reason for her to just leave Pune and come to Bangalore is still not known to him. And in fact, after coming to Bangalore, the child is simply kept away from the father. I filed an application even for visitation rights that is also not entertained.
But heard learned counsel for the petition objections to be complied during course
I'll
of
make
the
sure
day.
it's complied during the course.
There shall be stay of operation, further proceedings. What is Annexure J?
Annexed J, my lords, is
Rejection. Annexure J is rejection or of.
rejection of the application. Where I have sought for rejection of the petition itself.
Shall be stay of operation and of the impugned order dated 30th October 24 by Annexure J. And for the proceedings in GNWC 230 of 2024. Till next date of hearing. Call this matter up for 2 weeks.
Great.
Learned counsel for the petitioner is also permitted to take out notice
Do that.
to respondent before the family court or in the alternative to the learned counsel representing the respondent.
For the appellant, your lordship.
Hmm.
There's 107 days in filing the appeal.
R1.
Yes, Lord.
My lords, I'm so sorry to May I request for the order to be uploaded so that I could file it with the memo in the afternoon because it is there today and the court is asking me to file objections. Then
It will be uploaded. You can file a memo.
I'll file a memo, but
You can file a
sometimes-
memo that court has passed such an order.
But in this case, I have still not yet filed my wakalat minutes. I have sent across the appeal memo. But
Ye
I
allow, madam.
I
Ye
appeal,
one
your
of
lordship kindly allow
without
that.
delay of 107
107
days is condoned. Copies bandidya,
Copies quoted.
I've served the copy, Your Lordship.
call on. For 2 weeks,
4 weeks.
4 weeks.
Oblige, Your Lordship.
Shashidhara,
I'm appearing for the appellant, my lord.
hmm.
My lord, 386 days delay condone, my lord. Maybe condone the delay, my lord.
Claimant owner.
Claimant side, my lord.
Copy served, my lord.
Payment.
Already copy served, my lord.
Already
Other
copy
side
served,
copy
my lord.
served.
Janardhan, you have to file wakalat, my lord.
Heard
Please
learned
send to-
counsel for the appellant. Orders on IA1. Delay of 386 days in filing the appeal is condoned.
Not
Being
entitled interest for
satisfied with
delay.
the reasons assigned and cost shown in the affidavit annexed to the application. IA1 is consequently allowed. 1 of 24 is allowed. However, on appellant being successful in the appeal shall not be entitled to interest for the delayed
Please,
period.
my lord. No job.
For appellant.
Hmm.
My lord, and for the appellant, RC one was appeal, my lord. The vehicle is having valid insurance, but the tribunal passed the liability against the RC owner, my lord.
Your owner, is it?
Yes.
Heard learned counsel for the appellant. Issue notice to respondents.
1 and 3.
1 to 3, huh?
Two is a driver, not required,
2 is not required.
not required, 1 and 3.
1 and 3. Notice to R2 is dispensed. Memo is accepted.
Yes.
As no liability is fastened on R2. Issue notice. Ethalama, issue notice. On IA and main. Orders on IA number 1 of 24, pending consideration of IA number 2 for delay. There shall be stay of operation and execution of the judgment and award dated 27/12/22. Asked by the 4th Additional District Judge MACT Mysore in MVC 847 of 20. Subject to the condition the appellant deposits 50% of the award amount. The liability is fastened on you.
Yes, my lord.
What about R1?
R1 is the
Rejected.
claimant.
Claim petition against R3 is rejected. Claimant is rejected.
No.
Insurance company is rejected.
Yes, R3.
50% of the award amount within 4 weeks from today.
But
The respondent number 2, my lord.
I am for appellant, my lord.
Time, my lord.
Insurance
Pay for the respondent. Objection ಇದೆ 2 weeks time, my lord.
ಇದರಲ್ಲಿ ನೀವೇ ಅಪಿಯರ್ ಆಗ್ತಿದ್ರ
There is another appeal.
Both are
IA
here,
number,
huh?
IA number 1 ಅಲ್ಲಿ ಇದೆ.
ಎರಡು ಇದೆಯಲ್ಲ
467 days delay ಇದೆ. ಅದು ಒಂದು
correct 467. Both the appeals are filed by
Insurance company, my lord.
insurance company. Have you also filed? What is that appeal number?
2209 of 2023.
2209 of
2023.
23.
Please, my lord. As Insurance company challenging liability, my lord. As of data of accident.
Madam, you are appearing for whom?
respondent number 2, my lord.
Two now.
Owner, owner.
Huh?
Owner of the vehicle.
Vehicle.
Owner of the vehicle.
Vehicle.
R1, you are appearing for R1. So you take notice in the other matter also.
Can matter, my lord.
Learned Counsel Sri B. Pramod is directed to take notice for respondent number 1
Please, my lord.
in MFA 4660 of 24.
24.
Condone the delay.
Please, my
Yes,
lord.
ma'am.
In the second matter also same 467 days.
Please, my lord.
Orders on IA 1 of 24. In 4642 and then next order rather. Both will same order will be there. IA number 1 of 24 is filed to condone the delay of 467 days by the insurance company. Perus, the affidavit annexed being satisfied with the reasons assigned and cause shown, delay of 467 days is condoned. Orders on IA number 2, there shall be stay of operation and execution of the impugned judgment and award dated 31st December 22, passed by the senior civil judge additional MACT at Chitradurga in MVC 413 of 2020. Other ಇನ್ನೊಂದ್ರಲ್ಲಿ change ಆಗುತ್ತಾ MVC number? Same.
Different MIC, ma'am. 413 and 412 of 2020.
In the first matter, it is 413.
Please, my lord.
413 in the first matter. Secondly,
412.
412 of 2020.
Chitradurga MIC.
2020. Subject to the condition, the appellant insurance company deposits 50% of the award amount before the jurisdictional tribunal within 4 weeks from today. Full stop. Para. All this matter along with MFA number 2209 of 23.
Please, my lord. Before this court, we will deposit.
Deposit before this court matter.
Please, my lord. My job.
ಹೌದಾ? Whether in the second matter, Pramod was the part, you had appeared in the second matter before the tribunal also?
We have made party, my lord. Owner of the vehicle and claimants, my lord. Different claimants.
Different claimant.
Please, my lord.
She is appearing for the claimant.
She is appearing for one matter in claimant, my lord. Second matter, whether he is appearing.
ಅದು ನೀವ್ ಹೇಳ್ಬೇಕಾ? Are you appearing in the second matter?
No.
For claimant?
Not for claimant. Yes. Sorry, my lord. Yes. Getting confused. Sorry.
ಅದು ಕೊಡಿ, ಕಾಪಿ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ 4660 ಇದೆಯಾ ಅಪೀಲ್ ಮೆಮೋ?
ಇಲ್ಲ.
I will serve, my lord.
Yes, now show it whether if she is not the party, how I can direct her to appear. ಆ 2290 ನೀವು ಫೈಲ್ ಮಾಡಿದ್ರಲ್ಲ, ಅದು ಅಪೀಲ್ ಮೆಮೋ ಇದೆಯಾ?
ಇದೆ.
ಅದು who's your claimant party's name?
ಈ ಚಂದನ್.
Huh?
ಈ ಚಂದನ್.
So he's only in the first case, not in the second case.
Not the second.
I will
Second-
take it, my lord.
In second case ಬೇಕಾಗಿಲ್ಲಮ್ಮ. Pramod to directed to take notice ಇದೆಯಲ್ಲ ಬೇಕಾಗಿಲ್ಲ. Issue notice to R1. Issue notice to R1, ಅದು delay application, no orders on that.
ಶಶಿಕುಮಾರ್.
ಇಲ್ಲ, delay application allow ಅಂತ ಇದ್ವಲ್ಲ ಅದನ್ನ ಮಾಡಬೇಡಿ. Stay is granted subject to deposit.
I am for appellant, my lord. On behalf of the Krishna Kumar, I am representing Krishna Kishore, my lord. Insurance company challenging negligence, my lord. It by the back portion of the lorry. Charge sheet filed against to the car, my lord. Liability fixed against to the insurance company.
ನಾಗರಾಜ್,
Please.
ನೀವು claimant ರೇನು?
ಹೌದು, ವಿಜಯ್ ಕುಮಾರ್ ಅವರು. Serial number 27.
26 point.
Sorry, my lord. 27 represent.
ಅದರಲ್ಲೂ ವಿಜಯ್ ಕುಮಾರ್ ಇದೆ. You are appearing on behalf of Vijay Kumar?
My lord, I am for the appellant, my lord.
Yes, Mr. Vijay Kumar.
Yes, I filed application, Lord, seeking to release of the amount deposited by the claimant. Case of death, my lord. And I have also filed, my lord's appeal for enhancement as well as questioning contributed negligence of 10% on the deceased. my lord.
That is 26.1.
Yes, ma'am.
He has taken notice. We'll direct him to take notice.
Yes, ma'am. There is delay of 102
Can be
days.
allowed. ಬರ್ಕೊಳ್ಳಿ. IA number 3. IA number 1 of 24. Filed by the Learned counsel for KSRTC, na though? Corporation.
BMTC.
Corporation. Application is allowed, delay of 33 days in filing the appeal is condoned. You have deposited the amount?
Yes, my lord.
How much amount you have deposited?
My lord, about 11 lakh. 11 lakh and that. 1 minute. I'll mention.
Now, what is it you are challenging? Your
11 lakh
liability or
26
quantum?
11,26,697.
Already, you have any objection in withdrawal?
My lord, subject to result of the appeal because we have denied the very involvement of the vehicle and also total negligence on the part of the driver of the BMTC bus. 50% may be permitted to withdraw, subject to result of the appeal.
No, orders on
Even the
IAN.
claimants also not the my lord, dependents of the deceased. They are all the major married younger brothers. They are not depending upon income of the deceased.
Orders on IA number 3. This application is filed by the claimant seeking withdrawal of the amount deposited by the appellant corporation. Full stop. Having heard learned counsel for the respondent and the appellant, the application deserves to be allowed. Accordingly, IA number 3 is partly allowed. The respondent claimant is permitted to withdraw 50% of the amount deposited by the appellant. However, the same would be subject to outcome of this appeal. In case the appellant succeeds, the respondent would be liable to refund the amount along with prevalent bank rate interest.
Yes, yes.
In the first matter, it's 26. In 26.1,
My case, not there is 102 days delay. In
learned counsel Shri D. Vijay Kumar, you will take notice, sir.
Yes, my lord.
He is directed to take notice for respondent corporation. IA 1 of 24 is allowed. Delay of 102 days in filing the appeal is condoned.
Records be called.
It's a registry to secure records.
Please.
Insurance company challenging negligence,
Heard learned counsel issue notice to the respondent. Respondent on main and IA. Pending consideration of IA number 2, IA number 3 is taken up by imposing certain conditions. There shall be stay of operation and execution of the judgment and award dated 27/4/24 in MVC 4478 of 19. Passed by the Chief Judge Court of Small Causes, MACT at Bengaluru, SCCH1. Subject to the condition, the appellant insurance company deposits 50% of the award amount within 4 weeks before the tribunal.
For tribunal,
For the jurisdictional tribunal.
I'm sorry, in my case, records after withdrawal of the amount.
Earlier case, records to be summoned after withdrawal of the amount.
Please, grateful.
R1 notice may be dispensed, my lord. I will take notice to R2.
Notice to R1 is dispensed. Memo of, filed by the appellant is accepted. Issue notice to R2. Column.
For petition, my lord. Filing this petition, my lord. Okay. An arrest warrant has been issued against the husband, my lord. The previous order, my lord, your lordship may kindly see, without taking into consideration the direction issued by this honorable court, the learned judge of the trial court, my lord, has passed the very same order, your lordship. In the previous matter, my lord, the 20,000 was awarded, your lordship. This honorable court has said, my lord, she deliberately left the job. She is an engineer, BE, MBA, with a view to harass the petitioner before this honorable court. Then it was challenged before this honorable court. This honorable court has said that, my lord, squashed the order. My lord will get it, my lord, page 112, my lord, may kindly see me. 112, my lord.
112, my lord. Para 7 of the order. The learned counsel appearing for the petitioner husband. My lord got it, my lord. Wife has not come to the court with clean hands, and she has not produced the relevant materials before the court, and also having observed that she is a double graduate, has granted the maintenance of an amount of rupees 20,000. It is submitted that the court below has found that as per the orders of the Honorable Affects Court, the relevant statements are not filed before the court. The court also observed that the adverse inference has to be drawn. In the light of those observations, the court below ought not to have granted the maintenance. The learned counsel for the counsel appearing for the, she was asked to produce the relevant document to show that period of working and the amount drawn by her, my lord, why she was left for the job, everything, my lord. She did not produce the same, your lordship. That is why the finding has been recorded. The learned counsel for the counsel appearing for the respondent wife submits that the husband has not filed his bank statement. I have filed, my lord, on long back, your lordship. And in fact, she has not placed all the relevant information before the court. It is stated that the wife has quit her job and she has no source of income. She, learned counsel submits that she has placed all the relevant records before the court. Below, there is no suppression on behalf of the so-and-so of the respondent wife. It is submitted that as per the order dated 5/1/2024 passed by this court, the petitioner husband has deposited an amount of rupees 3 lakhs and he was permitted to withdraw the same. And it is submitted that no grounds are made out seeking interference with the interim arrangement made by the court below by granting the maintenance of an amount of rupees 20,000 per month. This is relevant. Having heard the learned counsel on either side, perused the entire material on record, there is no dispute about the educational qualification of both the petitioners and the respondent, that is the husband and wife. Both of them are well educated. According to the wife, she resigned her job and she is not able to maintain herself. This court has perused the affidavit filed by the wife, wherein, except stating that the husband is drawing an amount of rupees 1,50,000, even if it is not so, per month, and she is unemployed, there is no whisper about what was her earlier job or what she was doing, how much she was earning, and when did she quit the job, lost the job. Nothing has been stated. And when it comes to the statement of assets and liabilities, the court observed that the wife, except giving the particulars of her bank account, she has not furnished the bank statement before the court. This is the finding, my lord. It is the contention of the learned counsel appearing for the respondent wife that the husband has also not produced the bank statement before the court. This court has perused the affidavit filed by the wife before the court below, the objections that are filed, and also the order passed by this court below. It appears that the court below, without there being any requisite material, my lord may kindly note, even now it has happened, your lordship, has passed an order granting an interim maintenance of an amount of rupees 20,000 per month, balancing the interest of both the parties. This court deems appropriate to dispose of writ petition in the following manner. The order dated so-and-so as passed on IA number 4 in MC number 2464 of 2020 passed by the second additional principal so-and-so is set aside and matter is remanded to the court below. Both the parties shall file their respective statement and along with all the relevant documents, the court below shall consider the same and pass appropriate order within period of 8 weeks. If the parties shall file their respective objections, pleading and evidence within 10 days. As per the earlier order passed by this court, the petitioner has already deposited an amount of rupees 3 lakhs as interim arrangement. The respondent wife is permitted to withdraw an amount of rupees 1,50,000 and the husband is at liberty to withdraw the remaining amount. Because observing the conduct of the wife, my lord, this order has been passed, your lordship, because she quit the job when the case was filed, your lordship. That's the entire text, my lord, I did not read, your lordship. Otherwise, the court has observed that also, my lord. In the above management, the above arrangement class so-and-so, this is the order passed, your lordship. Whether the direction issued by this honorable court and the finding recorded in para 910, my lord, has been followed, my lord, while passing the present order is the question, your lordship. Now, even now, my lord, the trial court, my lord, has passed the replica of the previous order. My lord will get it, my lord. At annexure A, my lord.
Annexure A, there is no consideration of the direction issued by this honorable court. My lord, kindly see, my lord. All that it is said, my lord. Page 13, page 13 of the order, my lord. Page 13 of the order. Printed order, printed 13. Para 25, my lord. Para 25. The IT returns produced by the petitioners with memo dated 16/4/2024 in page number so and so. Pay slips in page number so and so 90 to 95 reflects that the petitioner has drawn salary of rupees so and so March 2024. The entire documents placed before the court, before parties to the court by both parties to the proceedings, and the facts admitted by the parties clearly shows that at present the respondent is not working and she quit the job on 7/11/2021. This reason has to be assigned why she quit the job and what was the salary drawn. All these things to be furnished before the court. That's what the direction issued by this honorable court. Even then also they did not produce, my lord. She claims that she is receiving money from her relatives, brother, for her maintenance and needs. Merely for the reason, this is the finding, my lord. Merely the reason that the respondent is leading comfortable life and she is capable of fetching job. The petitioner cannot evade his responsibility to maintain his wife when she is unemployed. Till she fetch the job, petitioner being husband bound to maintain her, considering the standard of living of the so and so, so and so. This is the finding recorded, my lord. The direction issued is, my lord, she has to produce the, she has to tell the reasons before the court below, why she quit the job, what was the salary drawn by her, and she has to produce her accounts, details, as required by the Apex Court. That has not been followed at all. There is no whisper regarding the production of all those things, my lord, as per the direction of this honorable court. However, and again 20,000 rupees came to be ordered, your lordship. Considering the earnings of the petitioner, they have taken the consideration of my earnings only. My earnings, my lord, it will come to 45,000 only, my lord, I retain. I have stated so, my lord. And some certain amounts, my lord, I have to maintain my aged parents, my lord, and to myself. And only 45, my lord, will be the take-home salary. With this, I have to maintain all this, my lord. As per the direction of this honorable court, my lord, whether she has produced any material before the court, whether she complied with the direction issued by this honorable court is not there, forthcoming in the order itself, your lordship. And her brother is in Poland, my lord. She used to stay in Poland only, not in Bangalore.
What is the direction issued by the court earlier?
Direction, my lord, is now, my lord, by the High Court, my lord. Yes. The observation, my lord, read it, your lordship. What was the material is the question. Para 10, my lord, is. It is the code below, it appears, para 10, fourth line, fifth line, your lordship. It appears that the code below, without there being any requisite material, has passed an order granting interim maintenance. What was the material placed after the direction issued by this honorable court, my lord? She quit the job. Why she quit the job? She has to tell, and she has to file an affidavit before the court saying that what was the salary which was drawn, how many years she worked, and she has to produce the statement of accounts, my lord, assets and liabilities as required under the by the FX court, my lord.
It's not produced.
It is not produced, my lord. There is no whisper in the court, my lord, order, my lord. That's what my specific contention. There is no. It is only a replica of the previous order. There is no.
Admittedly, even according to you, she is not working.
My lord.
Admittedly, even according to you,
I am not responsible, my lord. I can understand if she has removed, my lord, for various reasons, my lord, I can understand. Only for the purpose of dragging, harassing the husband, my lord, if she quit the job, which is in her hand, my lord. Whether this kind of persons, my lord, can be promoted, my lord, or encouraged is the question, my lord.
suppose that we will see.
No, I am only bringing it to a lordship's notice the conduct, my lord. That is the conduct observed by this honorable court in the previous occasion.
It was observed.
My lord.
What is observed in the previous occasion?
No, observed one means, my lord, she has not produced any material before the court to show para 9, my lord, I have read, my lord.
No, para 10, it appears the court below without there being any
Yes.
requisite material.
What was the requisite, even now also requisite, what was the requisite material? Is the
What is your salary, sir?
My lord, 90,000, my lord, I am drawing, my lord.
90,000.
There is no doubt about it, my lord. Out of 90,000, my lord, my take-home salary would be 45,000, my lord, after deducting salary, etc., etc., my lord. I am a aged parent, your lordship. I am living in a rented house, your lordship. I have to pay the rent. I have to.
Where your wife is staying?
My wife, my lord, is now, she used to travel, my lord, to Poland. Poland, her brother is there, your lordship. She is leading a happy life there, your lordship. Once in a while, she comes here, your lordship.
She is not staying in India.
She is not staying in India. She used to go and come, my lord. She stays the 3 months there, my lord, 3 months here.
That only she has to say, I cannot go on the basis of your statement.
No, that's correct, your lordship. And more so,
Visiting the brother is barred.
well, no, my lord, I am not saying, my lord. I am only saying, my lord, she is leading a happy life. If she has no job, if she has no money, how can she fly, my lord, from India to Poland? Is the question.
Maybe the brother is giving the air ticket.
That's what, my lord. That's what, my lord. They are
duty of-
looking after. ಅವ್ರಿಗೆ annexure page one ತಾವು ನೋಡಿ ತಾವು ದಯವಿಟ್ಟು page my lord may kindly see, my lord, annexure J, my aged parents are retired, your lordship, and 117, my lord may kindly see. They are got a very good commercial buildings, your lordship. Their father.
Have you produced all these documents?
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ, ಅಲ್ಲೂ ಮಾಡಿದ್ದೀನಿ, ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲೂ ಮಾಡಿದ್ದೀನಿ, ಇಲ್ಲೂ ಮಾಡಿದ್ದೀನಿ.
Where is the consideration of that?
ಇದಕ್ಕೂ ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ನಾನು, that's what I say, my lord. My case is that, my lord, nothing has been considered.
Right.
Only ಗಂಡ ಮೇಂಟೈನ್ ಮಾಡಬೇಕು, ಮೇಂಟೈನ್ ಮಾಡಿ ಅಷ್ಟೇನೆ.
Right.
That's the finding, my lord, recorded, my lord.
Notice ಹೋಗಿದೆಯೇನೋ?
My lord.
Notice is already gone.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ಇನ್ ದಿ ಮೀನ್ ಟೈಮ್ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆಲಿ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. ನಾನು ಅರೆಸ್ಟ್ ವಾರೆಂಟು ಆಗಿದೆ, ಅದು ನಮ್ಗೆ ಕಾಪಿ ಸಿಕ್ಲಿಲ್ಲ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ನಮ್ಮ ಇದು ಮಾಡುವಷ್ಟರಲ್ಲಿ. ಕೈಂಡ್ಲಿ ಸಿ, my lord, annexure K, my lord.
Order is passed in December 24.
December 24, your lordship.
You have deposited any amount?
My lord, I did not deposit any amount, your lordship.
So that 1.5
ಫಸ್ಟ್ 1.5 lakhs rupees ಅವ್ರನ್ನು ಕೊಡ್ತಿರ್ಲಿಲ್ಲ ಅವಾಗ. Since they requested, my lord, it was given, your lordship.
No, that 1.5 lakh which she has withdrawn?
She has withdrawn, your lordship.
Have you taken back 1.5 lakh?
1.5 lakhs rupees we have taken back.
You paid
As directed by the court, my
How
lord.
you pay 10,000 per month? Let us issue notice, let her come, and let her argue, then we will decide.
Can I request, my lord, 7,500, my lord may say, my lord.
Good, heard.
Subject to what my lord finally decides. my
We'll
lord.
see. Direct her also to file the assets and liabilities.
Yes, your lord.
Heard learned counsel for the petitioner. Orders on IA number 1, await notice of respondent. The proceedings are still pending before the family court?
Yes, family court is still pending, your lord.
Is appearing?
My lord.
Is appearing?
Advocate is appearing, she is not appearing, your lord.
Counsel for petitioner is also permitted to take out notice to respondent before the family court. And also in the alternative, to take out notice to the counsel appearing for the respondent in the family court.
Yes, your lord.
ಇಬ್ಬರಿಗೂ ತಗೊಳ್ಳಿ, apart from the await.
ಕೊಡ್ತೀನಿ, ಪ್ರೋಸೆಸ್ ಕೊಟ್ಟು ಅದು ಪ್ರೋಸೆಸ್ ಆಲ್ರೆಡಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ, ಒಂದು ಕಾಪಿ
Meanwhile,
ಸರ್ವಿಸ್ ಮಾಡಿ.
There shall be stay of operation and execution of the impugned order dated 17/12/24. 17/12/24 is issuance of warrant.
Issuance of warrant, your lord. Arrest warrant.
What is the order that the maintenance order ಇದೆ?
Maintenance order at annexure A, my lord.
So that is 30th May,
30th May 2024, your lord.
the second order.
Second order, your lord.
Operation of this order dated 30th May 2024. And the stay of impugned order dated 17/12/24, issuing arrest warrant to the petitioner in execution petition number 196 of 2024. Subject to the condition, the petitioner pays bar deposits rupees 10,000 per month to the respondent. Stop. What is the arrears now?
My lord, arrears ಯಾವುದು ಇಲ್ವೇ ಇಲ್ಲ arrears. ಅಂದ್ರೆ ನಾವು ಏನ್ ಕಟ್ಟಿತ್ತೋ ಅಷ್ಟು ಫ್ರಮ್ ದಿ ಡೇಟ್ ಆಫ್ ದಿ ಆರ್ಡರ್, my lord may say, my lord.
And
ಈ
also,
ಆರ್ಡರ್ ಅಂತ
pay the arrears of maintenance at the rate of rupees 10,000 per month
From the date of this order, my lord, may say.
from the date of, from the, when is that order passed from when?
30th May 2024, your lordship.
From the date of the order on IA number 4, Aladu?
IA number
IA number
4.
4,
4.
within a period of 4 weeks from today,
Yes. Can I seek for 6 weeks, my lord?
6 weeks from today.
Yes. Grateful, your lordship. Can I seek for hand delivery of the order, your lordship? Arrest warrant ella idu ಮಾಡ್ತಾರೆ. Police harassment ಇನ್ನೇನು ಇಲ್ಲ. ಪೊಲೀಸ್ನವರು.
This will be uploaded today.
Please, grateful. ಅಷ್ಟಾದ್ರೂ ಸಾಕು.
ಯಾವಾಗಿದೆ next?
Next, my lord, 17 ಇಲ್ಲ ಇದೆ. Execution petition.
You can communicate that order.
Yes, your lord. Yes, your lord.
You can communicate that order and this order stay, and you can, order will be uploaded today itself.
Yes, sir. Grateful, your lordship.
Yes, Krishna Kishore.
Case, my lord. In connected matter, I've served copy, my lord. Kindly, TCM may be called for, my lord.
Have
It's
they
a ca-
deposited?
That, we're not aware, my lord.
Your cross objector.
Yes, my lord, in the connected matter, I appear for the cross objector.
About how many respondents are there in that? Only insurance company or others are also there. Issue notice in MFA Crop 130 of 22. Learned Counsel Shri Krishna Kishore is directed to take notice for which respondent?
Respondent number 1, my lord.
R1, registry to show stream in the cost list. All this matter on.
Kindly TCM may be called for, my lord. It's a case of liabilities in question.
Secure records.
Much obliged.
My lord, I appear for the first respondent.
For the appellant, your lordship.
My lord, only short
Case of
point
death, your
consideration, my lord, is 9,000 is taken instead of 14,000, my lord. Date of accident is 2019.
Pay and recovery, your
And
lordship.
pay and recovery order was passed. The same has to be maintained, my lord.
That's all. Huh?
Please, your
Wrong.
lordship. I'm on the only ground wherein the income was taken on the lower side.
Claimant's appeal.
Please, your lordship.
New Year again.
Insurance company, first respondent.
Income was taken as 9,000, your lordship.
Liabilities on you only.
Yes. Pay and recovery, my lord. Pay and recovery.
Only pay and recovery.
Please, your
Yes,
lordship.
And what is the ground you have taken? For pay and recovery, what is the ground?
there is no DL, my lord. There is no FC and permit. For that reason, my lord, the court has held that you pay and recovery.
3385. Which is the MFA number here?
MFA number, your
The
lordship.
MVC number.
MVC number 7695 of 2019.
695.
A case of death, my lord.
Seven, 695. You're not concerned with the second case.
No, your lordship.
Regarding liability, my lord, para 35.
So age of that person is 26 years.
Please, your lordship. At the time of accident.
Multiplier 17 is correct.
Everything is correct, my lord,
Everything is
except
correct.
the
Amount of
notional
income
income, my
has to
lord.
be taken at 14,000.
Yes, my lord, instead of
Okay.
9,000, 14 has to be taken.
Like 2,000. When
19.
19, my lord.
19, your lordship.
1/3 deduction is correct.
Please, Your Lordship.
Future prospects are awarded.
Everything is in order, my lord, except
ಬರ್ಕೊಳ್ಳಿ. Will be 14,000 plus 40%, 19,600. So 13,067 into 12 into 17. 2,65,668, correct? Correct, madam? No, sorry, 26,65,000.
deceased was a bachelor, my lord.
Huh?
Deceased was a bachelor.
So deduction is 50%.
ಹೌದು.
Please, Your Lordship.
1/3 ಮತ್ತೆ personal deduction 1/3 ಅಂತ ಯಾವ್ದು ಬಂದಿದ್ದೇನೆ?
ಅದು dependents.
Dependents,
to
Your Lordship.
parents are the dependents.
Mother and father.
You're not questioning that.
We are not filing.
You're not an appeal.
I am not in an appeal.
Then how can that be reduced? What is taken by the tribunal is 1/3. 2 to 3%. Personal deduction is 1/3. So 26,65,668. 15 plus 15. 40,000 into 2 ಮಾಡಿದಾರಾ? Yes, madam, 40,000 into 2 is given to you.
No, Your Lordship. Consortium is not given, Your Lordship.
ಕೊಟ್ಟಿದಾರಲ್ಲಮ್ಮ, ಏನ್ ನೋಡಲ್ವಾ ನೀವು?
ಕೊಟ್ಟಿದ್ದಾರೆ.
Page
Paragraph
15, you
20.
don't read your papers before coming to court.
Sorry, Your Lordship. No, I missed it out. I've read the papers. Sorry, Your Lordship.
Appeal is allowed in part. The age of the deceased is 26 years, correctly taken. Same as retained, multiplier taken is 17 is correct, does not call for interference. 40% future prospects to be awarded, correctly is taken. The deductions is ordered at 1/3. There is no challenge to the same by the insurance company, same is retained. Therefore, loss of dependency would be 26,65,668. 15,000 towards consortium, towards funeral expense and loss of estate. Consortium at 40,000 into 2 dependents, 80,000. 10% escalation would be 8,000. Medical expenses would be 1,40,215. $29,23,883.
My lord. In para 18, my lord, however, in this case, the deceased was not shown to be married and hence half deduction has to be done towards personal expenses. It's paragraph 18, my lord.
Both of you, you are supposed
No,
to.
no, that's
assess.
what I submitted, my lord, 50% and
So
bachelor.
when I asked you, then why you get,
Your Lordship, and
should be assertive in your submission.
multiplier also, Your Lordship, is taken 17, it is 18, Your Lordship.
How? What is the age? 26 years, 18 ಹೆಂಗ್ ಬರುತ್ತೆ?
17, correct.
So that is what tribunal is taken, Your Lordship.
What is wrong in that? 17 is correct. Okay. Madam, you should read your papers. It's all small, simple thing in calculations. And the deduction of 1/3 barallama, 50% deduction. So tribunal itself is taken 50%.
Yes, yes, yes.
Calculation is wrong there. 14,000 plus 40%, 19,600 divided by 2, 9,800 into 12 into 17. 19 lakhs, 99,200. All other things same, 15 plus 15 plus 40 plus 40 plus 8 plus medical expenses. Along with 6% interest. Future interest, future, the balance payment to be made within a period of 4 weeks, along with 6% interest. The disbursement, ಏನು ಮಾಡಿದ್ದಾರೆ 50% each ಮಾಡಿದಾರಾ? All other terms and conditions of release and apportionment is as per the order of the tribunal. Order according.
Pay and recovery.
All right. Now, one paragraph add ಮಾಡಿ. It is a contention of learned counsel for the respondent insurance company that the deceased was not having a valid driving license,
FC and permit, man.
FC and permit. Which vehicle is it?
Offending, Your Lordship,
Paragraph 35,
Tata,
35 of the judgment.
Was not having valid FC and permit as on date of occurrence of accident, and therefore there's a breach of policy conditions, and hence the insurance company is not liable to pay the compensation. So the liability will have to be fixed on the owner.
Owner, we had to first deposit and recover from it.
Therefore, the liability would have to be fixed on the owner of the offending vehicle. In view of the policy being in force, there shall be an order of pay and recover.
It is made clear in the page 22 of the judgment, my lord, para number 3, my lord, the order passed.
ಅಲ್ಲೂ ಆಗಿದೆಯಲ್ಲ
ಹೌದು. That's what liability has to fix on the owner and then we have to pay and recover.
No, already that pay and recover is already ordered.
Yes, that is what,
same as to.
So what further modification is required?
not required, my lord. That is what I just mentioned, that is what mentioned before the MACT, my lord. That is the order, impugned order passed.
No, then I need not make a fresh order on that.
No, no.
There's no further order required, as tribunal has already passed an order.
It has to be.
That your liability because of policy being in force,
Yes.
that you shall make the payment and
Confirm-
recover the
con-
same
Just confirm that order.
pay and recovery paragraph ideyalla, that is retained and
ಅಷ್ಟೇ.
the same is ordered by the tribunal. The contentions ಆದ್ಮೇಲೆ same is already ordered by the tribunal, and the same is retained with regard to pay and recover.
Mention.
Insurance on liability plea. There is no FIR, no charge sheet, no allegations against us. In spite of 50% and fixed against us, that will be set aside.
All these cases are death cases.
Death case, all 5 cases. All the 5 deceased are inmates of the car. Driver of the car has caused an accident.
Huh?
Driver of the car has been caused an accident.
Driver of?
Driver of the car came and hit our vehicle. All 5 persons, including driver, 5 persons has been died.
Which vehicle they were traveling?
Car, please.
Car.
Non vehicle Mahindra.
There are 2 vehicles are involved. I am the insurer of the car, and he is the insurer of the other vehicle. That is Mahindra KA20B 7352. Their contention is that the charge sheet has been filed against the driver of the car. So the entire liability has to be shifted on the insurer.
No, I am not seeking entire liability against you. 50% to be set aside against please.
ಅದು ಎಂಟೈರ್ ಲೈಬಿಲಿಟಿ ನಮ್ಮ ಮೇಲೆ ಹಾಕಿ ಅಂತ ಹೇಳ್ತಾರ.
ನಿಮಗೆ ಎರಡು 50-50 ಮಾಡಿದಾರ?
50-50.
Where claimant is not before the court?
Please,
Claimant has not come before the court.
Claimants have filed the cross objections.
Claimants have filed cross objection, right?
Pin ಹಾಕಿದಾರ?
Yes.
Mahesh.
But in this, what has happened is the insurer of the car has settled few cases out of the court in the local adalata, deducting some percentage with regard to the negligence on the part of the other vehicle. It has been done. That is one of their grounds, saying that the entire, because the insurer of the car has accepted the liability by settling the claims out of the court, the entire liability should be on the insurer of the car. That is their contention. But really, there is some confusion with regard to the apportionment of the percentage of. I make a detailed synopsis that will be helpful for your lordships to dispose of the matters. A date may be fixed.
ಎಲ್ಲ ಕೇಸಲ್ಲಿ ಹಂಗೆ ಮಾಡ್ಬಿಡಿ.
ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಕೊಟ್ಟು. ಎಲ್ಲ ಕೇಸಲ್ಲೂ.
If you want
And I will also furnish the cases where the insurance company has settled the matter out of the court. And what is the sum for which the matter is settled. Now,
that is accepted by you?
no, he is not the, that is not before your lordships.
So that is not in here.
No, that is their contentions, because they have let in evidence before the tribunal and also produced the document in support of those cases. And say that the insurance company has accepted their liability, so the insurer of the car. So the entire liability should be, but the tribunal has discussed it elaborately and given a finding that no doubt the charge sheet is filed against the driver of the car, but still the accident has occurred due to negligence of both the drivers. And that is the reason why the liability is apportioned to 50-50.
That's not, it was based on the statement of R1, for whom not the insurance, whose vehicle was insured with the appellant's insurance company. R1 not in other case not has admitted that not is not able to say at whose part accident has occurred. On that basis, not the court has standard the liability on both insurance.
Yeah, so far as the insurer of the car is concerned, they are not in appeal. We have satisfied the awards.
Car.
My lord, for a moment, kindly take the sketch produced by me, please.
No, yeah, we are not ready to argue why I should waste please your time and mine.
Apart from this matter covered by judgment of this honorable court.
I'll hear all that.
Kindly fix the date, please.
So you can also come with whatever judgments
Please,
you
please.
have.
One petition of 33.5, that is 119 of 53. Is one office objection, but I have produced not the improved judgment and award downloaded from the website. Therefore, not office objection, since certified copy.
Common judgment.
Yes, what?
Common judgment.
Separate judgments.
The office objection, since the certified copy is connected appeal, not certified copy, production of certified copy.
All right, particularly in MFA 33, serial number 33.5, MFA crop 119 of 23. Learned counsel for the cross objector claimant submits that the certified copy of the impugned order is produced in the connected matters and seeks dispensation of the same. Same is allowed and accepted. Certified copy is dispensed. Otherly R4 wakalat neeve
I have to file wakalat in all the cross appeals.
33.5 objection signature of the presiding officer is not found in the judgment of the website to download the document.
The objection raised by the registry in 33.5 is overruled. Call on. Acceptance idea. All right. Now your acceptance of R3. Wakalat filed by R3 is accepted
In all cases, please.
in all cases. Call all these matters together on. Please.
The matters are connected matters.
And for respond number 2, minutes, connection matter.
Hmm.
Case of injury.
Injury.
Please, mother.
Ready na? Records and bika gila.
First matter,
Hmm.
MSC 123 of 2021, MFA 8350 of 2023. The doctor has been assessed the disability at 76.39% and whole body 25.446%. Tribunal has taken at 16%.
ಕಮ್ಮು ಮತ್ತೆ disability delete ಮಾಡ್ಕೋಬೇಕು ಅಷ್ಟೇ. ನಿಮ್ಮ ಹತ್ರ ಇಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್?
ಎಲ್ಲಿದೆ? Which paragraph?
Paragraph.
Judgment page number 12, my lordship. Para number 14.
ಅದು MVC 123 na?
Please, my lordship.
So ಎಲ್ಲದರಲ್ಲೂ claimant appeal ಇದೆ.
ಹೌದೌದು.
ನಿಮ್ದೇನ್ appeal ಇಲ್ಲ.
ಅವ್ರದ್ದು appeal ಇಲ್ಲ.
So there is no need to interfere with the 25.46. Or you want escalation, enhancement of that.
Yes.
But income has been considered wrong, lawyer side, my lordship. Then disability, my lordship,
One
as
nimsha
per.
irri, Mr.
Please,
Let him argue. He's
Please,
a
my
lawyer.
lord.
Well, I will ask you. So 76.39%, whole body at 25.46.
Yes. Tribunal has taken 16%. In first case.
So 25.46 is exactly 1/3.
Yes, exactly 1/3.
So you are sustaining that.
Yes, yeah, 1/3 has to be taken. In this matter, first matter, ma'am.
Hmm.
But other matters, different disability has to be taken.
All right. So you come one by one.
Yes, ma'am.
First matter. PW5 is the doctor.
PW5. 5, 6, 7, 8.
MACT takes 16%.
16%.
All right. $15, 16, 15.
16.
Whole body 15%.
15 is right.
15%, my lordship.
The 16 is the multiplier.
Multiplier 16.
Para 15 ಅಲ್ಲಿ last line ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. Whole body at 15% instead of 25.46. That is what is done by the MACT.
Yes.
So you want 25.46 or what else? Medical?
medical bills, my lord, in this case, owner has kept the medical bills, man. He has reimbursed the medical bills. He paid. He has not given medical bills to us. He retained.
ಯಾರು?
ಓನರ್
ಹ್ಮ್
ಅವ್ರು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ರು.
ಹ್ಮ್
ಇವರು ದೇ ಆರ್ ಆಲ್ ಪೊಲೀಸ್ ಮೇಲೆ. All 4 members are police.
ಹ್ಮ್
He paid the medical bills, my lord.
ಹ್ಮ್
He wants those bills has to be reimbursed to him. The claimants has refused. Therefore, he has kept the all files, all the medical bills to with him. ಈ ತರ ಓನರ್ ಪೂರ್ ಪೀಪಲ್ ನ ಹೆರಾಸ್ ಮಾಡ್ತಾರೆ ಅನ್ನೋದಕ್ಕೆ ದಿಸ್ ಇಸ್ ದ ಗ್ಲೇರಿಂಗ್ ಎಕ್ಸಾಂಪಲ್ ಮೇಲೆ.
Owner has in good faith paid the medical expenses.
Yes.
Now that amount is released and paid to you.
Yes.
So your now contention is owner wants that amount back.
Yes, back.
ಅದು ಓನರ್ ತಂದು ಕರ್ಕೊಂಬಂದು ಹೇಳಿದ್ದೀರಾ?
ಅದರಲ್ಲಿ ನಮ್ಮ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲಿ ಹೇಳಿದೀವಿ ಆ ತರ.
ಆಯ್ತು. ಅದು ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ?
1,50,000 ಅಂತ ಹೇಳಿದ್ದಾರೆ ಎಲ್ಲದರಲ್ಲೂ.
ಅದು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ನೋಡ್ಬೇಕಾಗುತ್ತೆ.
ಅದೇ ಎವಿಡೆನ್ಸ್
ಮಲ್ಟಿಪ್ಲೈಯರ್ 16 ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲಲ್ಲ?
ಮಲ್ಟಿಪ್ಲೈಯರ್ ಇದು 16
34 years age.
34 16 ಕರೆಕ್ಟ್ ಇದೆ ಮಲ್ಟಿಪ್ಲೈಯರ್.
Pain and suffering.
ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಕಮ್ಮಿ ಇದೆ.
ಎಷ್ಟು ದಿನ ಇನ್ಪೇಷಂಟ್ ಇದ್ರಿ?
ಇದರಲ್ಲಿ 25 days ಇಂಪೇಷಂಟ್.
ಅದು ಕೊಟ್ಟಿಲ್ಲ ಅದು.
ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ 40,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ, ಪೈನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಯುವರ್ ಫುಡ್ ನರಿಶ್ಮೆಂಟ್ ಅಂಡ್ ಅದರ್ ಥಿಂಗ್ಸ್ ದಟ್ ಇಸ್ ನಾಟ್ ಗಿವನ್.
ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ.
20,000 ಇದೆ.
ಟೇಬಲ್
ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ 20,000.
ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು ಎಲ್ಲಿ?
2020 ನಲ್ಲಿ.
ಎಲ್ಲಿ? ವಿಚ್ ಪ್ಲೇಸ್?
ತುಮಕೂರು
ಅಲ್ಲ, ತುಮಕೂರಲ್ಲ, ಇರದ
ತರೀಕೆರೆ.
ತರೀಕೆರೆ.
ಶಿವಮೊಗ್ಗ.
ಶಿವಮೊಗ್ಗದಲ್ಲಿ ಫಸ್ಟು ಅಲ್ಲಿ ಹಾಸ್ಪಿಟಲ್ ಇದ್ದು, ಆಮೇಲೆ ಅಲ್ಲಿಂದ ತುಮಕೂರು ಶಿಫ್ಟ್ ಆಗಿದೆ.
So this can be 25,000 instead of 20,000. Pain and suffering will have to be enhanced. ಎಷ್ಟು ಕೊಡಬೇಕು pain and suffering ನಿಮಗೆ?
ಅಟ್ಲೀಸ್ಟ್ 1 lakh ಆದ್ರೂ ಕೊಡ್ಬೇಕು. ವಿ ಕಾಂಟ್ ಮೆಜರ್.
ಏನಾದ್ರು ಇಂಜುರಿ ಏನಾಗಿದೆ?
ಇಂಜುರಿ ಮೇಲೆ ಫ್ರಾಕ್ಚರ್ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಇವರೇನು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿಲ್ಲ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ. ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ
ಇಂಜುರಿ ಏನಂತ ಹೇಳಿಲ್ವ ಅವರು?
ಡಾಕ್ಟರ್ ಇವರು ಇದರಲ್ಲಿ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ
ಇದೆಯಲ್ಲ, ಪ್ಯಾರಾ 14 ಅಲ್ಲಿ sustained left shoulder dislocation, greater tuberosity fracture, grievous in nature. Next. Pain and suffering ಆಯ್ತು, attendant charges, food nourishment ಆಯ್ತು. Working as what? Labor?
labor ಕೂಲಿ work.
ಕೂಲಿ.
So loss of income during later period. Income is taken as how much?
14,500.
14,500.
As per national income they taken, there is no income.
So accident is of the year 2019.
20 my lord.
20.
So income is taken up for how many months? This 29,000?
2 months
has
taken.
been granted.
Laid up period.
Shoulder. 6 months. ಒಂದು 6 ತಿಂಗಳು ಬೇಕಾಗುತ್ತಾ?
More than 4 months is enough.
Dislocation of shoulder and one
Please,
more
madam.
tuber. So 6 months.
In
recovery.
cross-examination is admitted is fractures are united, my lord.
Fractures are united.
Please, my lord. Judgment page number 13, my lordship. Para number 15, my lordship.
ಯುನೈಟ್ ಆಗೋದ್ರೆ ಅದು ಇದು ಡಿಸಬಿಲಿಟಿ ಹೋಗಲ್ಲ.
Can I permit a treat, my lord?
Yes, yes.
But if cross-examination is produced that it becomes clear that future fractures are united, so far as implants are not removed, this is apparent that the disability has been assessed before the removal of the implants. In fact, the disability should have been assessed after removal of the implants. Supposing the disability has been assessed after the completion of the full treatment, perhaps there would have been reduced the percentage of disability. Moreover, the wound certificate and case sheet exhibit P4 and exhibit P32 reveals that petitioner has not sustained any injury to right lower limb. Considering the aspect, I am of the opinion the disability assessed by the doctor is excessive. Therefore, having the regarding nature of injuries and the duration of the treatment of the present condition, the petitioner, this tribunal would like to take disability whole body 15% instead of 25.46 calculation by the doctor.
Implants has not been removed.
All right, we'll take it as 4 months. Yeah. 4 months around 58,000.
Please, my lord.
Medical expense actual 6,495.
Please, my lord.
Future amenities and happiness. Future medical expense nil. Yes, anything else, Mr. Shantaraj?
In this case, the future medical expenses has to be granted. Medical expenses has produced bills to an extent of 6,495,000. He stated before court on oath that he has spent 1,50,000. And bills has been retained by owner.
ಅದಕ್ಕೆ ಎವಿಡೆನ್ಸ್ ನೀವು ಮಾಡಿಲ್ಲ?
ಮಾಡಿದೀವಿ, ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿದೀವಿ.
ಇಲ್ಲ, ಅದು ಬಿಲ್ಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ದೀರಾ?
ಹೌದು.
ಓನರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ದೀರಾ?
ಓನರ್ ಅವ್ನ ಬಿಲ್ ಅವರೇ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದೀವಿ.
ಕರೆಕ್ಟ್. ಇವಾಗ ಓನರ್ ವಾಪಸ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಓನರ್ ಬಂದು ಹೇಳ್ಬೇಕಲ್ಲ. That can be accepted, your version.
Sorry, of course, it's a reality, but of course, on the.
What you are saying is right. Suppose if the owner or the principal, maybe he is the principal employer, contract employer, if he is coming and asking, maybe morally he has accepted his fault and he must have paid. All right. Next, what else?
In this case, this is the matter, first matter. Next matter, 124 Milan. Is doctor has assessed.
Before that, we'll finish this matter and then proceed. Perkolim. Idರಲ್ಲಿ
future prospects has to be added.
ಯಾವ್ದ್ರಲ್ಲಿ?
First matter ಅಲ್ಲಿ. 25.46%.
Fractures are united, my lord. Means tribunal has.
Early because if it has united, ಈಗ ನನ್ಗೂನು ಯುನೈಟ್ ಆಗಿದೆ ಇದು. ನನ್ನ ಕೈ 4-5 ತಿಂಗಳು ತಗೋತು, ಆದ್ರೂ ಸೆನ್ಸೇಷನ್ ಕಳ್ಕೊಂಡಿದೆ. ಲಿಟ್ಲ್ ಫಿಂಗರ್ has lost sensation. Merely because it has been united, the disability will not go.
What is the evidence of the doctor?
Yes, doctor. PW5.
ಓದಿ.
ಇದು disability Is in cross-exam, he has read cross-examination.
He's the treated doctor?
He's a treated doctor. He's
Not
not a
treated.
treated, one of the consultant doctor.
Read his evidence.
Yes.
ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇದೆಯಾ?
ಇದೆ, cross-examination ಇದೆ. LCR ಬಂದಿದೆ.
Yes, you can read.
Cross-examination. Documents both of them documents.
I permitted read my letter. I submitted Mr. Girish, son of Tipaya, aged about 36 years, residing at Belur village. The CNL is come to hospital. History of RTA patient was traveling in four-wheeler car and hit by the roadside around 10:30 p.m. on 1/8/2020 near Anantapura village, Sagar Taluk, Shivamogga. Preliminary on 2/8/2020 patient was taken treatment at Max Super Specialty Hospital, Shivamogga, and then came to the above hospital 3/8/2020. The following injuries: left side anterior shoulder dislocation, left greater tuberosity fracture, was admitted on 3/8/2020, was treated, operated with open communication and intellectual fixation with the pillows, plate, screws, and it discharged on 17/8/2020. In recently, I examined the above petitioner 2023. He has a difficulty in doing activities of daily living and is present pain and difficulty in the walking, climbing, and doing work. I submitted based on the age and nature of injuries, clinical and radiological examination of the Government of India Gazette notification. I am of the opinion that suffers physical disability of right lower and left lower limb 76.39% and 25.46 for the whole body. I submitted the time of the producing of the document recently examination reported case sheet number 1 X-ray 2 document number of disability certificate. That's my that.
Cross-examination.
In cross-examination, myself, I am given treatment to the petitioner when I am here with.
He's the treated doctor.
Came to when examined of the petitioner, I came to know that injuries suffered by him was fresh. A team of the doctor is given treatment to Dr. Shashikumar was the head of the team. I have 8 years experience as the orthopedic surgeon. It's true that fracture suffered by the petitioner is united. So far, implants are not removed. It is false to say that petitioner does not have any pain. It is false to say that I have not assessed the disability as per the Gazette notification. It is false to say that petitioner does not have so much disability as calculated. It is false to say that when I am giving false evidence to enable to petitioner to get more compensation through the he is as fit as he was before.
ಅಷ್ಟೇ. ಏನಿದೆ ಮತ್ತೆ ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್? So he has negatived all your case. So why 25% should not be taken? Both limbs.
Learned MACT has been conclusion that my lordship finally.
On what basis?
Fractures are united. That purpose they had taken 16% disability. This is my submission, my lordship may be.
Future prospects. 25% ಅಂದ್ರೆ ಹೆಂಗ? Shoulder injury and he's a labor. He can't do his work.
My contention may be taken on record, my lordship.
Short notes ಬರ್ಕೊಳ್ಳಿ. Age of the injured is 34 years. Multiplier is 16, correctly taken, does not call for interference. The income assessed by the tribunal is 14,500 as notional income, same is retained. Doctor is examined as PW5, find disability to an extent of 76.39% to right lower limb and left lower limb. Whole body disability at 25.46%. However, tribunal has differed from the same and has taken the disability at 15%. There is no contra material or cross-examination elicited by the insurance company to reduce the disability to 15% to whole body. In view of lack of there being contra material from the insurance company, the opinion expressed by the expert doctor PW5 has to be accepted. Accordingly, 25.46 is to be taken as disability to whole body. Stop. Learned counsel for the appellant seeks future prospects to be granted in view of disability of 25.46% to whole body. Stop. Accepting the same. 40% future prospects would have to be added to the income in view of age being less than 40 years of the claimant. Therefore, the loss of future income due to personal disability would be 14,500.
14,500.
500 plus 40%. 20,300 into 12 into 16 into 25.46.
9 lakh. 9 lakh?
ಎಷ್ಟಾಯ್ತಮ್ಮ? Correct. 9,92,328.96. Towards pain and suffering, 40,000 is awarded. Additional 40,000 is granted by this court. Towards attendant charges, food, nourishment, conveyance, 50,000, 45,000 is granted as against 20,000. In view of a claimant being inpatient for 25 days. Towards loss of income during later period, at the rate of 14,500 into 4 months, 58,000 is awarded as against 29,000. Medical expenses, 6,495 is retained. Loss of future amenities and happiness of 30,000 is retained. Towards future medical expenses in view of removal of implants, 20,000 is awarded under this head. Full stop. When paragraph. Learned counsel for the insurance company vehemently objects to grant of future prospects as there is no serious injuries sustained by the claimant and the fractures are united. Therefore, the claimant being a labor would be able to perform some activities for his employment. However, this court is not inclined to accept the same in view of the disability opined by the doctor to be 76% to the left lower limb and right lower limb, 76.39 and whole body disability at 25.46. Ordered accordingly. Yes, next.
Next matter, my lord. This case, doctor has assessed the permanent disability to an extent of 92% to the limb and 30.986% to the whole body, my lord. Here, there is a shortening of 10 inches, my lord. Last kindly see the photos, my lord. Earlier in 2023, it has taken. Now yesterday, photo has been taken, my lord. 10 inches. There is shortening of 10 inches.
ಎಲ್ಲರೂ ಲೇಬರಾ ಎಲ್ಲರೂ
All are
All are
laborers,
laborers.
my lord. 4 members are laborers, my lord.
So this is taken as on date of the occurrence of accident or later?
Photos, it has been taken on 2023, my lord.
Accident.
Now,
20.
the Xerox copy which I am taken, my lord, yesterday it has been sent, my lord.
2020 accident.
Yes.
20 accidents.
Same is opined by the doctor.
He has taken, in this case, my lord, the disability has been not accepted. He has taken 20%, my lord.
Income 14,500
Yes, yes.
ಎಲ್ಲದರಲ್ಲೂ same.
Same.
Produce Aadhaar card, age proof. 31 years is correct?
30 years, my lord, 30 years. 17 multiplier has been applied.
16 is ತಗೊಂಡಿದ್ದಾರಲ್ರಿ
ಇದರಲ್ಲಿ
ಮತ್ತೆ
34 years. taken 30.
ಅಲ್ಲ, first 34, first one.
Second ಅಲ್ಲಿ 31 years multiplier 16, 20% income. Second is MVC 124 alva.
Yes,
Please, my lord.
120.
124 al para 29 is what it deals with.
31 years.
31 years multiplier 16.
Aadhaar card as per exhibit P14.
Aadhaar card is not an authenticated document. Apex court itself has been stated.
ನೀವೇನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ, ಸರಿ, ಇದು ಏಜ್ ಪ್ರೂಫ್ಗೆ ಆಧಾರ್ ಕಾರ್ಡ್ ಇಲ್ಲ.
So you produce na?
ಅದು ಅವ್ರು ಇನ್ಸಿಸ್ಟ್ ಮಾಡ್ತಾರಲ್ಲಿ ಇದು MSCT ನಲ್ಲಿ.
Now if you are differing from that, the onus lies on you to show that your age is so and so.
Of course, medical documents has been shown as 30 years, but he has taken 31 years, relying upon the Aadhaar card.
All right. Next.
Disability 30.86. ಇದರಲ್ಲಿ I am relying upon the judgment of the apex court, my lord. Recently, principal law restitutio ad integrale. An amount of 15 lakh has to be granted.
Now, what is the disability in this case?
This case, 92% to the whole body.
A particular limb, particular.
And 30.86% to whole body, my lord. Here, there is a shortening of 10 inches, my lord. Leg.
ಎಲ್ಲಿದೆ ಮೆಡಿಕಲ್ 92% ಅಂತ ಎಲ್ಲಿದೆ ಅದು? Yes, para number 26 itself.
Please, my lord.
92.06% to right lower limb and whole
Whole
body
body?
at 30.86.
Please, my lord.
Apex court recently, my lord, in case Muralidhar case, 10 lakhs has been granted for pain and suffering, since it is a paraplegia case.
ಇದು paraplegia.
ಇಲ್ಲ ಇದು paraplegia.
ಅಲ್ಲ,
decision ಅಲ್ಲಿ.
Principle, they have stated, my lord, principle of restitutio ad integrum. It has to be compensated suitably. Therefore, they have claimed 10 lakhs, relying upon the Castle and Master Roy's case, my lord. 15 lakhs has to be granted, but they have claimed 10 lakhs and 10 lakhs has been granted. Recently, another 7 years old girl, apex court, recently held 15 lakhs has been granted for pain and suffering. Loss of amenity, 15 lakhs has been granted. In respect of pain and suffering, what is the pain and suffering? It has elaborately discussed in this matter. We can't measure it in terms of money. Therefore,
ಇದ್ರಲ್ಲಿ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವಾಗ?
ಆ,
ನಿಮಗೇನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದ್ರಲ್ಲಿ?
ಅಲ್ಲಿ ಅದೇ pain and suffering ಇದು
40,000 ಕೊಟ್ಟವ್ರೆ.
Pain and suffering 40,000 rupees awarded.
ಅಲ್ಲ, 10
Whether,
inches-
whether future prospect is taken in this case?
No, not taken. In all the cases, future prospects has not been
All right,
taken.
future prospect ಕೊಡುವ ಇದರಲ್ಲಿ.
The pain and suffering ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕು ಅಂತ ನನ್ನ ಇದು 10 inches shortening
ಇವಾಗ
ಇದೆ.
in that minor case, future prospect is not given, there the future, that 10 lakh, 15 lakhs is given. But in these cases of adult in nature, future
in-
prospect is given and pain and suffering, something can be enhanced.
ಇದರಲ್ಲಿ ಮುಳಿದರ್ ಕೇಸಲ್ಲಿ ನಮ್ಮ ಈ ಕೊಡ್ದೇನೆ ಸುಪ್ರೀಂ ಕೋರ್ಟು 10 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಪ್ಯಾರಾಪ್ಲಿಸಿಯಾ ಕೇಸಲ್ಲಿ.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ?
ಇದು ಶಾರ್ಟ್ನಿಂಗ್ ಮತ್ತೆ ಇದಿದೆ, ಇದು ಫ್ರಾಕ್ಚರ್.
ನೀವು ಫೋಟೋ ಕೊಟ್ಟಿರೋದು ನೋಡಿದ್ರೆ,
ಹೌದು,
apart from the shortening of the leg.
ಹೌದು, 10 inches ಶಾರ್ಟ್ನಿಂಗ್ ಇದೆ.
So he can sit down and do some work. Maybe not to the extent of what he was doing.
Yes, yes, yes.
Absolutely, he cannot do the same work as he was doing prior to the accident. That is 100% sure. No accident, a person can come back to his original position. The future prospect has to be given plus 40%. Pain and suffering on the increased model. Next. What else is there in this case?
ಇದು ಅಷ್ಟೇ.
Attendant, how many days inpatient?
ಇದರಲ್ಲಿ 67 days inpatient.
67 days.
Yes.
67,000. What about income during later period?
ಇದು 2 months ಮಾತ್ರ ಕೊಡಿ.
2 months grant.
Also wrong. So 14,500 into 6 months. Medical expense 8,000.
ಅದೇ
Future
ಸೇಮ್
amenities and
ಮೆಡಿಕಲ್
happiness.
ಇದನ್ನ ಕೊಟ್ಟಿಲ್ಲ.
50. Future amenities and happiness 50,000 instead of 30,000. Pain and suffering 1 lakh instead of 40,000.
The amenities, 1 lakh, minimum 2 lakhs has to be granted. Yes, deprived to enjoy his life.
That is why 50,000 is being awarded. We don't know, he may still be able to do some work.
Some work.
Unlike paraplegia or fully deformed, unable to get out from the bed, then you need sufficient, and in fact, you will probably need one attendant also. Adರಲ್ಲಿ.
Yes, in that case, attendant is needed.
ಇದರಲ್ಲಿ ನಿಮಗೆ ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸ್ ಏನಾರು ಹೇಳಿದಾರಾ?
ಹೌದು, ಇದರಲ್ಲಿ implants remove ಮಾಡಿಲ್ಲ ಇದರಲ್ಲೂ, ಇದು ಕೊಟ್ಟಿಲ್ಲ.
ಇದರಲ್ಲಿ instead of that amenities, what we will do is permanent disfigurement ಇದೆಯಲ್ಲ, there we can add another 20,000, make it 50,000. Thereby whatever you have said 1 lakh will come to you. 1 lakh ನೀವು ಕೇಳಿದ್ ಬರುತ್ತೆ ಅದ್ರಲ್ಲಿ. Because different heads ಅಲ್ಲಿ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. Future medical expenses, whether doctor has said anything, removal of implant?
Doctor has not stated.
ಹೇಳಿದಾರಾ?
For fixed treatment, approximate cost surgery around 1 lakh rupees. But my one submission, my lord, the data falls in 2020, my lord. If they have done any treatment, my lord, they can produce the document. I am ready to pay that future medical expenses, my lord.
That is not the, in the motor vehicle cases.
We'll give another additional 20,000 on that.
Please, my lord.
Unlike the poor people, where the poor people can keep labors and all, they won't go. ಇದನ್ನೇ ತಲೆಯಲ್ಲಿ ಇಟ್ಕೊಂಡು ಬೇಕು ಅಂತ ಅವರು ಬಿಲ್ಸ್ ಎಲ್ಲ ರೆಡಿ ಮಾಡ್ಕೊಂಡು business
submission, my
minded.
lord. I can
They will
understand.
probably keep it in mind and keep those bills. You can't
Please, ma'am.
expect a labor to do all that. Next. ಈ ಕೇಸಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿಮ್ಮ. The age of the claimant is 31 years. Multiplier is taken at 16, same is not interfered. Income is taken at 14,500. Doctor is examined as PW5, whose opined disability to an extent of 92.06% to the right lower limb, whole body disability 30.86%. ಇದರಲ್ಲಿ ಟ್ರಿಬ್ಯುನಲ್ ಏನು ಮಾಡಿದ್ದಾರೆ, ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? 20%.
20%.
Whereas tribunal has taken the disability at 20% without there being any contra material or cross-examination to that extent. Hence, the opinion expressed by the tribunal cannot be accepted. The expert opinion of the doctor at 30.86% to the whole body is to be taken on the face value. In view of there being no contra material placed by the insurance company. Future prospects at 40% requires to be granted in this case in view of permanent disability of 30.86% to the whole body. As for the loss of income due to permanent disability would be 14,500 plus 40%, 20,300 into 12 into 16.
Please, Madam. Multiplier 16.
30.86. Twelve lakhs.
12 lakh.
2,799.
Please, Madam.
12 lakhs, 2,799. As against 5,56,800. Pain and suffering, 1 lakh is awarded against 40,000. Attendance charges, extra food, nourishment, conveyance, 67,000 is awarded as against 20,000. As claimant was inpatient for 67 days. Loss of income during later period, 29,000 is awarded. At the rate of 14,500 for a period of 6 months recuperation. It would be 87,000. Towards medical expense, 8,000 is retained. Future amenities and happiness, 50,000 is awarded as against 30,000. Future medical expenses, 40,000 is awarded as against 20,000. Permanent disfigurement, 50,000 is awarded as against 30,000. All right, next, 125 MVC.
This case also, 90%. This is, in this case, external fixation has been done, my lord. External fixation.
So either 30 years, 17 multiplier.
External fixation ಇರೋದ್ರಿಂದ ಕಾಲು ನೀಡ್ಕೊಂಡು ಅವನು ಮಲಗೋಳಕ್ಕೆ ಆಗಲ್ಲಂತೆ.
124. Let me see 124. Now we are 125. Barkolima. MBC 125. Age of the claimant is 30 years. The multiplier is taken at 17. It's not interfered. Doctors examined PW5 disability assessed at 90.92 to the left lower limb and whole body disability at 30.30. However, tribunal has assessed the disability 20% without there being any contra material, same what we have repeated earlier. Therefore, disability is to be taken at 30.30%.
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ತಗೋಬೇಕಾಗ್ತದೆ. ಯಾಕೆಂದ್ರೆ ಎಕ್ಸ್ಟರ್ನಲ್ ಫಿಕ್ಸೇಷನ್ ಇರೋದ್ರಿಂದ ಅವನು he can't see.
No, that how I cannot go beyond what the doctor has expressed disability.
Mathematical calculation medical.
When I am not agreeing with the tribunal at 20%, how this court can put itself in an expert's shoes? I'm not an expert in medical
Yes, of course.
unless the doctor himself has said 30.30% whole body. You can be given 30.30 future prospects.
This case, pain and suffering can be.
ಅದರೆಲ್ಲ ಮಾಡುವ
ಅದರಲ್ಲಿ ಇದು ಮಾಡ್ಬೇಕಾಗ್ತದೆ ಇದರಲ್ಲಿ
ಹೇಳಿ.
ಇದು ಅವನು ಮಲಗಕ್ಕಾಗಲ್ಲ ನಿದ್ರೆ ಬರಲ್ಲಂತೆ ಈ ಕಾಲು
ಕೊಡಿ ಕೊಡಿ. Where is the other court, assistant court officer?
ಸ್ಲೀಪ್ ಮಾಡಕ್ ಆಗಲ್ಲಂತೆ ಪೇನ್ ಬರ್ತದಂತೆ 1 hour 1.5 hour ಅಷ್ಟೇ ನಿದ್ರೆ ಅಂತ ಒಂದು.
No, this is in 2023.
ಈಗ ರೀಸೆಂಟ್ ಫೋಟೋ ನಿನ್ನೆ ಎಸ್ಟರ್ಡೇ ಇಟ್ ಹಸ್ ಟೇಕನ್.
ಎಲ್ಲಿ 23 ಅಂತಾನೆ ಇದೆಯಲ್ಲ.
ಹೌದು 23 ಈಗ ಇನ್ನೊಂದು
ಜೆರಾಕ್ಸ್. Correct. So this will come under pain and suffering and disfigurement ಅದೆಲ್ಲ ಬರುತ್ತೆ. That we will see. Yeah. Pain and suffering ಬರ್ಕೊಳ್ರಮ್ಮ. 1 lakh rupees as against 50,000. ಇದರಲ್ಲಿ ಎಷ್ಟು ದಿನ inpatient?
ಇದರಲ್ಲಿ 13 days
ಅಷ್ಟೇನಾ?
ಅಲ್ಲ
ಅಂತ ಹೇಳಿದ
ಇದು
My lords, in the earlier case, my lords, he was 13 days inpatient. In
No,
this,
no.
my lords, your lordships is dictating is 60 days.
ಇಲ್ಲ ಇಲ್ಲ ಅದರಲ್ಲಿ ಎರಡು ಹಾಸ್ಪಿಟಲ್ ಇದು ವಿಕ್ಟೋರಿಯಾ ಅಂಡ್
ಅಲ್ಲ, ಈ judgment.
ಜಜ್ಮೆಂಟ್ ರಾಂಗ್ ಆಗಿ ಬರ್ತಿದ್ದಾರೆ.
Because Mr. Shantaraj,
Yes.
what Ashok Patil is saying may also make sense because this is appearing to be more 67% and that must be 13%. I mean 13 days.
ಎಸ್ ಎಸ್ ಮೇಡಮ್
ಯಾಕೆಂದ್ರೆ
There's some
ಅದರಲ್ಲಿ
confusion because
ಮಲ್ಗಕ್ಕೆ
there are
ಏನ್
4
ಮಾತ್ರ
matters.
ಬರಲ್ಲ ಅವ್ರಿಗೆ. ಇನ್ಪೇಷಂಟ್ ಜಾಸ್ತಿ ಆಗಿರಲ್ಲ, ಓನ್ಲಿ ಫಾರ್ ದ ರಿಡಕ್ಷನ್.
ಅದರಲ್ಲಿ ಹೌದೌದು ಅದು ಇದು
ಸೊ ಅದರಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿರೋದು ಅವರು?
6 months ಕೊಟ್ಟಿದೆ, 2 months ಕೊಟ್ಟಿದ್ರು ಅವರು, ತಾವು 6 months ಅಂದ್ರಿ.
ಸೊ ಅದರಲ್ಲಿ
3 months, my lords, maybe.
ಪ್ರೀವಿಯಸ್ ಕೇಸಲ್ಲಿ 40,500 into 6 months ಇದೆ, ಅದು 14,500 into 4 months ಮಾಡಿ.
ಎಸ್ ಎಸ್
And 67,000 ಬರಲ್ಲ ಅದರಲ್ಲಿ. You make it 30,000 instead of 20,000. ಬರ್ತಾಯ್ತು. ಪ್ರೀವಿಯಸ್ ಕೇಸಲ್ಲಿ the MVC number
125.
120 ಕನ್ಫ್ಯೂಸ್ ಮಾಡಬೇಡ್ರಿ. 124 ಅದು. 124 ಅಲ್ಲಿ ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 67 ಹೇಳಿದ್ದೆ ಅದನ್ನ 30,000 ಮಾಡಿ. ಅಂಡ್ ಇನ್ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಪೀರಿಯಡ್ ಇಂಟು 4, 14,500 into 4, 58,000. Only that will change. Now in 125 ಅಲ್ಲಿ ಏಜ್ ಎಲ್ಲ ಬಂತಲ್ಲ, ಡಿಸಬಿಲಿಟಿ ಬಂತು, 40% ಆಯ್ತು. ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ 1 ಲಕ್ಷ. ಅಟೆಂಡೆಂಟ್ ಚಾರ್ಜಸ್, ಫುಡ್ ನರಿಶ್ಮೆಂಟ್ 67,000.
ಅಲ್ಲ, 25,000 is awarded. He was inpatient for 60 days.
60,000 instead of 25,000.
Yes.
Loss of income laid up period 40,500 into 6, 87,000. Medical expense 13,631 retained. Loss of future amenities, happiness, it will be 50,000 as against 30,000. Future medical expenses 50,000 as against 20,000. Permanent disfigurement how much should be awarded in this for permanent disfigurement?
My lords, your lordship kindly award 50,000 minutes as against 20,000.
50,000 instead of 20,000.
ಕಮ್ಮಿ ಅನಿಸ್ತು.
Any other bills ಏನಾರ ಇದೆಯಾ? ಇಲ್ಲ, ಇಲ್ಲ, ಇದ್ರಲ್ಲೂ ಇಲ್ಲ.
ಅಲ್ಲ ಅದು ಕೊಟ್ಟಿಲ್ಲ. ಆಲ್ ಎಸ್ ರಿಟೈನ್ 4 cases.
Yes. Next. Future
Future medical.
medical expense, 20,000 ಇದೆ, that you make it 40,000 as against 20,000. ಗೊತ್ತಲ್ಲ, loss of future earning capacity, ಇದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಬಂದಿಲ್ವಾ?
ಅದು ಚೇಂಜ್ ಮಾಡ್ಬೇಕಾದ್ರೆ
ಅದರಲ್ಲಿ 14,500 plus 40%.
ಅಲ್ಲ 30%.
ಏಜ್ ಏನು?
30 years.
I'm saying the
30 years.
percentage of disability is
ಇಲ್ಲ,
30.30.
I'm coming on that disability ಅಲ್ಲಿ. For
Yes.
future prospects.
Yes, 40%.
40%.
20,300 into 12 into 17.
17 is multiplier.
Then 20,300 into 12 into 17 into 30.30.
12 lakhs 54,783, my lords. Your lordship, kindly round off to 12 lakhs 55,000.
12 lakh 54,783 rounded off to 12 lakhs 55,000.
55,000. Lordship, kindly observe that on perusal of the photographs, recent photographs, the enhancement is not made on the disfigurement and other heads. So that it will justify the.
One sentence add ಮಾಡ್ಕೊಳ್ಳಿ. In these two cases, learned counsel for the appellant has produced along with a memo latest photographs to show the enormity of the disability and loss of future earning capacity, on the basis of which this enhancement is made by the court. Same is taken on record. Yes, 126.
59.33%. 19.77% to whole body area.
8 days.
8 days. Was inpatient for a period of 8 days.
In cross-examination, he is admitted that his fractures are united after. This maybe tribunal has been considered 10% is correctly said. That is my submission, Maharaj.
Name submission ಎಲ್ಲಾದ್ರಲ್ಲೂ ಅದೇ ಬರುತ್ತೆ. In all submission, your objection will be noted.
Please, Maharaj. That
ಇದರಲ್ಲಿ ಏನು ಫೋಟೋಗ್ರಾಫ್ ಇದೆಯಾ?
ಫೋಟೋಗ್ರಾಫಿ ಇಲ್ಲ, ಅವೆರಡು ಬಹಳ ಸೀರಿಯಸ್.
ಇದರಲ್ಲಿ ಏನು ರಿಡಕ್ಷನ್ ಇಲ್ಲ.
ರಿಡಕ್ಷನ್ 10% ನೋಡಿದ್ದಾರೆ, instead of 19.77%.
ಅದು 19% ಕೊಡುವ ನಿಮ್ಗೆ ವಿತೌಟ್ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್.
please, Maharaj.
ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಆಡ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಸಾಕ್ಬಿಡಿ ಅಂತಾರೆ ಮಲ್ಲಿಕಾರ್ಜುನ್ ರೆಡ್ಡಿ.
ಇವಾಗ ನೀವು ನಿಮ್ ಕೈಯಲ್ಲಿ ಫ್ರಾಕ್ಚರ್ ಆಯ್ತು, ನೀವು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರಲ್ಲ ಪೇಪರ್ ಎಲ್ಲ ಹಿಡ್ಕೊಂಡು. ಕರೆಕ್ಟ್ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಹೇಳ್ತಾ ಇರೋದು.
ಸೆನ್ಸೇಷನ್ ಕಳ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ ಲಿಟ್ಲ್ ಫಿಂಗರ್. ಇದು
Based on avocation, the earlier cases it required because they are laborers and they will have to lift. Here 20%, give them suitable and maybe increase in others' heads. Otherwise, this will become a precedent for other cases. Whenever we pass judgment, it acts as a precedent for other cases.
Please, Maharaj.
So it should not be taken undue advantage by others where their 20% and does not affect future earning capacity.
Otherwise, act, spirit of the act itself has been defeated, Milan. ಆ ಕಾನ್ಸೆಪ್ಟ್ ಅಲ್ಲಿ
ಬರ್ಕೊಳ್ಳಿ. The age of the claimant in this case is 39 years. Multiplier adopted is 15 years. Correct? Does not call for interference.
ಹುಷಾರಾಗ್ತಾರೆ ಬೇಗ.
The doctor was opined disability of 59.33% to the right lower limb and left upper limb. Whole body disability 19.77%. The tribunal has assessed disability at 10% without there being any contra material and evidence of or cross-examination. Hence, disability is to be taken at 19.77%. So loss of income due to disability would be 14,500 into 12 into 15 into 19 point.
Rounded 20% can be.
7 modern. $5,15,997. 5,16,000 rounded off to 5,16,000. Towards pain and suffering, 1 lakh is awarded as against 30,000. Yes, the inpatient idರಲ್ಲಿ
8 days.
8 days. madam.
20,000 correct ಇದೆ. Towards food, nourishment, attend charges, 20,000 is retained. Loss of income during later period, rate of 14,500 into 4.
3 months, my lord. 8 days inpatient. 3 months may be up.
20%, not the question of inpatient. After that, whether he
please.
can do the job, but how much longer time he will have to recuperate.
Please, my lord.
So 14,500 into 4, 58,000. Medical expenses, 2,776 retained. Loss of future amenities, happiness, 50,000 as against 30,000. Future medical expense, ಏನಾರ ಇದೆಯಾ ಇದರಲ್ಲಿ implants?
ಇದು implants ಇದೆ.
ಹೇಳಿದಾರ ಡಾಕ್ಟರ್?
ಡಾಕ್ಟರ್ ಯಾವ್ದ್ರಲ್ಲೂ ಹೇಳಿಲ್ಲ, ಬಟ್
ಅದೇ. Not stated in his evidence, the petitioner requires to be treated in future. PW8. ಎಲ್ಲ ಕೇಸಲ್ಲಿ ಡಿಫರೆಂಟ್ ಡಾಕ್ಟರ್ ಇದಾರೇನೋ?
ಇಲ್ಲ, ಒಬ್ರೆ.
PW8 ಅಂತಿದೆ ಇದರಲ್ಲಿ.
ಅದೇ 4 ಕೇಸ್ಗೆ 5 ಇಂದ 5, 6, 7, 8 ಆಗಿ ಮಾಡಿದ್ದಾರೆ.
Doctor is 5, 6, 7, 8.
Please exhibit.
No, doctor is PW5.
5 ಫಸ್ಟ್ ಕೇಸ್ಗೆ.
Dr. Akbar.
Oh, so he the same doctor, but becomes 5, 6, and 7.
4 ಕೇಸ್ಗೆ 4.
Each case, first case will PW5, second will PW6, third 7, fourth case will 8. So it will PW8. PW8 is the doctor. Or in ಹೇಳಿಲ್ಲ future medical expense.
ಏನು ಹೇಳಿಲ್ಲ ಇದರಲ್ಲಿ.
ನೀವು ಏನು ಹುಡುಕಿದ್ರು ಬರಲ್ಲ ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡಿ? You will be the first person otherwise to say. That's all. All. Into appeals are allowed in part. Claimants, the judgments and award is modified. Claimants are entitled to total compensation of so and so, along with interest at 6% per annum. Balance compensation shall be paid within a period of 4 weeks. Enhanced compensation shall carry 6% interest. All other terms and conditions stipulated by the tribunal stands intact.
Enhanced amount will be released in my lap.
Enhanced amount shall be released in favor of the respective claimants.
Delay.
No delay? All right.
All the cases.
Amount new payment ಮಾಡಿದ್ದೀರಾ?
We have deposited before MS. Trial court award satisfied, madam.
ಎಲ್ಲಾದ್ರೂ
So instead of madam, all other terms ಬದಲು enhanced compensation shall be released in favor of the
yes, all cases.
appellant claimants. ಇದೊಂದು ಮೆಮೊ ಕೊಡಿ. ಈ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಮೆಮೊ ಕೊಡಿ.
Hey, Constable,
Yes.
evening, bit late, my lord. On transfer petition, my lord, the case is listed on 17th from Kustki to Bangalore, my lord. Therefore, kindly have done day after tomorrow.
Madam, day after tomorrow ಬರ್ತಾ ಇದ್ದಾರಾ? His lordship, ladyship? All right, so you want on Wednesday?
Please, my lord.
Call this matter on 15 post this matter.
Serial number 19 admission matter, madam.
19,
39, sorry, madam.
39,
Yes.
But
appeal of the insurance company.
ಏನ್ ಬೇಕು?
ಇದ್ರೊಳಗೆ ಸ್ಟೇ ಬೇಕು ಸರ್.
ಮಧ್ಯಾಹ್ನ ಮಾಡುವ.
ಆಯ್ತು ಸಾರಿ.
56 next week, ma'am.
Next week.
Yes, ma'am.
56.
56.
At request of respondent, call this matter on next week.
Malab, serial number 46, I appear for petition in this matter. 46.
6.
Yes, my lords, I undertake to file wakalat in this matter on the next date, my lords. NOC wakalat,
For respondent,
for the petitioner, my lords.
learned counsel for the petitioner seeks time. Your name, you want name to be shown, NOC.
NOC wakalat, we'll
What's the
file it
name?
on the next
What is the
date,
name?
Mr.
Name.
Ajay Kadkol.
Ajay,
Kadkol.
Kadkodi.
I'll just-
Registry to show the name of learned counsel Shri Ajay so-and-so for petitioner in the cost list.
Serial number 45, my lords.
Hmm.
I appear for the respondent. I
Hmm.
pay for a short accommodation, my lord. I
At
for
request of respondent, call this matter after 2 weeks. 45.
45, my lords. Prepare the objection.
ಅವ್ರು ಹಾಕ್ತಾರ ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು ಮುಂದೆ ಹೋಗೋಣ. I can't force her to file objections if she does.
ಈ 24.1 ನನ್ನ ಹೆಸರು ಮಿಕ್ಕಿದೆಲ್ಲ 3 ಅವರ್ 4 ಕಾಲ. ಮೇಡಮ್ ಹಾ ಒಂದ್ ಕೇಸಲ್ಲಿ ಇದೆ, ಮಿಕ್ಕಿದ್ದು ಬಿ ಪ್ರದೀಪ್ ಅಂತ.
ಮೇಡಮ್ 41 ಏನು ಅಡ್ಜರ್ನ್ ಆಗಿದೆಯಾ?
ಸಪ್ರೇಟ್ ಆರ್ಡರ್ ಮಾಡ್ತಿರಾಕ ಸಂಬಂಧ ಒಂದೇ ಜಡ್ಜ್ಮೆಂಟ್.
ಮೇಡಮ್ 41 ಮೇಡಮ್ ಮೇಡಮ್
ಸರ್ ಅರ್ಜನ್ ಆಗಿಲ್ಲ 41.
ಇಲ್ವಾ? ನೀವೇನಾ?
ನಾವೇ.
ಹೌದ್ರಾ? ಮಾಡ್ತೀರಾ? ಅದೇನ್ ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಏನಿಲ್ಲ.
ಕೌಂಟರ್ ಕೇಸ್ ಅದೇ ಅವರು ಏನು ಫರ್ದರ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಅಂತ ಹಾಕೊಂಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
ಅಲ್ಲ ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಅಲ್ಲ ಇದು.
ಅದೇ ಇದು ಹೌದು
ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್.
ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಇದು ಹೊಸಕೆರೆ ನಿಂಗಪ್ಪ ಕೇಸ್
ಓಕೆ.
ಅಪ್ಲೈ ಆಗುತ್ತೆ. ಇವಾಗ ಇದರಲ್ಲಿ ಅದೇ ಸೇಮ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಫೀಸರ್ ಮತ್ತೆ ಡಿಫ್ರೆಂಟ್.
ಬಟ್ ಎನಿಯಾವ್ ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಇದ್ರೂನು ಅಲ್ಲಿ ಪ್ರೊಫೆಷನಲ್ ಅಫೆಂಡರ್ ಆಗ್ತಾರೆ ಬಿಟ್ಟಿದ್ದಾರೆ, ಅಪೀಲ್ ಅಲ್ಲಿ ಕನ್ವಿಕ್ಷನ್
ಕನ್ವೆಕ್ಷನ್ ಆಗಿದೆ. ಹೌದು.
ದಟ್ ಈಸ್ ದಟ್ ಕ್ಯಾನ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್. ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಇರ್ಬೋದು, ಬಟ್ ಆದ್ರೂ ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆಯಲ್ಲ ಅಪೀಲ್ ಅಲ್ಲಿ ಅಷ್ಟೇ.
ಅದ್ ನಮ್ ಗ್ರೌಂಡ್ ರಿವಿಷನ್ಗೆ
ನೀವು ಮಾಡ್ತೀರಾ? ಓಕೆ.
ಸೀನಿಯರ್ ಬರ್ತಾರೆ.
ಇನ್ನೊಂದು ನಿಂದ್ರೊಳಗೆ ಹಾಕ್ ನೋಡ ಇದೆ ಇದೆ ಇಲ್ಲಿ ಹೇಳಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ Court officer. Court officer. Court officer.
ಮೇಡಮ್ ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ ಮೇಡಮ್?
ಸರ್ ಇದೆ, ವೇಟ್ ಮಾಡಿ.
ಅದು ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಅಥವಾ ಸೆಕೆಂಡ್ ಅಥವಾ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಆಗುತ್ತಾ ಮೇಡಮ್?
Serial number 27, my lord. 27. Kindly post alarm me. Number 5884 of 24. 5883.
Delay now.
84, 83 and 68, 84 of 2024. Issue notice
Please.
to respondents.
Serial number 2, my lord. File dispensation notice to respondent 2 and 3. And issue notice to respondent number 1 is the insurance company.
2 and 3 dispensation.
Yes, Mr.
Issue notice to respondent number 1. Notice to respondent number 2 and 3 are dispensed at request of appellant. Memo is accepted.
And delay of 54 days may be condoned, madam.
The notice, delay condone ಮಾಡ್ಕೊಂಡು.
Serial number 3 na? ಯಾರಿಗೆ dispensation?
Respondent number 1, 3 and 4.
Issue notice to R2. Notice is dispensed to R1, 3 and 4 at request of appellant. Memo is accepted.
14ನಲ್ಲಿ
Hmm.
it is connected with the MFA 7519 of 2023. ಇದರಲ್ಲಿ Krishnaswamy has filed appeal.
Hmm.
Respondent 1 to 3 and 5 to 6 may be dispensed.
Respondent?
Respondent 1 to 3
Hmm.
and 5 and 6 may be dispensed with. R4 Krishnaswamy.
Issue notice to R4.
Krishnaswamy has filed.
Notice to R1 to 3, comma,
And
5 and 6 is dispensed
Pardon?
at request of appellant. Memo is accepted. Learned counsel Shri A.N. Krishnaswamy is directed to take notice for respondent number 4 in view of
It may be listed along with 7519.
and
PCR may be called, man, in this case.
appeal being filed by insurance company in MFA 7519 of 23. All along with MFA 7519 of 23. All right?
Yes, man.
Serial number
PCR
25,
may be called, man.
TCR.
Yes.
The next date call model. Next date. Or early, let it be tagged down.
Quantum.
Yes, sir. 12. Notice to R1 and 2 dispense, issue notice to R3.
Serial number 25, my lord.
Hmm.
R1 may be dispensed. It's a claimant's appeal only for quantum. R1 is the offending vehicle owner.
Owner.
Please.
So
25 serial.
notice to R1 is dispensed at the request of appellant. Issue notice to R2.
16 ಅಲ್ಲಿ R1 notice may be dispensed.
16.
16.
Notice to R1 is dispensed. Issue note at the request of appellant. May be
R2.
accepted.
18 ಅಲ್ಲಿ also, my lord.
Issue notice to R2.
19 ಅಲ್ಲಿ.
19 ಅಲ್ಲಿ.
R1 ಗೆ dispensation, no?
Same.
R2 I will take notice, madam.
You notice to R2.
And 22 ಮತ್ತೆ 23 ನಲ್ಲಿ R1 ಗೆ dispensation, R2 ಗೆ I will take notice.
R1 dispensed, issue notice to R2. 23 yellow same, huh?
ಹೌದು.
Notice
Liability has been admitted.
to R1 dispense, issue notice to R2.
2, yes.
Yes. All other cases, issue notice to our respondents.
Appeal for the appellate, ma'am. I filed a dispensation memo notice to respond number 1, ma'am.
Notice to R1 is dispensed at request of appellant, memo accepted, issue notice to R2,
United India Insurance Company.
issue notice. First time, Allah.
Yes, my lord.
Next. Claimant's appeal, Allah. Claimant's appeal.
Claimant, sir.
I am for appellant, my lord. Insurance company challenging quantum, my lord.
For the issue notice to respondent. Orders on IA2, there shall be stay of implementation and operation of the impugned order. Stay application ilva. ಕೊಟ್ಟಿದ್ದೀರಮ್ಮ ನೀವು 8036.
For this court, we will deposit.
Pending consideration of, what about not pressed, are those delay? Delay is not pressed.
Please, my lord.
Stay of impugned judgment and award dated 10/7/2024 in MVC 173 of 19. Passed by Senior Civil Judge JMFC Mulabagal, MACT, CJM Kolar. Subject to the condition, the appellant deposits 50% of the award amount within 4 weeks from today, before this court.
Before this court, my lord. Much obliged.
Agree?
Honored.
Notice to respondent. Yes, Mr. Hegde.
My lord, serial number 39, my lord, I appear for the appellant. Appeal of the insurance company on the question of liability and quantum, my lord.
All. Stay of the impugned judgment and award. Asked MVC 1257 of 20, dated 18/9/24 by the MACT at Bengaluru, Chief Judge Court of Small Causes. Subject to the condition, the appellant deposits 50% of the award amount within 4 weeks. Along with interest ಮಾಡ್ತೀರಿ ನಾವು?
Your lordship may kindly order, my lord, along with interest before
Along
the
with-
tribunal.
Along with interest before the jurisdictional tribunal in 4
Obliged.
weeks.
Obliged, my lord.
Serial number 40, I appear for the petitioner, my lord.
Yes, Mr. Abu Bakr.
The very marriage itself is in dispute, my lord. And she filed, the respondent filed a petition for maintenance. It was partly allowed, but the husband, petitioner's contention, my lord, how the forcefully the very event happened and how she has filed this petition. Your lordship may kindly see at page number 13. In page 3 of the judgment and order of the trial court.
Page number?
Page number 13. In page 3, para 5.
Page number 30 in page 3.
Page number 13, in page 3 of judgment and order, para 5, my lord.
1 minute.
para 5. The respondent has taken contention marriage invitation card produced by the petitioner is created for filing of this petition. It is contended petitioner and her family members were introduced by one Mrs. Jansi, and on the same day, petitioner and her family members forced the respondent to marry the petitioner. It is contended petitioner and her family members, rowdies, have threatened the respondent and his mother for marriage of the petitioner. It is contended there is no anyone support to the respondent and his mother, and taking advantage of this position, family members of the petitioner threatened the respondent and his mother. It is contended Mrs. Jansi, petitioner, and family members came to the respondent's house and threatened that if the respondent will not marry with the petitioner, they will file case against the respondent under section 375 and 376 of IPC. And the same day, they took the respondent and his mother to one temple by forcefully and interlocked them performed the marriage. It is contended there is no sexual relationship between the petitioner and the respondent at any point of time, and they are living separately from the date of marriage. And my lord, further, your lordship may kindly see in the cross at page number 16, para 13, at the end. In the cross-examination, he has specifically admitted as under Jansi Ravaru Nanna Mele Bharatiya Danda Sahite Kalam 375 ಅಡಿಯಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲು ಮಾಡಿಸುತ್ತೇವೆ ಎಂದು ಹೆದರಿಸಿದ ಕುರಿತಾಗಿ ನಾನು ಜಾನ್ಸಿರವರ ವಿರುದ್ಧ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ದೂರನ್ನು ಕೊಟ್ಟಿಲ್ಲ. ಅದೇ ರೀತಿ ಅರ್ಜಿದಾರರ ವಿರುದ್ಧ ಕೂಡ ನಾನು ಯಾವುದೇ ದೂರನ್ನು ಕೊಟ್ಟಿಲ್ಲ. ಫರ್ದರ್ ಮಿಲಾಟ್ ಅಟ್ ಪ್ಯಾರಾ ನಂಬರ್ 14, ಅಂದ್ರೆ ದೇವಸ್ಥಾನದ ಎದುರು ಮದುವೆ ಆಗಿದ್ದೇವೆ ಅಂತ ಹೇಳಿದ್ರೆ ದೇವಸ್ಥಾನ ಕಂಪ್ಲೀಟ್ಲಿ ಗೇಟ್ ಎಲ್ಲ ಇದು ಪಿಕ್ಚರ್ ಅಲ್ಲಿ ಯಾವುದು ಕಾಣಲಿಲ್ಲ. ಅದು ಪ್ಯಾರಾ ನಂಬರ್ 14 ಅಲ್ಲಿ though PW1 cross-examined at length, nothing has been brought on record to disbelieve her evidence. No doubt in the cross-examination, it is suggested to PW1, which reads as under. ನಿಶಾನೆ P2 ಮತ್ತು ನಿಶಾನೆ P3ರ ಫೋಟೋದಲ್ಲಿ ಒಂದು ಗೇಟ್ಗೆ ಬೀಗ ಹಾಕಿದ್ದು ಕಂಡು ಬರುತ್ತಿದೆ ಅಂದರೆ ನಿಜ. ನಿಶಾನೆ P2 ಮತ್ತು ನಿಶಾನೆ P3ರ ಫೋಟೋದಲ್ಲಿ ಕಂಡುಬರುತ್ತಿರುವ ಸಂಗತಿ ಪ್ರಕಾರ ಆ ಫೋಟೋದಲ್ಲಿ ಕಂಡುಬರುತ್ತಿರುವ ದೇವಸ್ಥಾನದ ಗೇಟ್ ಓಪನ್ ಆಗದೇ ಇರುವುದು ಕಂಡುಬರುತ್ತದೆ ಅಂದರೆ ನಿಜ. ನಿಶಾನೆ P2 ಮತ್ತು ನಿಶಾನೆ P3ರ ಫೋಟೋಗಳಲ್ಲಿ ಪುರೋಹಿತರ ಭಾವಚಿತ್ರ ಕಂಡು ಬರುತ್ತಿಲ್ಲ ಎನ್ನುವುದು ನಿಜ. ಈಗ ನಿಶಾನೆ P4 ನೋಡುತ್ತಿದ್ದೇನೆ. ಈ ಫೋಟೋ ಪ್ರಕಾರ ದೇವಸ್ಥಾನದ ಗೇಟ್ ಲಾಕ್ ಆದ ಪ್ರಯುಕ್ತ ಅದರ ಮುಂದೆ ನಿಂತು ಫೋಟೋ ತೆಗೆದುಕೊಂಡಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ ಅಂದರೆ ನಿಜ. ನಿಶಾನೆ P4ರ ಫೋಟೋದಲ್ಲಿ ಹೆಚ್ಚಾಗಿ ಗಂಡು ಹುಡುಗರ ಭಾವಚಿತ್ರ ಕಂಡು ಬರುತ್ತದೆ ಅಂದರೆ ನಿಜ. ಅವರೆಲ್ಲ ಎದುರುದಾರರ ಗೆಳೆಯರು ಎಂದು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಾರೆ. ನಿಶಾನೆ P4 ಫೋಟೋದಲ್ಲಿ ಎದುರುದಾರನ ತಾಯಿ ಭಾವಚಿತ್ರ ಕಂಡು ಬರುತ್ತಿಲ್ಲ ಅಂದರೆ ನಿಜ. ನಿಶಾನೆ P4ರ ಫೋಟೋದಲ್ಲಿ ಎದುರುದಾರನ ಸಂಬಂಧಿಕರ ಭಾವಚಿತ್ರ ಕಂಡು ಬರುತ್ತಿಲ್ಲ ಅಂದರೆ ನಿಜ. So on the basis of the above said cross-examination, respondent tried to establish that his marriage with the petitioner took place forcefully and he tied Mangala Sutra to the petitioner due to threat. At the cost of the petition, I would like to say that if really the said marriage took place forcefully as alleged by the respondent, it is not clear that after the alleged marriage, why respondent has not approached the jurisdictional police to lodge complaint against the petitioner and her family members. Even he has not initiated any private complaint or civil suit seeking necessary action against the petitioner and her family members. Further, my lord, ಮತ್ತೆ page number 20 ಅಲ್ಲಿ para number 18. Page number 20, para number 18. No doubt PW1 in the cross-examination has admitted that there is no physical relationship between them from the date of marriage till today, but it is not a ground to come to conclusion that respondent has not neglected and refused. And there is no physical relationship. It's whatever the drama happened. It's only a forceful the event, my lord. and there is no marriage at all. But still, the trial court came to the conclusion and awarded partly ordered to pay the 10,000 monthly maintenance. Accordingly, it is being paid, but notice has been issued from this honorable court and paper publication also issued. Even then, she has not appeared. She will not appear also, my lord. And even with regard to the income, that is at page number 21, my lord. Page number 21 at line number 5th line. Admittedly, petitioner has not produced any income proof document of the respondent. In the cross-examination, she has clearly admitted that she has not produced any documents with regard to the income of the respondent. Hence, this court is of the opinion that petitioner has not proved the income of a respondent as alleged in the petition. And now the Milord proceedings regarding the recovery of maintenance is going on. Every month I was forced to pay 10,000 rupees.
Whether she has
Without any
initiated
valid
recovery
marriage.
proceedings?
Milord?
Whether she has initiated recovery proceedings?
Yes, on the basis of this, Milord.
Which is that?
Actually, I filed an IA for that is at page number 37, Milord. So, please to say the operation and execution of the judgment dated 19/10/2019 passed CMIS number 609 of 2018.
Whether she has filed any recovery proceedings?
Yes, she has filed, but my intention is to stay the operation and execution of the judgment of.
Good. Orders on IA number 2. Despite service of notice, there is no representation on behalf of respondent. He is unrepresented. Notice was taken out by paper publication.
Yes, my lord. Yes, my lord. First notice was 3 times notice issued. She knows it and she avoided the notice. Then we have taken paper publication.
Any other proceedings are pending between the parties?
No other proceedings.
So she has not filed recovery proceeding for recovery of this amount?
Yes, and only I have prayed for operation. Idane stay kelide nanu. Adukku adra details nanu illa.
There shall be stay of operation and execution of the impugned judgment and order dated 19/10/2019, passed in CMIS 609 of 2018. Subject to the condition, the petitioner pays and deposits rupees 5,000 towards monthly maintenance to the respondent till next date of hearing. For long.
Five 5,000 million?
5,000 per month you deposit and pay. Continue to pay.
Till the interim order.
That's the interim order. We'll see if she makes an appearance on the next date. After that, it can be decided.
Oblige, immensely oblige.
Please, ma'am. For the petitioner, the respondent was heard and not reserved for orders.
Correct. Very good. This is that case and counter case.
Please, my lord, please.
Is there anything else further to be argued from your side? No.
And last date, my lordship, my lord, heard fully, my lord, and lordship, my lord, held it part, so I'm sorry, my lord, for reserved.
Correct. Same IO, same code, but different prosecutor. That was the point which was
Same prosecutor. I was one and the same, but the prosecutor one and the same in both the cases.
correct.
That
So
is the prejudice,
the prosecutor has to be different.
different.
In your case, it is the same prosecutor.
Same prosecutor, that occasion failure of justice. That is the only point, not.
I'll post it next week.
Please, my lord,
And meanwhile, I'll prepare the judgment and then pronounce it.
please.
And learned counsel Shri Pradeep Kesi further and learned HCGP,
Yes.
Sri Lakshman list this matter on 23rd January.
But in fact, not on this point, not there is no judgment. My lordship has to not say something in this.
I think the law is pretty clear on that.
Law is very clear.
Because there will be conflict of his own.
Please, please.
Because one way he will be asking for conviction.
One way he is not seeking for acquittal.
Seeking for.
That cannot be, my lord, that cannot.
Yes.
Please.
Yes, Mr. Nayak. This was that earlier matter which I had heard.
Yes, sir.
Yes, Your
Heard
Lordship.
matter.
Regarding the loss of estate, whether it is 25%, so in respect, so far as the Manavalgan case judgment is concerned, or 50% is the question before your lordship for
My
the consideration.
contention, my lord, entitled to loss of dependency, my lord. The
Could you,
major son and married daughters, death by the mother.
there is some conflict judgments.
Yes, contrary
Your Lordship.
judgment, division bench, also single bench judgment, my lord. I have produced it, my lord, along with memo judgments, these judgments, my lord.
In the memo which I have filed, your lordship, I have culled out even my cases and the cases relied upon by the other side also. Your Lordship.
Hmm.
And the points on which those judgments speak, that also have mentioned in my memo itself.
Can you just briefly take me through with each of your memos?
Pardon, your lordship?
Can you just brief me on the,
Yes, your lordship.
Yes.
yes,
Let-
yes. Because I must have heard it
Long back.
time back. ಇದು ಕೊಡಿ ಫೈಲ್ ನೋಟ್ಸ್ ಮಾಡಿರ್ಬೇಕಾದ್ರೆ ನೋಡಿ ನೋಟ್ಸ್ ಮಾಡಿಲ್ವಾ Yes, just tell me, Mr. Nayak.
Yes, my lord. First judgment, my lord, AIR.
Just briefly tell me the facts.
Facts, my lord,
It's a case of
case
death.
of death, my lord.
So
Claimants are major son and married daughter.
claimants are
Major son and married daughters, my lord.
major son and married daughters.
House. Major sons add
The deceased, Nanjamma.
Mother.
Mother of the appellants, my lord.
So date of death is 15/2/19, is it?
15/12/2019, my lord.
So 1 and 2 are major sons,
Yes,
Kumar and Hanumantaraju.
yes,
Hanumamma and Anusayamma are the daughters,
married daughters.
married daughters.
Please.
Yes. So what has the tribunal done?
My lord, tribunal is not awarded, my lord, a loss of dependency or loss to estate. Only compensation given, my lord, love and affection, 1,60,000.
Ah,
and funeral expenses 16,500. Loss of loss
Estate?
to the estate 16,500. Total 1,93,000 along with 9% interest, my lord.
So now you're asking for the loss of dependency.
Yes, my lord. Loss of dependency as per Apex.
Found that these two major sons and daughters were dependent on the deceased
Yes, my lord.
Nanjamma.
In Nanjamma.
And what is the age of Nanjamma?
Nanjamma, age of Nanjamma, my lord, as per Exhibit 4 PM report, Exhibit 5 inquest report shows that, my lord, 60 years, my lord. Exhibit P9 producing the Aadhaar card, my lord, 70 years, my lord. The tribunal is considered, my lord, 70 years, my lord, at the time of accident.
Okay. That
Age
is
of the
exhibit-
deceased.
Exhibit?
Exhibit 9, Aadhaar card, 70 years.
Aadhaar card.
Yes,
What is the income taken?
my lord, income is not taken, my lord.
Not taken.
Not avoided, my lord, loss of dependency or loss to
Not
estate.
assessed also.
Yes, my lord. My contention, my lord, entitled to loss of dependency, my lord, a major son and married daughters, class 1 legal heirs, my lord, fully dependent, my lord.
This is all is your argument.
Yes.
Okay, what does the law say according to you, the memo with judgments?
Ready.
What do you? Judgments for the Supreme Court AR 2020 SC 434. I'm having this copy, Mister. I'm having this copy.
Please.
I have this copy. Give me the judgment.
Already copies is there.
You're relying on Birender's case.
Yes, my lord.
That is 2020.
Apex court judgment, my lord. AR 2020 SC
That
430.
speaks about para, which para?
Para number 15 and 22, my lord. I maybe read it. Para number 15, my lord. Para 15, my lord.
Yes.
It is thus settled by now that the legal representatives of the deceased have a right to apply for consideration. Having said that, it must necessarily follow that even the major married and earning sons of the deceased, being legal representative, have right to apply for compensation, and it would be the bounded duty of the tribunal to consider the application irrespective of the fact whether the concerned legal representative was fully dependent on the deceased and not to limit the claim towards the conventional aids only. The evidence on record in the present case would suggest that the claimants were working as agricultural laborer on contract basis and were earning meager income between rupees 1 lakh and rupees 150 per annum. And in that sense, they were largely dependent on the earning of their mother. In fact, were staying with her, who met with an accident at the young age of 48 years. Next, Melada para 22, Melada. Considering the above, respond number 1 and 2 would be entitled for compensation to revoked on the basis of loss of dependency due to loss of gross salary so and so of the deceased and future prospects and deduction of only 1/3 amount towards the personal expenses of the deceased. As regards the multiplier 13 applied by the tribunal and the High Court, the same needs to interference. As a result, on the facts and the circumstances of this case, the amount payable towards the compensation will be recalculated on the following basis. Loss of dependency due to loss of income calculated at rupees so and so. and deduction of the personal addition, and the claimants would be the entitled for sum of rupees 70,000 towards conventional adds directed paragraph or 59.8 Pranay Sethi. My lord, as per Pranay Sethi is considered, my lord, loss of dependency, my lord. However, next para, my lord. However, this amount along with interest at 9% and the claim petition till payment will be payable subject to the outcome of the application made by the respondent number 1 and 2, the competent authority for the grant of financial assistance under the 2006 rules. If that application is allowed and the amount becomes payable towards financial assistance under the said rules to the specified legal representative of the deceased, commensurate amount will have to be deducted from the compensation amount along with the interest component. There is the respondent number 1 and 2 therefore can be the permitted to withdraw the compensation amount only upon filing of an affidavit cum declaration before the executive court. They have not received or would claim by the amount towards the financial assistance under the 2006 rules, and if already received or to be received in future on the account, the amount so received will be disclosed to the executing court, which will have to be deducted from the compensation amount determined in terms of the order. The compensation amount therefore the paid to the respondent number 1 and 2 subject to the above and upon giving on undertaking before the executing court to the indemnify the insurance company on that extent, my lord. My lord, in this case, my lord, legal representatives are fully dependent, my lord. In this case, my lord, mother is died. Major sons are claimants, my lord. The deduction, one-third deduction, my lord.
So they are married also?
Yes, my lord. Next, my lord, judgment, second. MFA 118 of 2018. This court division bench judgment, my lord. The claimants are wife and 2 daughters, 1 son, major son. My lord, tribunal is 50% deducted, my lord. This honorable court, my lord, 1/4 is deduction, my lord. Loss of dependency, my lord. Para 8 and 9. Division bench judgment, my lord. Para 8 and 9. I may be read it, my lord.
Yes.
The other contention of the insurance company is that claimant number 1 is the husband and is deceased who has been examined as PW1.
You are
and
reading para 8.
8, my lord. Page number 6, para 8, my lord. MFA, second, my lord.
118.
118 of 2018, my lord.
Para 8 doesn't start with what you have read just now. We have considered submissions made by the.
Yes, para 8.
We have heard. Read it.
The other contention of the insurance company. Other contention of the insurance company, my lord.
Which is the judgment you're having a reported judgment?
Yes, my lord. Division bench judgment, Justice Alok Arade and Justice M.G. Kamal. MFA number 118
You have
of
given me the
2018. This court division bench judgment, my lord.
You have another copy? Para 8 starts with we have constrained, considered the submission made by learned counsel.
Yes, my lord. No other copy, my lord. No, my lord.
So next case.
Next, my lord, serial number 3, my lord, MFA 102868 of 2014, my lord. Single bench, reported judgment, my lord. In this case, my lord, para 8 onwards, my lord.
Yes.
My lord, para 9, I may be read it, my lord.
Hmm.
The learned counsel for the appellant insurance company also in his argument relied upon the judgment of the Honorable Apex Court in the case of Srimati Manjurai Behra versus the Oriental Insurance Company Limited and another, passed in civil appeal number 1702 of 2007, dated 30/3/2007, and referring to this judgment, they would submit that the married daughters are not defendants. Council also relied upon the judgment of this court passed in MFA 347 of 99 in the case of Manavalagan Malad versus Krishnamurthy and others, wherein also this court held that would be the position if the claimant legal heir is not a dependent, and held that question of awarding any amount under the heads of loss of dependency would not arise as there was no financial dependency. Next, paramalad. Land Council referring to these two judgments would vehemently contended that the tribunal failed to take note that the fact that the married daughters and major children are not dependents, and hence they are not entitled for compensation, and hence it requires the interference of this court. Further, Land Council also contends that the deduction made by the tribunal at 1/5 is erroneous, and it ought to have been 1/4 considering the number of dependents, and hence the request interference of this court. Per contra, para 12, Malad. Per contra, Land Council for appearing for the claimants would vehemently contended that the married daughters are also entitled for compensation in support of his contention. They relied upon the judgment of the Honorable Apex Court reported in Manu SC 28 of 2020 in the case of National Insurance Company Limited versus Virender and others, and brought to the notice of this court that Apex Court in similar circumstances held that our major legal representatives of the deceased have a right to apply for compensation, and even major married and earning sons of deceased being legal representatives have a right to apply for the compensation, and it would be the burden duty of the tribunal to consider the application irrespective of the fact whether the concerned legal representative was fully dependent on the deceased, and not to limit the claim towards the conventional heads only. Hence, the very contention of the insurance company cannot be accepted. Next paramela. 13. Council also relied upon the judgment of the Honorable Apex Court reported in 1987, Part 3 SCC 234 in the case of Gujarat State Road Transport Corporation Ahmedabad versus Rahmanabai Prabhabai and another, wherein the Apex Court held that brother of a person who died in any motor vehicle accident is entitled to maintain a claim petition under section 110A. Under section 110A of the Motor Vehicles Act, if he is the legal representative of the deceased. It is further held that in Indian family, brothers, sisters, and brothers' children, and sometimes foster children live together, and they are independent. They are dependent upon the breadwinner of the family. Next, Council also relied on the judgment of Kerala High Court reported in ICL 2021 Part 8 Kerala 893 in the case of United India Insurance versus Shalumal dated 25/8/2021, wherein it is discussed that in petitioner under section 166 of Motor Vehicle Act, whether dependency is a relevant criterion in a claim petition, or whether the parents and married daughters entitled to claim petition as dependents of the deceased, and held that it would be prospectus they accept the contention of the appellant that a 25 years and daughter would be no longer dependent on 49 years old mother because he was given in marriage. The bond between the mother and daughter is internal. No matter how she old may be, sometimes a girl just needs her mom. Even the dependency is a relevant criterion to claim compensation for loss of dependency. It does not mean financial dependency is the arc of covenant. Dependency includes gratuitous service dependency, physical dependency, emotional dependency, physiological dependency, and so on and so forth, which can never be equated in the terms of the money. Further, Land Council would also contended that the insurance company did not choose to examine any witness and now cannot contended that there was the contributory negligence on the.
That may not be required.
Yes. Next, if not considered a loss of dependency, that considered to the loss to estate 50%, I have some judgment is forthwith, MFA 7318 of 2016 division.
You have given?
Yes, MFA 7318 of 2016 division bench judgment,
MFA?
7318 of 2016, That's one copy there.
This is the division bench judgment.
Division bench judgment.
Puri?
Para 14 of the judgment, Para 14, In the light of the aforesaid judgments, we have no hesitation to recon the loss of estate. In this judgment, consider to the loss of estate 50%. Loss of estate deducting 50% of the income of the deceased, so and so. The material evidence on record despite that the deceased was a cancer and was aged about 46 years at the time of the accident. It is not in a dispute that the claimants were aged about 48 years and 44 years respectively at the time of filing the claim petition and there on independent occasion, but the sum would be not distant them to claim the loss of estate applying the multiplier method. In the absence of cogent positive evidence to assess the monthly income of the deceased considering the date of the accident, age and occupation of the deceased, the monthly income can be notionally determined at rupees 8,500, adding 30% towards future prospect. The monthly income would be 11,050. Is savings can be the considered as 50% would be rupees 5,525 applying the multiplier, so would be the 9,28,000 terms of National Insurance Company also
Yes.
But in this case, 50% loss of estate considered, The claimants are brothers, Next, MFA 4186 of 2018 single judge, para 10, major sons.
50% is taken because of
Loss of estate, first judgment, apex court judgment, Birender, loss of dependency considered, legal representatives are fully dependent, another single judge, loss of estate considered to the 50%, So, the two judgment, another two judgment,
Yes.
Last judgment ಅಲ್ಲಿ single bed last judgment MFA 5319 of 22 para 24 ಅಲ್ಲಿ 20 ಮನವೊಲಗನ್ನನ್ನು ಫಾಲೋ ಮಾಡಿದ್ದಾರೆ. ಪೇಜ್ ನಂಬರ್ 10 para 20 last judgment 5319 of 2022 single bench
He has followed which one? Manavalagan.
Yes,
and Birender.
Manavalagan. Birender no Malavangan ಎಲ್ಲ ಫಾಲೋ ಮಾಡಿ 50% to loss to estate considered, my lord.
Hmm.
Page number 10, para 20. I may read it, my lord. MFA 5319 of
20.
Yes, para 20.
Yes.
The Honorable Supreme Court has held in a Manavalagan versus, actually, this Honorable Court Division Bench judgment, my lord. Manavalagan versus A. Krishnamurthy and others reported in ILR 2004 Karnataka 2368, wherein for the death of the brother or sister, when the siblings filed the claim petition, normally the loss of estate would be considered 50%. Tribunal alli 15% consider ಮಾಡಿದ್ರು. However, the Honorable Supreme Court has held in the some judgment where if any evidence lead by the claimant that can be considered, the Honorable Apex Court has categorically held the above percentage in of the course subject to any specific evidence to the contrary at the claimants. On pursuit of the Honorable Supreme Court in Manavalgan case clearly reveals that the Honorable Apex Court has not restricted the loss of estate should be considered always 15%, but it inclusive the executive definition that if any evidence is laid, the court can deduct more than 50% towards the personal expenditures and consider loss of estate, my lord. ಲಾಸ್ಟ್ ಪ್ಯಾರಾ 24 ಅಲ್ಲಿ ಮಂಜುರ ಬೇರ ಜಡ್ಜ್ಮೆಂಟು ಆಮೇಲೆ ಬಿರೇಂದರ್ನು ಎಲ್ಲ ಫಾಲೋ ಮಾಡಿದ್ದಾರೆ. Followed this, my lord, para 24, my lord.
Yes.
It appears from the evidence the deceased along with this claimant were staying together in the house. Therefore, by considering the evidence on record, I am of the view that taking 15% as loss of estate is not considered in this case, whereas the division bench of this court in a case of MFA 7318 of 2016, my lord, division bench judgment, my lord. By considering the various judgment, Manjura Behra versus Oriental Insurance Company Limited and another National Insurance Company versus Birender and Vinish Jain and others case, the Manavala Mangalama and others, Basavaraj Gowda versus others case were all considered and finally 50% was deducted towards the personal expenses of the deceased, my lord. All the judgment, my lord, 50% loss to the estate is considered, my lord. This Honorable Court, my lord.
Yes.
The Apex Court is considered, my lord, loss of dependency, my lord.
Yes.
Yes, my lord. My submission, my lord, in this case, my lord, major son and married daughters, my lord, legal representatives and class 1 legal heirs, my lord, kindly consider to the loss of dependency, my lord.
But you have not proved anything to show that they are dependent. You are relying only on the basis
No,
of
my
the
lord,
judgment of the apex.
Not proved, but major son and married daughters, class 1 legal heirs, my lord, entitled to
Not in dispute by them that they are the legal heirs. I don't think you are disputing that. The question is on facts, whether have you placed any material to show that they are dependent on the deceased 70-year-old lady,
Yes.
Manjama.
mother of the appellants.
Whether is there any material produced by you? Except for the legal.
My request, my lord,
arguments.
if not considered loss of dependency, will consider to the loss to estate, my lord, 50%, my lord.
But that I don't think that also she agrees. That is
Alla,
also
alla,
25%.
ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು
Our argument prakara, it is 25%
yes,
on loss of estate.
yes.
Are you conceding that that can be given?
No, my lord, loss of estate, 50% is considered, my lord.
That's all.
Please.
For a moment, last two judgments he had not given to me in the list which he had given. So I'll just go through it. Meanwhile, my colleague will look into those. I'll make my submissions.
Yes, I think it was relied earlier itself.
Your Lordship, he has given me only these three
ಎಲ್ಲ
judgments.
ಕೊಟ್ಟಾಗಿದೆ ಸ್ವಾಮಿ ಅವಾಗಲೇ.
ಅಲ್ಲ, ಮೂರೇ judgments ಕೊಟ್ಟಿದ್ದಾರೆ ನಂಗೆ ಅದ್ರ ಮೇಲೆ. But I am not taking time on that ground, Your
All right,
Lordship.
doesn't matter.
Your Lordship, as rightly pointed out by Your Lordship, that whether they were dependents and have you brought any material on record, I just would like to bring Your Lordship's kind consideration to para 17 of the judgment, Your Lordship.
Of which judgment?
Tribunal judgment. Rather contrary material is appearing on record to show that they were not dependent on the earnings of the deceased.
Exhibit P10,
Judgment, Your Lordship,
Hmm.
judgment on page number 20,
para
para
17.
17, the Kannada version, Your Lordship.
Yes, madam.
Yes, Your Lordship. May I read it, Your Lordship?
Yes.
ಒಂದನೇ ಅರ್ಜಿದಾರ ದೃಢಕಾಯರಾಗಿದ್ದು ಅವರು ಸ್ವತಃ ದುಡಿಮೆ ಮಾಡುತ್ತಾರೆ ಎಂದರೆ ಸರಿ. ನನ್ನ ತಾಯಿ ತೀರಿದ ನಂತರ ನಾನು ಮತ್ತು ಒಂದನೇ ಅರ್ಜಿದಾರ ಬೇರೆ ಬೇರೆ ವಾಸವಾಗಿದ್ದೇವೆ. ಮೂರನೇ ಅರ್ಜಿದಾರ ಮದುವೆಯಾಗಿ ಗಂಡನ ಮನೆಯಲ್ಲಿ ಸಂಜೀವಿನಿ ನಗರದಲ್ಲಿ ವಾಸವಾಗಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ಅದೇ ರೀತಿ ನಾಲ್ಕನೇ ಅರ್ಜಿದಾರ ಮದುವೆಯಾಗಿ ಗಂಡನ ಮನೆಯಲ್ಲಿ ಮಾಗಡಿ ತಾಲೂಕು ಚಿಕ್ಕಮುದಿಗೆರೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ಸದರಿ 3 ಮತ್ತು 4ನೇ ಅರ್ಜಿದಾರರನ್ನು ಅವರ ಗಂಡಂದಿರು ಸಾಕುತ್ತಿದ್ದು ಅವರು ನಂಜಮ್ಮನ ಆದಾಯದ ಮೇಲೆ ಅವಲಂಬಿತರಾಗಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿ. ನಾನು ಹಾಗೂ
So this is admission of whom?
PW1 son, Your Lordship.
Son.
ಹಾಗೂ ಒಂದನೇ ಅರ್ಜಿದಾರ ನಾನು ಹಾಗೂ ಒಂದನೇ ಅರ್ಜಿದಾರ ಸ್ವತಃ ದುಡಿಮೆ ಮಾಡಿ ನಮ್ಮ ಹೆಂಡತಿಯರನ್ನು ಸಾಕುತ್ತಿದ್ದೇವೆ ಎಂದರೆ ಸರಿ. He himself says, mere legal representative is different and dependency is different aspect, Your Lordship, which has been rightly considered by their lordships in Birendra case also. The facts of that case, I may kindly be permitted to reiterate once again, that in that case, the mother was a government employee and these children, though they were major and married, were working as coolies. And there was, in view of the specific evidence placed on record, Honorable Apex Court has come to the conclusion that wherever they have proved their dependency, even though they are married and major, they are entitled for the loss of dependency, Your Lordship. So in my humble view, the judgment of Birendra case is not of any help to the appellants hearing because they themselves have said that they are not dependent on the earnings of the deceased and were independently earning and they were all married and residing separately also.
Yes.
So in that view of the matter, Your Lordship, the next question that would arise for Your Lordship's consideration is, if for the loss of estate, as considered by my brother advocate, what is the quantum that is to be considered while awarding compensation towards the loss of estate, Your Lordship? In this regard, I would, as I have relied upon Manavalgan case, Your Lordship, the first judgment itself, ILR 2004 KR page number 3268, Your Lordship.
Yes.
There, paragraph 16 and 19 may kindly be considered, Your Lordship. Right now missing from my file, Your Lordship. This division bench of this honorable court has given reasons why that has to be considered as 25%. Not only the children, Your Lordship, they have categorized other legal heirs also, who are all entitled to what is the percentage of that entitlement while considering loss of estate. Even 25 to 15% also they have considered, Your Lordship, for the sister and brothers also, Your Lordship. And the same judgment has also been followed by this honorable court division bench judgment in MFA 7070 of 2014, which has been disposed on 13/6/2023, Your Lordship. In this judgment, Your Lordship, paragraph 13 and 14 of the judgment, they have relied upon the Manavalgan case also.
So in Manavalgan's case, what is the?
Paragraph 16 and 19, Your Lordship.
Right. Now that says 25% of.
Yes,
forest.
25% they say.
What is that paragraph?
I'm sorry, Your Lordship.
One submission, madam.
That is at paragraph number.
Yes, Your Lordship. I'll just.
Paragraph number 20, clause, the Roman 4.
Yes, Your Lordship.
You have the judgment with you?
I'll just.
Manavalgan case, madam, 1992 accident, madam.
1 minute, brother, don't interfere. Namdan ಹೇಳಿ, please. The reasoning they have, that I have tried to bring to the kind consideration of this honorable court, para 16, your lordship, of the Manavalgan judgment reported in Indian law reports. That is, but what would be the position if the claimant, though a legal heir, is not a dependent of the deceased?
Where are you reading?
Paragraph 16 of Manavalgan judgment.
Yes,
your
yes,
lordship.
yes.
What would be the position if the claimant, though a legal heir, is not a dependent of the deceased?
Yes.
Obviously, the question of awarding any amount under the head of loss of dependency would not arise, as there was no financial dependency. In fact, in this case, the deceased was not even managing the household as is normally done by a housewife, as the husband and wife were living in different places due to exigencies of service and the couple had no children. In such a case, the main head of compensation will be loss of estate under Section 2 of the Fatal Accidents Act. The claim petition becomes one on behalf of the estate of the deceased, and the compensation received becomes part of the assets of the estate. So this is the estate for which these present appellants are entitled to, is my humble submission. At the age of 70 of the mother, it can't be expected even practically also that the mother will look after the children and they were dependent, or that she will be able to earn a huge amount and then pay 50% of her income towards the loss of estate to their children who are already aged, your lordship. At the time of filing a petition before the tribunal, 43 years, 42 years, 45 years, and 38 years. I understand if they were just 20 years, 21, 25 also, I can understand to some extent mother would be still looking after the children or paying most of her earnings for the savings of the family asset.
Yes.
The claim petition becomes one on behalf of the estate of the deceased, and the compensation received becomes part of the assets of the estate. Consequently, what is to be awarded under the head of loss of dependency under Section 1A would be nil, as there is no real pecuniary loss to the members of the family. Now, coming to paragraph 19, your lordship, we may summarize the principles enunciated thus. The law contemplates two categories of damages on the death of a person. The first is the pecuniary loss sustained by the dependent members of his family as a result of such death. The second is the loss caused to the estate of the deceased as a result of such death. In the first category, the action is brought by the legal representatives as trustees for the dependents beneficially entitled. And in the second category, the action is brought by the legal representatives on behalf of the estate of the deceased, and the compensation, when recovered, forms a part of the assets of the estate. In the first category of cases, the tribunal in exercise of power under Section 168 of the Act can specify the persons to whom compensation should be paid, and also specify how it should be distributed. That example they have given. I'll skip that example.
Yes.
But in the second category of cases, no such adjustments or alteration of shares is permissible, and the entire amount has to be awarded to the benefit of the estate. Even if the tribunal wants to specify the sharing of the compensation amount, it may have to divide the amount strictly in accordance with the personal law governing succession, as the amount awarded and recovered forms part of the estate of the deceased. Where the claim is by the dependents, I'll leave the dependents, your lordship, clause 3. Where the claim by the legal representatives of the deceased who were not dependents of the deceased, then the basis for award of compensation is losses to the estate. That is, the loss of a savings by the deceased. So the savings of an aged lady, aged 70 years, will not be to the extent of 50% of what she used to earn. It is very difficult to expect itself that at the age of 70 she would be earning. Even if it is considered she is earning, she would not be in a position to pay 50% of it, because she will be having her own ailments. Her own health had to be taken care of. So she may not be in a position to contribute towards the asset of the family, lordship. Therefore, 25%, what has been considered by the lordships of this honorable court in a division bench reported in Manavalgan's case, lordship, is justified. And the same principle has also been appreciated, and the same view has been held by the division bench of this honorable court in MFA 7070 of 2014, though it is decided on 13th June 2023, your lordships. Paragraph 13 and 14 of the judgment. They have considered this Manavalgan case also, your lordship.
No, here the para of 25% is now in
Yeah, that
Roman
25%, that I'll bring.
Roman 4, para 20.
Yes, Your Lordship.
That's probably what you want to.
Yes, Your Lordship. I have forgotten to read that. I'll read it the entire. The Roman 4, the procedure for determination of loss to estate is broadly the same as the procedure for determination of loss of dependency.
Roman 4.
Roman 4, illi barutte some. Next page number 3284. Yes, Your Lordship. If the deceased is survived by an educated employed wife earning an amount almost equal to that of her husband, and if each was maintaining a separate establishment, the question of loss of dependency may not arise. Each will be spending from his or her earning towards his living and personal expenses. Even if both pool their income and spend from the common income pool, the position will be the same. In such case, the amount spent for personal and living expenses by each spouse from his or her income will be comparatively higher. That is 3/4 of his income. Each would be saving only the balance, that is 1/4. But if the saving is taken as 1/4, the loss to the estate would be so much of amount per annum. And by adopting the multiplier of 14, they have said it, Your Lordship.
That is 25%.
25% of the earnings, Your Lordship.
So here, the calculation made is 25%.
25%. The calculation part of it is, it comes to 25%.
Of
The
the
same,
estate.
yes, Your Lord. The same view is held by Your Lordship also. That judgment also I have furnished, Your Lordship. MFA 2204 of 2021.
There were no division bench judgment. I would have just followed what I had already written.
But in
Now
the, that
problem
also,
is that after Manavalagan,
yes, Your Lordship.
there are 2 other division bench judgments which are now conflicting.
Yes, sir. But my humble, so far as those 2 judgments are concerned, Your Lordship, in the first judgment, there the dependent, one dependent was husband. In one case, wife, along with the major children, wife was also a claimant therein. And in the second judgment, husband was also a claimant along with the major children. So probably for that reason, they might have taken that consideration, and though no specific reason has been provided, Your Lordship, there.
So this Manavalagan is followed in the other division bench in 7070.
Yes, Your Lordship. Yes. Yes. In 7318, Your Lordship, what they have relied upon, the deceased was only aged 46 years. So that judgment is not applicable, Your Lordship. The paragraph 13, Your Lordship, 14 of that judgment.
Of his what he.
Of his
No,
judgment.
first you substantiate your judgment.
Yes, Your Lordship.
One is Manavalgan
Manavalgan.
by the division bench in
Yes.
2004.
Yes, Your Lordship.
And that is followed in the 2023 judgment of his Lordship, Ladyship Justice K.S. Mudgal's judgment.
Yes, yes, Your Lordship.
That is relied on the Manavalgan.
Manavalgan case also. And this honorable court in MFA 2204, Your Lordship, 2021, disposed on 20th February 2024, Your Lordship. Here also, Your Lordship is pleased to consider that judgment of Manavalgan and bifurcate it from the judgment of Birendra also, how it is not applicable.
Correct, because Birendra says that they have to show material that
Yes,
they are.
yes,
That
Your
is what Birendra says.
Yes,
The whole
yes, Your
problem is the misunderstanding of the case leads to all this.
Exactly, Lordship.
So. So you have also relied on that, no, this appellant, Justice Narendra Prasad judgment is relied by you.
Yes, ma'am.
In my memo, I have culled out the judgments relied upon both of us, Your Lordship,
Just,
but specific headings I have given.
me to the judgment
Which-
passed by me in 24.
Yes, Your Lordship.
Which paragraph?
Paragraphs 10, 11, and 13, Your Lordship. I'm very sorry, Lordship. I came with an understanding that it will be dictated today. So that judgment is also missing from the file. Paragraphs 10, 11, and 13, Your Lordship. I'm extremely sorry, Your Lordship.
Yes.
So, so far as two division bench judgments relied upon my brother counsel, Your Lordship, in one case, as I submitted, wife was also one of the claimant along with the major children, Your Lordship. And in another case, husband was also the claimant along with the major children. And the age of the deceased in that case, Your Lordship, in one case 55 years and the other one is 46 years, Your Lordship.
Now, in the judgment relied by the appellant
Yes, Your Lordship.
for the division bench judgment is one.
Yes, Your Lordship.
He relies on one division bench judgment.
Yes,
that is
Honorable Justice Sujata and
Sujata and Justice
yes,
Indresh
Indresh,
judgment.
Your Lordship.
In that, have they relied upon Manavalgan case or not relied?
Your Lordship, they have not considered that, Your Lordship, though mention has been made about it.
It was argued.
Adral ಮಾಡಿಲ್ಲ
not
sir.
relying
They have not relied upon Manavalgan case, Your Lordship. And
Tender case,
after
relying
the
upon-
judgment of this case, Your Lordship, I'm sorry to submit that specific reasons are not forthcoming, Your Lordship, why that 50% has to be. Paragraph 14, Your Lordship.
So you're relying on Birender and Justice, the Honorable Justice
Suja-
Sujata's. judgment.
Yes, relying
One
upon
division
Virender case, my lord.
One division bench.
Yes.
46 years. Paragraph 14 of the division bench judgment relied upon with the
No,
counsel
there
of
is
the
one
other
more
side.
Judgment is relied by you, no? Justice Alok Karadis, Justice MGS Kamal.
Yes.
So that they have relied on.
They have relied upon only Birender case, Your Lordship. They
That
have not,
also Manavalgan's is not. for-
considered, Your Lordship.
Not relying, my lord.
Not argued and not placed also.
Not argued.
Probably.
The flaw.
Yes, Your Lordship.
The flaw is from your end because you have not placed Manavalgan.
Yes, Your Lordship.
Not you here. in the earlier.
The counsel appearing there.
Still for the. So there they have gone totally on the basis of
Just Birender.
Birender. But even in the judgment rendered by His Lordship Justice MGS Kamal, it is on the facts 2 to 4 are considered to be dependent on the income.
Yes, Your Lordship.
But in his case,
They were not,
facts of your case, you
They
have
were
not
not
placed
dependent.
any
They were not-
material to show that they are dependent on you,
yes, Your Lordship.
the deceased. The claimants have not produced anything to show that the claimants are dependent on the deceased Nanjamma, except showing that they are legal representatives of deceased Nanjamma.
Yes, only legal representatives, my lord, not showing the.
So
defendant.
therefore, this division bench judgment relied by you of His Lordship Justice Alok Aradhe and MGS Kamal may not be applicable to you on facts. Justice Birender's judgment says that you have to show specifically that they are dependent on you. No doubt all legal representatives are entitled, but what they are entitled to is clearly stated in Manavalgan's case, followed by the other judgment in
Justice
My lord,
Mudugal-
Justice
Justice
Sujata
Mudugal.
and Indresh judgment, my lord, they relying upon the apex court judgment, Birender,
Correct, sir, but
50% to the loss to estate.
50% loss of estate provided they are dependents.
Yes.
That is clear. I don't think there is any confusion on that. With regard to Birender's case, if you are dependent and if you are able to show that you are a coolie and you are depending absolutely on the income of the deceased person, whether he is mother,
Or father.
husband, son, daughter, whoever, if you are able to place that material, then you can be considered as a dependent.
Yes.
And loss of dependency can be given. The question here is, number one is whether you are dependent, and number two, whether you are entitled to loss of estate because you are a legal representative and not a dependent. Here, admittedly, even according to your own evidence, you say that you are not a dependent.
Yes.
That's the evidence which he read, and you cannot go back on that. So at the most, you will be entitled to loss of estate. So despite there being conflicting judgments of the division bench, I don't think anything material is produced to show why this court should not agree with the two division bench judgments relied, going in accordance with Birendra's judgment.
Fine, my lord, if not considered to dependence, if considered to loss of dependency, loss to estate, my lord, 50%, my lord. My humble submission, my lord.
The loss of estate 50%, which judgment says?
My lord, division bench judgment, my lord, Justice Sujata and.
Alok Karadhasan.
That is not even considered Manavalgan's case. And what is the basis of 50%?
My lord, Malavanagan case, my lord, 1992 accident. My case, my lord, 2019 accident, my lord.
It's not
Long back, 20 years back, my lord.
That doesn't make any difference. It is the principle. It's the ratio laid down by law, by the judgment. It is not the number of years. There is no change of law from 1992 to 2004. Is there any change of law?
Rather, they have been followed by this honorable court in the latest judgments also, Your Lordship.
Madam,
The division bench.
Mudgal has followed it.
Yes, Your Lordship. Madam Mudgal and Your Lordship also.
I have also followed it. What is the judgment of His Lordship Justice Narendra Prasad? You have relied on that?
MFA 4186 of 19.
Who has relied on this judgment? Shows appellant. Must be you have relied on it.
No reasons.
Is it relevant to this case?
No reasons are.
Who has relied on this judgment?
Madam, which number?
4186 of 19.
4186 of 19, madam.
Madam, you have appeared in this matter.
Yes, Your Lordship.
Yes,
Yes, I do have. I do have, Your Lordship.
Our argument, madam.
I have.
They have not challenged
appeared.
the judgment, madam.
I have appeared, Your Lordship, that now off the record, I cannot say that I had submitted this judgment and alls. What has been considered is I can only submit that.
Oh, you're there also said since they are major sons.
Yes, Your Lord.
They are
I have
entitled
contended so.
Only for loss of estate.
Yes, Your Lord. I have contended my principle, Your Lordship. But relying upon the Manavalgan judgment, that ruling, now it's also not in my memory whether I have said it or not, but I have contended my principle, Your Lordship.
Anyway, a single judgment, so may not, I mean, of course, it is a persuasive value, but since I have my own judgment, which
Yes.
followed, following the Manavalgan's case and Birendra's and Pranay City, I think I'll have to stick on to that.
Yes.
Other basis mail 25% after fund. Though it is pretty time consuming. On the last date also you argued. I thought I would be able to pronounce it earlier, but could not find time. But
Meanwhile, Your Lordship sitting before the Dharwad bench, so which matter could not be disposed of.
Yes.
Otherwise, it could have been disposed of, Your Lordship.
all right, so I'll
Please.
say heard and then pass orders. Huh?
Yes, Your Lordship.
You have not placed anything else further from what you have last argued. Nothing is placed today, extra or
No, no,
more
no.
material.
No, Your Lordship.
Heard learned counsel, Sri Nayak. Krishna Venkatraman for appellant and Srimati Manjula Tejasvi and Tejasvi for our two. Madam Renuka, you're also in this?
She's for the first respondent KSRTC was insured with us, Your Lordship.
I'm only a formal party.
Ah,
I'm the owner of the bus
you're the owner of the bus.
and I had insured it with certain response. Who is to answer the question?
This for number 1.
So this KSRTC is insured with the
United
Yes.
Day Insurance Company.
Nimte insurance ಇದೆಯಲ್ಲ?
But ಸ್ವಲ್ಪ vehicles ಅವಾಗ they had taken a decision.
So you are relying on her submissions. Your any submissions further? So I will say you're
Sailing.
sailing. Learned Counsel so-and-so and Learned Counsel Srimati H.R. Renuka for R2, who subscribes to the contentions and arguments put forth by Learned Counsel Sri Manjula and Tejasvi. List this matter on, when is that other matter posted on? 23rd. List this matter on 27th. I will not be sitting 27th, 29th. 30th, 29th, 7th, I will not be here. 27th, iralla. 7th and 8th, iralla, I will be. 30th, I will list it
Obliged.
and pronounce it on that date.
Obliged.
Thank you for assisting the court, madam, and Naik.
Please,
Further hearing, madam. ಈ group start ಆಗಿದೆ. ಒಂದು ನಿಮಿಷ, ಅದು ಏನಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅದು? We have to start with B group. Where is that party in person? Where is the counsel for the other side? Mr. Manmohan, you are appearing in this matter. Madam Nisha ji,
Yes, sir.
what is the urgency to be taken out of turn?
Sir, I would like to place on record. a mem-
First, you have to tell me what is the, she's your,
She's my mother, sir.
please tell her to sit down. Please,
Please
please sit down. Let her sit there.
Decision. So this is a case under section 125 CRPC. I would like to place a memo of calculation for the areas that is pending.
So this and the earlier matter is one and the same.
No,
Same
sir.
parties, Lord. This is as against the proceedings under section 125 of CRPC. The amount that has been awarded is about 2.8 lakhs per month to be paid to her. That is subject matter of challenge before my lords. Now, my lord, my only difficulty, what I pointed out last date also is, but because we don't have the exhibits that are marked, we have applied, my lord, and we are yet to receive a copy. In fact, last time we applied because the file was in court, my lord, we were not able to get a copy. Because there are 100 odd documents, my lord, that are marked in evidence. And those documents are not available, including.
Now, the cost list shows that non-filing, depositing 50% of maintenance
Lord.
awarded at the rate of
What?
1,80,000.
True.
So what is this 1,80,000 is awarded by the trial court?
Not yes, Lord. 1,80,000 and then it is increased, not accordingly the order itself, not. What happened was that order was challenged before the Honorable Supreme Court, and Honorable Supreme Court had granted an interim order directing that we deposit 1 lakh per month. Now that SLP has been dismissed. So now, my lord, we are back to square one. Lord, I'll have to argue.
Or by you?
Yes, Lord, that has been
So
dismissed.
now you have now the.
I have to argue on merits.
It has attained finality on 1 lakh.
Insofar the interim order is concerned.
1 lakh.
Yes, no. That is interim order that is granted by the apex court was 1 lakh per month. What was granted by Lord Dishonorable Court was the.
Like 80.
Please, 1,80,000.
So now you are not deposited either 180 or 1 lakh.
No, 1 lakh for, I think for a period of few months, Lord, it was deposited.
What's the arrears?
Arrears, Lord, I'll have to.
If I may assist the court, my lordship.
Yes.
I am filing the memo which shows the areas. I'll just serve a copy to the opponent. Just to inform the court, the base of the case, the fact is it's a petition under 125 CRPC. I was awarded an interim maintenance in the court by the trial court, 12,750.
File it.
As per an interim maintenance of 12,750 was awarded Initially it was 20,000. He reduced it to 12,750 by going and challenging it before the Sessions Court. It got reduced to 12,750. On 30th May 2023, the Honorable Family Court passed a judgment and an order directing him to pay me 2,80,000. If the order has been taken, it's on in the petition, which is at page 17, sorry. It's at page 17 of the petition copy. He has submitted the judgment copy with it.
Yes.
And on the last page of the judgment copy
Page
is the
72.
final operative part of the order,
Hmm.
where the trial court has given a description and a detail of how it has come to the conclusion
Hmm.
of granting me 2,80,000.
Hmm.
If I'm permitted to read the order,
Hmm.
it's on page 72 of the petition copy that they have filed. The petition filed under the petitioner under section 125 CRPC is hereby allowed in part. The petitioner is entitled for maintenance from the respondent as under from 1/1/2012
Now it is 2,80,000 per month, Mr. Manmohan.
Yes.
as of date.
All right. So why don't you
My-
pay some amount?
One,
And I
I
will
have,
keep.
my
I
lord,
have till date, Lord, I have given about 45,26,000 is paid. Lord, my income, Lord, is about 42,000 per month. But the order, Lord, of the family court is to the effect that, Lord, she is used to traveling abroad on holidays. Now, that is also taken into account, and this amount is awarded. Lord, there is no justification for awarding this amount not as a maintenance. Lord, this is a maintenance amount 125. But what would be the scope of proceedings under 125? Lord, can it be that, Lord, heavens are asked for, Lord, it is given? But it cannot be so. But there has to be some justification to arrive at a figure. Now,
What
Lord,
is the justification in arriving at this figure by the trial court?
Lord, in trial court says, Lord, it disbelieves my income tax returns. It says income tax returns cannot be believed. It says that this company that was carried on by the
You're an employee or owner of the company?
Lord, erstwhile, not I was not owning a company. It became a proprietorship concern, then it was not sold. After which, Lord, I am working in the company. I'm shown as a CEO. My salary is about 42,000 per month. Now the trial court says that I have not pointed out how there's a change or sale in the of the company, and there is no justification to believe this 42,000 as being my salary. On those circumstances, the trial court says my income tax returns cannot be relied upon. And then, Lord, her claim is for 5 lakhs per month. Ultimately, the trial court says, I feel because she is used to foreign travels, she has other medical expenses, and conclusion is arrived at. Not from a reading of the order, Lord, what is apparent is, but the court says that my conduct is not right, but comes to a conclusion, then says that I am liable to pay this amount of money. But what is the basis to arrive at such a figure, Lord, is not justified. The order, Lord, is non-speaking. That is why, Lord, one, I would want to look at, Lord, the records that are marked in exhibits, and also, Lord, examine the cross-examination, Lord, of the respondent, and also as well as my cross-examination, so that, Lord, I get a complete picture of what has actually transpired. Because reasoning, Lord, from the order, Lord, I don't see anything to say how this figure has been arrived at. I can understand, Lord, saying this would be the expense for XYZ, and therefore I'm coming at a figure of 2.8 lakhs. Lord, there is nothing. Lord, the reasoning, Lord, will also turn to, Lord, page 67. Sorry, para 67
Yes.
at page 68.
Yes. Yes.
But I'm only pointing out, Lord, I will not
Yeah, no
argue,
problem.
Lord, because I
Yes.
don't want to make a submission without the records.
Hmm.
But in my considered opinion, the claim of the petitioner of 5 lakhs as maintenance per month is not only on the higher side, but it is exorbitant. In my opinion, as she is a citizen of US, as she has to travel to other countries on holiday trips, etc., it is necessary to keep in mind her such travel expenses in her remaining part of her life, even though she has separated from the respondent. After considering the lifestyle of the petitioner, the respondent, the business bar income of the respondent, and the needs of the petitioner, my opinion, justice would be met if she is awarded a monthly mint of 1,80,000 for the period 1/1/2012 to 31/12/2016. 2,30,000 from 1/1/2017 to 31/12/21, and 2,80,000 from 1/1/2022. Because it is necessary to keep in mind the raise in the cost of living, including medical treatment, travel expense, etc., the cost of living in the year 2011 was less as compared to the cost of living for 15 and 20. Therefore, in my opinion, for every 5 years, she's entitled to a hike of 50,000 in the monthly maintenance. That is why I feel appropriate to award sum of rupees 1,80,000. First 5 years, 2,30,000. Second 5 years, and 1,22,000. Sorry, 2,80,000 from 1/1/2022 onwards.
My
No,
lordship,
there has to be some justification to arrive at a figure.
my lordship, if I might just make one submission, a paragraph before what the learned counsel has read, if it can be kindly looked into, para 66. If I may be permitted to read. It says further, it is necessary, the whole order and the judgment clearly says about how the conduct of the respondent has been before, I mean, the appellant has been before the trial court. And in para 66.
What are you doing, madam?
Pardon me?
What are you doing? What's
I'm
your,
a housewife, my lordship.
what is your education?
I'm a physiotherapist, but I gave up my career for taking care of my son in the year 2000
You
itself.
have children?
I have one son who's 24 now. He's studying MBBS.
Where is he?
He's with my husband. He's not even allowed me to see my child from 2011 since the litigation started.
Where is he staying?
He's right now in Georgia. Syria, a country next to Syria. He's studying MBBS there. And I'll just read this one paragraph which will give light to the reason why the judge has given that order. In para 66, the learned judge writes, further it is necessary to keep in mind the lifestyle of the respondent. His lifestyle is even more lavish, luxurious as compared to the lifestyle of the petitioner, as he had the habit of collecting very luxurious and costly cars, costly wristwatches, possessed various properties at various parts of the country and even at abroad, allowed his son to visit various countries for more than 40 scuba divings, admitted him in a foreign college for studying medical, possesses a small boat, etc. If the status of the respondent, along with the status of the manner in which the petitioner spent her life, just before filling this petition, then in my opinion, she's entitled for appropriate befitting monthly maintenance. My lordship, my husband is a proprietor earning more than 400 machines. He's a multimillionaire. I have produced all my documents before the court. Only after, and we have asked him in cross-examination. He has wantonly changed everything, transferred the property, transferred the company. Even the lordship trial court has recorded. He has not brought records before the court, even after questioning him. The Honorable Court had directed him to produce documents. IA-2 was filed for bringing his passport, his bank statement. He has wantonly not produced that. And even the IA, which is the income tax he's referring to, he's only produced 2 documents, 2 pages. He is trying to
File your
avoid
assets
tax.
and liabilities.
This file,
This file.
this file.
It is placed here before this court.
Yes, my lord, it is placed along with the memo.
The trial court has the whole set, my lordship. He has filed
Honorable
the
Head.
assets of the trial court records have come before this Honorable Court. And the assets and liabilities is placed in that, but he has not produced all the documents. In the cross-examination, we have questioned him thoroughly with each facts, and he's admitted in that. He has not brought, he says that he sold his company. He sold it to his own employee. A manager who was earning 25,000 now is his boss giving him 42,000, which is not acceptable by any court or by any layperson also. You being a proprietor, ask you how much is the sale
An
consideration.
income tax assessor.
I am not, sir. I was a housewife. I was working for him. He paid taxes for me, but every time he took out my money, I never had to file taxes because the machines, what he gave me, he took it back. So I had no source of income. All I had was 25,000, which was never recorded on IT records. And that's the reason why I don't have any source of income. And my lordship, this Honorable Court had given an interim order to pay 50% of the areas. Instead of paying that, he had money to engage a senior counsel in Supreme Court and file the case there. For a year, the matter was held there in Supreme Court. Now, when on November, the matter got dismissed in the Supreme Court. He should have at least complied with the High Court order. He has not complied with the High Court order, nor has he complied with the Family Court order.
Where is the High Court order?
My lordship, it's in, I can give a copy. Because the matter was clubbed with a writ petition file, with the MFA file, my lordship. It is.
What is the order passed by this court? And
Yes,
the
sir.
date of that order?
On 13/12/2023. When the matter was clubbed with the MFA matter, madam, it has been recorded in the MFA file, which a copy should have been in this file. I'm
Yes, I
not.
have it. Give it back.
Okay,
13/12/23.
13/12/2023.
Yes.
It clearly says, if I may be permitted to read, as per the trial court's order, the maintenance is in areas from 1/1/2012. Interim stay of execution of the impugned order, subject to the petitioner depositing 50% of the accrued maintenance awarded at the rate of 1,80,000 per month before the executing court within 1 month from the date of this order. Instead of complying with the order, he takes it to Supreme Court, harasses me by filing it there, not serving me a copy, even though a caveat was filed. And then now, when November the case gets dismissed, he's yet giving me only 12,750. My lordship, even on the last occasion I mentioned, he's traveling
Alright,
around
Mr.
the world.
Manmohan,
Please.
now you are bound by this order. You are bound by this order passed by this court in the division bench, which was, this matter was called along with, at 50%. Have you complied with that?
Lord, I'll verify to my knowledge, no, but not the fact remains that not it is an interim order granted subject to payment of this amount.
All
Lord,
right,
if I
we'll
have not
consider
paid
the main matter, no difficulty, after you secure documents and whatever read. But you tell your client to pay this 50% of the amount, and meanwhile, we can hear the main matter. She's also ready to argue.
Lord, I don't have the financial capacity to pay that kind of money, Lord. My difficulty is not this. The quantum of money that is arrived at by the family court, Lord, if it is reasonable, Lord, I can understand. But the amount that is not arrived at, without there being any basis, Lord, if such an amount is arrived at. But in fact, Lord, the maintenance that I have paid till now, it's about 45 lakhs, Lord, I have already paid her. It's not that, Lord, I have not paid anything to her. But Lord, on the other side, how would the matter to be considered in a case where not exorbitant amount is awarded?
And you should argue the main matter.
But I'll argue the main matter. But I will not. Well, only thing is not because of change in counsel, but we would want to see the records. I'll argue the matter of merits.
When
No
you will
difficulty.
argue the matter.
Lord, immediately once I get not the papers, Lord, I'll just give me 2-3 days to run through it. Lord, immediately I'll argue the matter.
All
No
right,
difficulty.
My lordship.
Next week.
My
Very well.
lordship.
To get whatever records you want to,
Please.
and argue the matter.
Very
This
well.
can be decided by this.
Absolutely, Lord. I have no.
She can't be kept in the lurch waiting for you.
I bow down to what my Lord is saying.
My
I will
lordship.
argue the matter. No difficulty.
My lordship, they have the file since November. Our wakalat was filed on 13th November of 2023 in this matter. They have been holding the file. Even the trial court records are with the previous counsel, handed over to this gentleman here, the learned counsel. My only submission, they're procrastinating the case. My husband is not in the country. He's roaming around the world. Ever since 2022, he's not been in India. He has the money. He's just not wanting to pay me. When there's an order of the court, it is his duty to oblige and comply with the order of the court. There are judgments to that effect. I have filed with my memo of calculation that he is not, if he is not obliging or complying with the order of the court, the audience cannot be given to him. His merits it cannot be heard on merits. Because he one way was asking the court to hear him, but at the same time, he's not complying. He's mentioning about it being a bigger amount. He should have argued it before the Supreme Court. The Supreme Court clearly saw that 1 lakh he could pay it without any difficulty. Every month, 1 lakh he was paying. The minute it gets dismissed from there, 12,750. Last 10 days I've been sitting in Bangalore because he's made me file so many cases I have to contest, my lordship. I have made defense nets. I cannot travel. I have got health issues. I cannot even go to the doctor for my health issues. Because in 12,750, do I spend it for travel? Do I spend it for my stay? Do I spend it for my food or for my medical? I cannot decide on which part should I pay. I cannot engage a counsel because I don't have the money to pay them. It's not easy, but he has the money to engage senior counsels. My lordship can see even Supreme Court, he has engaged a senior counsel. Before the High Court, he has engaged several senior counsels. Trial court also, he's got senior counsels representing him. Well, I am forced to travel back and forth, party in person with a handicap. My mother is 75, my lordship. At this stage with me, she can't leave me alone. I can't leave her alone.
So you have now filed an execution petition?
I have filed an execution petition. Every time the bailiff goes there to execute the warrant, he's out of the country. She comes back with a report, he's not in the country. We cannot execute it. He's wantingly doing this, my lordship. He has the money. If he can stay from 2022 out of the country, he has the money to pay the order. And it's only 50% what the Honorable Court has directed.
Right, your execution petition is filed.
Right, my lordship.
There
That's
any
the
stay?
reason
Is there any stay of that execution proceeding?
No, because my lordship, he has asked.
There's not compliance. Therefore, Lord, he is entitled to execute it.
There is no stay, but they have asked me to give an undertaking that till the matter has been heard, that the matter should not be in the previous writ petition also, my lordship has heard the undertaking given. So I cannot get him arrested. I cannot get my money. I'm just running around in circles between courts from the last 13 years.
I will not extend that
Not the
order.
Not the undertaking, Lord, is in the writ petition, not in this.
Maybe
There,
now
Lord,
it is all connected.
True. That Lord, there not.
If he gets arrested.
Now you cannot say, ask her to give an undertaking not to initiate further proceedings in the execution.
No, we are not said so.
And you don't execute or you don't pay the amount which you agreed. And an interim order is passed and that is attained finality.
It is known, but that interim order, Lord, in this matter, my lord, is not in force as on date. In the writ petition, my lord, the only interim order is that, my lord, she will not precipitate the matter. That is because warrants were issued. But that is the only issue that was there. Now, all I'm saying is, my lord, I'll get the set of papers, but I'll argue the matter on merits.
You can
Not
do
to
that.
fix a date, but
But my lordship,
but can, if my lords not grant me some indulgence, my lords may have it on 3rd of February, fix a date not at 2:30, but I'll argue the matter. Because even my lord, we don't want to keep it pending. I
Why
understand
this
her
court
anxiety.
should give you indulgence when your client is not inclined to honor the promise made to this court and an order passed by this court?
My lord, the order, my lord, that is granted is conditional order.
Yes.
And my lord, when I'm not in a position to my lord pay that amount, but then, my lord, the interim order will stand vacant because subject to that. It is not a case where, my lord, I have not paid any amount. It's a case where I'm unable to pay the amount. There's a sea of difference between the two. It is not,
No,
not
if
intention.
this court reduces the maintenance amount,
Please,
whatever you have paid, you can deduct that for the future payments.
but to pay, my lord,
Eventually, some maintenance may be awarded. I'm not saying is going to be awarded or is going to be increased or reduced.
True.
Whatever outcome this court comes,
Hmm.
whatever you have paid, either would be reduced or increased.
true, my lord, but to say, my lord, to pay 50% of the amount, my lord, as per, my lord, her calculation, my lord, the total amount comes to about 13 crores 17 lakhs. But of course, my lord, I'll make my calculations also to that effect. So to pay that, half 50% of that, my lord, will come to about, my lord, 1 crore 50 odd lakh.
All right, forget about half of it. You
my,
show some bona fides, pay some amount.
My lord, 45 lakhs is already paid.
my
It's not
lordship,
that I have not paid any money. It is not a case. I'm sorry, 56 lakh 64,000 has been paid till date. It is not a case, not even, there is an order for.
When was it paid?
my lordship,
No, there are various dates, not, I'll make a chart also to that effect. Not starting from not 2014.
Hmm.
Not the payments are made, I think it's in. I have produced it along with the memo my lord, that was filed,
Hmm.
not by the council. You'll have to kindly see that memo, my lord.
Hmm.
Memo with documents,
Filed by?
not filed by the council for the petition number. But I think it was filed not on 2/11/23. But there are other cases also where maintenance is ordered.
no, my lordship. No, my
With
lordship, that's a
the
very
another
wrong
amount of-
submission made by the learned counsel. And the submission that made by the
minute.
learned counsel that 13 crores is there is a total lie. Even before the Supreme Court, they got an ex parte order by mentioning false statements there.
12, 6.
I have submitted my memo of calculation today, which clearly shows what is being paid and what is pending. An amount of 3 crores 17 lakhs is pending as of date.
Not page
My
7.
lordship, on
Page 7, not
page,
should get it, not the payments made.
on page 2 of my memo filed today,
This refers to not case number 226 of 12. But as per interim order, not, because the date not is not correct. Here, my lord, the total amount not comes to about 26 lakh.
Now, you have given some calculations today.
yes, my
You have
lordship.
been served with that copy?
Yes, not, I've been served with a copy.
So are you
And-
subscribing to it or you have
But I'll have to seek instructions, not
differences in this?
My
So
lordship,
according to your calculation
yes, my lordship.
in page number 3,
Yes, my lordship.
2 crores 52 lakhs
2
49.
crores 52 lakhs 49,750. But the trial court has also granted me interest because he is a businessman. He's aware of the delays, how it affects. And ever since an interim maintenance has been awarded to me, he has had me running around between execution court and recovery courts. That's the reason why the trial court has specifically mentioned it's an exceptional case and I'm granting 7.5% interest on the arrears in case if he doesn't pay it on time. So I have calculated with the address and it's coming up to 3 crores 17 lakhs, not 13 crores as the learned counsel has mentioned.
Not said 13 crores, I
You
said
did
3,
mention earlier that's the
3
reason.
crores, not 30 crores.
And my only submission before this honorable court, I have submitted a citation which clearly says, if the petitioner comes before the court, even the interim order was granted on his application. He asked the court for an order. When an order has been passed and if he's not complying with it, his petition needs to be dismissed. He cannot be allowed to be entertained his petition at all. Because my lordship, this is only disrespecting the court. And it is not the first time, my lordship. There are several contempt petitions filed against him because none of the orders of any of the courts he's ready to comply. There's a contempt as of right now for the disobedience of the MFA matter. A house that was granted, he's cut off the water line so that I don't stay there. I'm made homeless.
FA is filed for what?
MFA is not what has happened is there is a property, not which is
Or the
declaration suit
of
where
that
not
will
she,
or the gift deed, will.
settlement deed.
Settlement deed.
There's a settlement deed not which she had challenged.
That is
And
set aside.
That settlement deed is declared as bad, but insofar as not the possession she had sought for, that has been rejected. So as against it, not I have filed an appeal, so has she filed an appeal. There is an interim order directing that not she can reside in one of the houses there and not a particular gate 3 and 4 to be kept open. Now, the essence of her contempt relates to there being no water in the property, which of course not I'll place the order sheet also on record to point out that the water supply is being, not she has sought water supply from the panchayat. Because according to the panchayat, there is no connection and not the water is supplied through the borewell, etc., or tanks. Now, it's her case that the pipe in the property was not destroyed by my client. That is her allegation. And that contempt is filed, not it is meant, I think it is coming up not on 20th or so. That is where the matter stands.
My lordship,
My
it's
only,
not only
my only
water.
request is, Lord, I don't want to argue in bits and pieces. But if I have the entire papers, Lord, I will proceed to argue on merits. I'm not.
My lordship,
Once
this
and
is
for all,
taking
finally
the
not a
court
matter
for
can be
granted, my
disposed of.
lordship. They ask for an order, they don't want to comply. And when the matter comes before an executing court or the court where the court is going to take action against them, they come around saying that, okay, we will give pennies to her and we'll get it aside.
All right, you go ahead and execute the order.
My lordship, that's the reason why I've come before this court, that I have filed citation which says that recovery and execution is not the end of it. His petition should be dismissed for the fact that he's not respecting the court. The very fact that when he has approached the court, he should have complied by the order. He has the money. If my lordship, if he didn't have the money, I would not be coming before this court asking for his petition to be dismissed. He makes me run around. He comes before the court. He doesn't want to comply with the order of the court. Now he says, I don't have the money. Whatever you had, you could have paid and told the court, I don't have the money. You have the money to travel around the world. And it's not from yesterday that you have traveled. From 2022, he's traveling around out of the world, out of the country. Either he's in US, either he's in Dubai, either he's in Australia, either he's in Europe. You have money. So when that is the case, my lordship, I humbly pray that this petition should be dismissed.
Heard learned counsel for the petitioner. Now Shravana doesn't appear.
He doesn't appear.
And then counsel for the petitioner, Sri Manmohan PM. And party in person, Srimati Nisha S. Kumar. As respondent. Counsel for the petitioner seeks time to secure certain papers and documents and argue the matter. The party in person has produced memo of calculations. Along with 3 documents, including the judgments of the Honorable Apex Court. He contends that there is arrears of more than 2 crores 52 lakhs 49,750.
So 3 crores, my lordship, 3 crores 17 lakhs. The total amount that is due as of today.
Make it 3 crores 17 lakhs 90,168.75. And pursuant to the interim order passed by this court, no amount is paid. Though the interim order, though the same was taken up before the Honorable Supreme Court. And petition of the petitioner being dismissed, no effort is made by the petitioner to pay the maintenance amount. This court deems it appropriate to provide one more opportunity to the petitioner. Either the petitioner shall pay the amount as ordered by this court by way of an interim order, or proceed further to argue the matter. All contentions, including the audience of the petitioner, would be considered on the next date of hearing. List this matter on. When are you coming here? for the-
21st, my lordship, on the morning, my lordship has granted me date of 21st.
Yes, on 21st is, you can go on with the
Next
matter.
week, Lord, by then, Lord, I'll not be.
My
able to
lordship, the
get
documents
papers.
are equivalent to what is being
But there are
filed in
100 odd
MFA.
documents, Lord. 160. Lord, and not examination in chief, cross examination, everything. Lord, I would request not my habit on, Lord, 3rd of February, Lord. Yes.
You're coming for which matter on 21st?
On 21st, my lordship, the writ petition matters before this honorable court, and I have a contempt before the
So that writ petition is for what?
the writ petition with regarding the executing court's order, which they have filed a writ petition before this court, and they wanted to club it with the MFA.
Anyway, that is of no consequence now because that order, interim order is granted in that to extend it.
But it is an
No,
undertaking
no,
given.
there's only an
Undertaking,
undertaking, my
Not
lordship.
to
The
precipitate.
thing is, he can,
Proceed further in the execution.
I'm proceeding, sir. One way they tell me to give an undertaking. Now, if I arrest him in the recovery case, they will come back saying she is not complied with the undertaking given before the writ petition court. So I am stuck like this.
No. That undertaking will be vacated. I'll give you a free hand to go ahead and execute the matter.
If he's in the country, my lordship,
That is up to you.
he's running out of the country. That
It's up to you.
otherwise, my lordship, I have asked for at least him to deposit his passport. He has his passport. The honorable court can grant an order directing
No,
him
that
to
will not be
produce.
granted. You don't have, sir, this
What is
court will not grant.
petition, my lordship? He's just
Getting-
harassing me.
Consider whether dismissing his petition or what is to be ordered.
It
that
may
is-
be posted on 21st. He's not even paying anything. On 12,000, how
I'll
do
make
we
it clear,
survive?
Barkole. In view of the petitioner having not paid the amount
At least a
as ordered
cost.
by this court by an interim order. Passed on. what is that? 11?
13th December 2023, my lordship.
13 December 2023. Respondent wife, no divorce has happened yet?
No, my lordship, his divorce petition was dismissed.
Appeal is pending.
It got dismissed.
It is dismissed, appeal is pending.
No.
The respondent would be at liberty to execute the order.
Appeal pending against divorce.
Call this matter on. Third,
Please, Lord.
31st, my
Lord,
lordship.
can I seek, Lord,
Monday.
Monday?
Give it on. Fourth, huh? Fourth.
Very
The
well.
third is a MFA court.
Very well.
Fourth, I will hear all matrimonial proceedings. So
Very
fourth February.
Lord,
In the meanwhile, you can execute that order.
He is not there in the country, my lordship. I am pleading before this court is the same thing. He doesn't pay money. He keeps roaming around the court. How do I execute? And that's the reason, at least if it is dismissed, we can get some this in
Cannot be
order.
dismissed just like that, madam. Please understand, this has to be heard and dismissed. I have to
But
be
if he's not
convinced,
respecting the court,
I have to be convinced with your submission that it has to be dismissed per se without even hearing it
okay, my lordship.
because of non-violation of the interim order.
At least a cost may be granted for today, my lordship, because he's not
Yes.
complied.
You're coming from?
I'm coming from Bombay, my lordship,
Yes.
with my mom.
Yes, you
And
pay the to
ask
and
them.
fro cost. Pay the to and fro cost. Just come
Right.
from Bombay. Where is your ticket?
according,
No, I've come from Bangalore right now. I've come to Bombay, Mangalore, collect my files, come.
Produce the ticket.
Last 10 days I've been
To
staying.
Produce the ticket for coming and
instructions are
going.
she has come
My
from
stay,
Bangalore.
my
reimbursed.
food, everything, my lordship.
Madam, you please produce your ticket, food also you add it and make a memo that will be ordered. That will pass out. But he will bear your expense.
At least a lump sum can be ordered today,
No,
because
but
he's
let her
not
place
paying
it on record.
anything, my lordship. How
But what
do I
has
survive?
happened is everything is not is in the air. Not,
No, fact remains that she's not residing in Bangalore.
there is a house provided to her in Mangalore
Which what
as
is the
per the
plan?
order of the division bench. But she says she is traveling from Mumbai.
My
The house
lordship,
plot as per the order is provided in Mangalore.
a house which doesn't
Now-
have water.
Now, she's contending that she goes to Mumbai, she comes from Mumbai. In fact, my instructions are she's come from Mangalore.
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 You produce
Therefore,
that.
my lord,
Lordship,
my
a
submission to
house
my lord
that was
is-
granted by the MFA court. He has robbed all the furniture from it. He has damaged the water supply line from the overhead tank to the pipe. And that is the reason I was compelled to file a contempt. Now they come before this court saying we have given her a house. This is how they make submissions before the court.
But that
Every
matter-
court is a separate this thing, sir. I don't have a place in Mangalore because I have hearings in Mangalore. I have to travel from Bombay to Mangalore. Finish my hearing there, then I have a matter here. I have to travel to Bangalore. Since the last 10 days,
Is in Mangalore?
I have matters there. He's filed appeals over appeals.
But there
A
are
house which was
75
granted-
cases, my lord. To my instructions, my lord.
Because every case that an
So
order,
many cases are filed.
every case an order
But
is
there is
filed.
also a case, complaints that are filed against my client. When ultimate a report is given, that not false and frivolous cases are filed against him.
No,
But there are a lot of things not that are there.
Lordship, that's
It is
the-
not as though it looks, everything
there is a
clear.
report from
I'll
Annamalai.
Place on record not how
Yes,
many cases
please.
are filed.
Place
My
it,
lordship,
file it.
there
Madam, you
is-
file your expenses of coming and going along with your food and stay. I'll pass an order for granting you that costs. File a memo next date when you come, on
Next-
4th.
on next date.
4th. All this matter on 4th.
My lords have asked me to comply again with 1312 order, my lord. That is
Either
what-
you comply or you face the consequences of execution.
Very well. No, because-
And you argue on that date,
Very
on merits.
Lords have said so, my lord, because I heard it, lords have directed me to comply or she can execute is what my lords have said.
Yes,
Very well.
comply. Either you comply 1311 order or she will execute it.
Very well. If that is,
Liberty is given to execute.
very
And
well.
also you argue the matter on 4th.
Very well. I
So
shall,
on arguing the matter on 4th, your defense also or argument will be considered whether you are going to be heard because of non-compliance, because she is relying
but
on
I'll
some,
convince my lords on that, lord.
she is relying on some judgment which she must have already given.
Yes, she has furnished.
So
me,
you
lord.
can substantiate your.
Very well.
argument.
I shall. Grateful.
Yes.
Much obliged, my lordship.
You need not bring your mother if she has to.
I cannot come in alone, my lordship. I have a problem with my left arm. I ended up with paralysis because of the litigation. So I need my mom's assistance. That's the reason. Much
That's all.
obliged.
Yes, next.
Please.
My lord, in serial number 47, your lordships, I'm sorry, your lordships.
40?
47, your lordships.
Ah,
Your lordship directed to keep the respondent present before this honorable court.
ah.
Respondent mother is before this honorable court, your lordships directed. And your lordship directed to speak to the
Kindly pass over, my
Respondent.
lordship, my learned counsel is held up in another court hall.
So it may be called after one or two matters on the.
because she is left with small baby, 1 year baby at home and some.
How old is the child?
1 year, 2 months, my lord.
Why was she asked to come? Should be that costly order sheet.
Your lordships last time directed me to speak to the respondent regarding some settlement in the Araval.
She's coming from where?
Hebbal, near Hebbal.
From Bangalore only.
Bangalore. Baby is in home, that's why.
I've come all the way from Singapore, my lordship,
Hmm.
and that's why.
Petition copy ಕೊಡಿ. So only the custody and guardianship is what is involved?
Yes, my lord.
You're having a lawyer?
Yes,
Yes.
yes. Sorry.
Why are you speaking? You discharge the lawyer and you can argue like how the previously case was being argued. When your lawyer is there, you have no business to talk. So you stay back. If required, your assistance will be taken. Where is your senior colleague?
He's held up in another court, my
Go
lord.
bring him.
Kindly pass over.
Pass over.
Yes,
Just wait,
yes.
madam. Please wait for some please. Correct. Mohan. Yes, Mr. Mohan.
My lords, yes, my lords. My lords, in this case, the interim maintenance is being under challenge, my lords. Wherein I am for the petitioner herein, my lords. An award of 3,000 rupees has been given to the wife and 5,000 each to two children, my lords. It is my case, my lord, that I am the homemaker and my husband is staying in Dubai and is earning around 2 lakh rupees as per.
One submission, Your Lordship. Irrespective of all these, my submission to Your Lordship is, if the parties are directed to be present before the court, we'll try for end the everything. So he is in Dubai. He will be coming on 13th. If Your Lordship post it on 13th, I will keep the party present because the husband filed application of a petition for restitution of conjugal rights. It is also pending.
No other petition is pending.
No, only two. This one,
Maintenance and restitution.
maintenance and restitution of conjugal rights. I advised my client that ultimately she is not ready to join him. And because of this petition, it is very clear that she, her petition itself said she is not ready to join. So under such circumstances, it is better to wash both the hands and it will be, ultimately he is taking care of both the children.
It's incorrect to say so, my lord. I'm sorry
That is in the order itself, it is clearly mentioned that he is taking care of the educational expenses and other expenses of both the children.
No, my lord, it is not correct. In fact, he has invited me to stay with his parents, my lord, because he himself is in Dubai. He is not willing to take me to Dubai. He wants me to stay with his parents and to take care of the parents. I did that. But in fact, my mother-in-law told me that when your husband is not staying with us, you kindly go to your parents' house and come back when he comes to Virajpet. I was forced to move to Mysore because there is no education facility where the remote village my parents are staying, my lord. So it is not correct. And just to avoid maintenance, he has filed a petition for restitution of conjugal arrest. When he himself is in Dubai and not willing to take me to Dubai, how can that Section 9 petition can be allowed, my lord? This is it. So what they are making is not correct. If at all they do not want to take me and they want to provide maintenance, yes, let that be me, my lord. So at least for the sake of children, I'll just agree for that. But let them not make me suffer for each rupee, so that it's become extremely difficult for me to meet my educational expenses.
From when you are separated?
From, according to her, it is 2017.
That is the time he left to Dubai, my lord, with the assurance that he will take me to Dubai.
Why are you not taking her?
No, because there he cannot maintain his wife there in Dubai because that his salary doesn't permit him
What is your avocation?
2 lakhs Indian rupee.
For avocation job.
Avocation is only a PU completed.
ಏನ್ ಕೆಲಸ ಮಾಡ್ತೀರ್ರಿ?
ಕೆಲಸ ಅಂದ್ರೆ
ಕೆಲಸ ಅಲ್ಲ ದುಬೈಲಿ ಏನ್ ಕೆಲಸ ಮಾಡಲ್ವಾ?
ಅಲ್ಲ ಮಾಡ್ತಾರೆ 2 lakhs ಸಂಬಳ ಇದೆ ಅದಕ್ಕೆ.
What is the income you are drawing and what is the work you are doing? You are a civil engineer.
2 lakhs Indian rupees ಬರುತ್ತೆ ಅಂತ. See, your lordship take.
You are getting how much?
2 lakhs Indian rupees. Nine 9,932 dinars. Dubai.
How much is a dinar now?
9,932.
How much is one dinar? How much is one dinar?
That I don't. It is in the objection itself, it is stated 2 lakhs.
So maybe roughly around 18 to 20 rupees. All right. So with that 9,000, you cannot maintain your wife.
Irrespective of all, my submission to your lordship is, let it be posted on 13th. I will keep my party present. If possible, everything could be settled.
You are willing for some kind of a settlement, Mr. Mohan?
Yes, my lord. If at all there is no other option, because at least I can take care of my children, my lords. But anyway, I'll just take instructions for my client, my lords. If at all the mediation can happen, it can be invested in my...
mediation, I will keep the party in before this court. If
this court feels that it has to be referred to mediation, then it could.
All that time cannot be spent by this court. You have to go before mediation and decide your
Mysore
rights.
is further, I will
both
keep the
parties
parties.
should sit across each other and talk out your differences. How much maintenance we will. take
Please,
care
please,
of.
that's the reason why I made submission in the beginning itself. It could be sorted out by,
It's on 13th,
13th is coming to India,
13th of February.
February.
All right, Mr. Mohan.
Is it before Mysore Mediation Center, my lords, or it is before your lordships?
No, if first matter may be listed here only, then if your lordship feels that it could be
Is
referred.
there
to.
any other criminal case filed?
No, no criminal case.
So except restitution and this, nothing
And
else.
this
is-
only 2 petitions are pending.
All right, you bring your client.
Akbasu.
She's staying-
Yes,
staying where?
ma'am. I'll keep her present.
She's a resident of?
She
Mysore.
currently is residing in Mysore, my lord.
You keep her present at 11 o'clock.
Yes, my
in
lords.
the morning,
Yes, very well, my lords.
both of you. Learned counsel for the petitioner is present through video conferencing. Learned counsel for the respondent, Sri Jagdish Paligar, submits that his client, the respondent would be coming from Dubai on 13th. Hence list this matter on 13th. The petitioner and respondent shall keep themselves present to explore the possibility of an amicable settlement, including exploring mediation process between both the parties. List on 13th, 2/25.
Grateful, my lords.
For petitioner, my lord.
Ah.
Petitioner is the husband, my lord.
Hmm. Yes,
The marriage of the,
I would seek weeks' time to file the objection, your lordship. I have already drafted the
my lord, in this case, my lord,
objection, your lordship.
they have taken the warrant, my lord, executing the warrant before the trial court, my lord.
What is the
Matter
order
posted on
passed?
17/1, my lord.
What is the order passed?
My lord, page number 39, my lord, impugned order. Challenging the compromise petition recorded by the trial court, my lord.
Page number 39.
39, my lord, in page number 39.
Hmm.
The maintained the same order sheet before the court and also before the Lok Adalat, my lord. That is the procedural irregularity. The guideline issued by this honorable court, my lord, violated, my lord. On the basis of the said impugned order, my lord, they have filed the one criminal miscellaneous petition, my lord.
What was the settlement of compromise?
Compromise it at page number 32, my lord. ಇಲ್ಲಿ 32 ಅಲ್ಲಿ ಟೈಪ್ಡ್ ಇದೆ ಸ್ವಾಮಿ. ನೆಕ್ಸ್ಟ್ ಕೈಲೇ ಬರ್ದಿದ್ದಾರೆ. 32 ಪೇಜ್ ನಂಬರ್ ಅನಕ್ಷರ್ ಜೆ.
Annexure?
ಜೆ my lord.
32 is annexure D.
ಡಿ my lord. ಸರಿ. ಅರ್ಜಿದಾರರು ಮತ್ತು ಎದುರಾದ ಅಪರಾಧ ಪ್ರಕ್ರಿಯೆ ಸಂಹಿತೆ ಕಲಂ 321 ಅಡಿಯಲ್ಲಿ ಈ ಕೆಳಗಂತೆ ರಾಜಿಯಾಗಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರು ಎದುರುದಾರರ ವಿರುದ್ಧ ಜೀವನಾಂಶ ಕೋರಿ ಕೇಸನ್ನು ದಾಖಲಿಸಿದ್ದು ಇರುತ್ತದೆ. ಎದುರುದಾರರು ಸಹ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಸಮನ್ಸ್ ಜಾರಿ ನಂತರ ಹಾಜರಾಗಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರು ಮತ್ತು ಎದುರುದಾರರು ಗುರು ಹಿರಿಯರ ಮತ್ತು ಊರಿನ ಸಮಾಜದ ಮುಖಂಡರ ಜೊತೆ ಸಮಾಲೋಚಿಸಿದ್ದು ಅದರಂತೆ ಎದುರುದಾರ ಅರ್ಜಿದಾರಗಳನ್ನು ಅವರ ಜೊತೆ ಕರೆದುಕೊಂಡು ಹೋಗಲು ಒಪ್ಪಿರುತ್ತಾರೆ ಮತ್ತು ಅರ್ಜಿದಾರರ ಯೋಗಕ್ಷೇಮ ನೋಡಿಕೊಂಡು ಸಾಕಿಸಲು ಒಪ್ಪಿರುತ್ತಾರೆ ಮತ್ತು ಅರ್ಜಿದಾರರ ಮನಸ್ಸಿಗೆ ಯಾವುದೇ ಹಿಂಸೆ ಆಗುವಂಥ ಘಟನೆಗಳು ನಡೆಯದಂತೆ ನೋಡಿಕೊಳ್ಳುವುದಾಗಿ ಒಪ್ಪಿರುತ್ತಾರೆ. ಒಂದನೇ ಅರ್ಜಿದಾರರು ಸಹ ಗುರು ಹಿರಿಯರ ಸಮಕ್ಷ ಸದ್ಗುಣಿಯಾಗಿ ನಡೆದುಕೊಳ್ಳಲು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಊರಿನ ಹಿರಿಯರ ತೀರ್ಮಾನದಂತೆ ಮನಸ್ತಾಪಗಳನ್ನು ಪರಸ್ಪರ ಹೊಂದಾಣಿಕೆ ಮೂಲಕ ನಡೆದುಕೊಳ್ಳಲು ಒಪ್ಪಿದ್ದು ಇರುತ್ತದೆ. ಉಭಯತರರು ಕರಾರು ಪ್ರಕಾರ ನಡೆದುಕೊಳ್ಳಲು ಬದ್ಧರಿರುತ್ತಾರೆ. ಆ ಕಾರಣದಿಂದ ಒಂದನೇ ಅರ್ಜಿದಾರರು 2 ಮತ್ತು 3, 4ನೇ ಅರ್ಜಿದಾರರು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಲ್ಲಿಸಿದ ಜೀವನಾಂಶದ ಅರ್ಜಿಯನ್ನು ಹಿಂಪಡೆಯಲು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ಸದರಿ ಕೇಸನ್ನು ವಿಲಯ ಮಾಡಲು ಪ್ರಾರ್ಥನೆ. ನೆಕ್ಸ್ಟ್ 33 ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 8 ಎಲ್ಲ ಸಿಗ್ನೇಚರ್ ಆದ್ಮೇಲೆ 8 ಅದು ಇನ್ಕ್ಲೂಷನ್ ಆಗಿದೆ. ಎದುರುದಾರರು ಒಂದು ವೇಳೆ ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ಅರ್ಜಿದ ಯಾವುದೇ ತರಹದ ನಿರ್ಲಕ್ಷ್ಯ, ಹಿಂಸೆ, ಹೊಡಿಬಡಿ ಮಾಡಿದರೆ ಅರ್ಜಿದಾರರು ಜೀವನಾಂಶದ ಅರ್ಜಿಯ ಬದಲಿಗೆ ಈ ದಿನದಿಂದ ನ್ಯಾಯಾಲಯದ ಆದೇಶದ ದಿನದಿಂದ ಒಂದನೇ ಅರ್ಜಿದಾರರಿಗೆ 5,000 ಮತ್ತು 2ರಿಂದ 4ನೇ ಅರ್ಜಿದಾರರಿಗೆ ರೂ. 5,000ಗಳನ್ನು ಕೊಡಲು ಎದುರುದಾರರು ಒಪ್ಪಿಕೊಂಡಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರು ಜೀವನಾಂಶದ ಹಣವನ್ನು ವಸೂಲಿ ಮಾಡಲು ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಬಹುದು. ದಿಸ್ ಈಸ್ ದಿ terms and conditions, my lord. Before that, my lord, the marriage Date of the marriage is 29/3/2018, madam. Out of the wedlock, my lord, respondent number 2 to 4, born, my lord. The husband filed the divorce petition on 11/11/2019, my lord, on the ground of cruelty, my lord. 13(1)(1)A, my lord, MC number 406/2019. Thereof, wife filed the petition under section 125 CRPC, criminal miss number 9/11/2021, wherein the compromise petition filed before the court, my lord. Thereafter, my lord, they have accompanied both, my lord, they have lived together, my lord. For what the reasons best known to the respondent number 1, she returned back to the parental house, my lord, and again she filed a criminal petition number 198/2024, my lord, and sought the maintenance from the date of compromise petition, my lord. My lord, kindly peruse the judgment of this honorable court, my lord. Para 17, my lord. Apart therefrom, there is a procedural irregularity inasmuch as the compromise petition was filed before the court and thereafter the matter referred to Lok Adalat for recordal of the compromise. In this case also same procedure followed, madam. This court in Srimati Akkubai versus Sri Venkatarao and others, ILR 2014 KR 2051 has severely deprecated the said practice. Para 11 of the judgment is reproduced hereunder for easy reference. I really wonder whether the learned judge who has entertained this matter was aware of the elementary aspects of judicial functioning and the Lok Adalat. A common order sheet cannot be maintained by the court as well as the Lok Adalat. A court cannot be converted into a Lok Adalat in the order sheet maintained by the court. A portion of the proceedings is referable to the court proceedings and another portion refers to the proceedings of Lok Adalat. The conciliator has no place inside the court. The very object of accepting this Lok Adalat as an alternative mode of resolution of dispute is that all matters do not need adjudication. The matter which could be resolved by persuasion, negotiation, and understanding should be taken out of adjudication process and should be resolved by means of Lok Adalat satisfactorily, so that the cases are disposed of expeditiously and the courts will be saving the time of adjudicatory process and they can utilize that time which is saved in adjudicating the cases. If on the day the plaint is presented, the parties are also present before the court, they are ready with the compromise petition, and when they are filing an application under Order 23 Rule 3 CPC, when they are admitting the terms of the compromise and execution of the terms and conditions, then the court before which it is presented is the competent court to record the compromise and dispose of the suit in terms of the compromise. The question of referring the said dispute to the Lok Adalat would not arise. If it is referred, it is a farce. If this is accepted and encouraged, both the judicial system and this alternative dispute resolution mechanism gets a bad name and would be subjected to ridicule in the eyes of public. All persons who are indulging in this process would be doing great injustice and disservice to the judicial system. They are not conscious of their action and its repercussions and image of the judiciary which would create in the mind of the public. That is not the object with which neither Legal Services Authority Act of 1987 is passed by the Parliament, providing for the institution of Lok Adalat, nor Section 89 was introduced by the Parliament amending CPC. The essence of these provisions is neither understood by the learned judge nor by the learned counsels who are appearing for the parties. Para 18, my lord. This court has held that such a practice of recording compromise before the court and thereafter referring to the Lok Adalat is not contemplated in the Legal Services Authorities Act 1987, and as such, compromise if recorded before the Lok Adalat is required to be set aside.
All right, now the compromise has happened.
Yes, my lord.
Now after
Page
the-
number 39, my lord.
Hmm.
Last order, compromise petition filed by the parties is here accepted.
Hmm.
Case is closed in terms of the compromise. Non-judicial conciliator made a signature, my lord.
Hmm.
Judicial conciliator, there is no signature.
Hmm.
There is no signature on the judicial
In the
conciliator.
order sheet of the court,
Yes, my lord.
the non-judicial member comes and signs the judicial order. All right, this is what you're questioning here?
Yes, my lord.
Yes. How do you sustain this? So after this, something proceedings are filed after this?
Please, your lordship. Yes, your lord.
After this compromise, some proceedings are filed.
Yes,
My
your
lord.
lord. As per
Filed
annexure
by
F,
the criminal miss number 198 of 2024.
annexure F, page number 41, your lordship.
So that
41.
is filed by whom?
Wife, my lord.
By the wife,
So you are
the
appearing for whom?
respondent. The respondent,
You are appearing for whom?
husband.
I am for husband, my lord.
So now you have filed maintenance application. You have filed maintenance
Yes, your lordship.
for the wife.
Yes, your lordship. As
Recovery
per
of the
annexure
maintenance.
F, your lordship.
Recovery of the
That
maintenance,
is-
my lord, 128.
This is filed under section 128.
128 is annexure F.
Yes, your lordship.
Where is the 125 proceedings?
125 is not filed because in the order itself, your lordship, compromise petition.
So
He
you are
himself-
executing the compromise.
Please, your lordship.
You are executing the compromise, not
Yes,
the
your lordship.
125 proceedings.
Yes, your lordship.
Recovery is that compromise,
Yes,
not
your-
125.
Not 125.
So if that itself goes, then this will not survive. That is your argument.
Yes, my lord.
What is the objection to be filed? here?
No, your lordship, in this case, based on the compromise entered into between the petitioner and the respondents, your lordship, the order compromise decree came to be passed, your lordship. The order,
In that, there is some order of maintenance
yes, your lordship.
of some 5,000.
They themselves entered into a,
All right, but that
compromise.
itself, now he is seeking, then why did you participate?
Yes,
You are a participant to that compromise.
yes,
You are a participant in the compromise.
Yes, my lord.
Now you want to go back on that because he's initiated executing the recovery process.
No, my lord. I am, even today, I am ready to take back my wife, my lord. She is gone to the parental house without, and one more 498 also filed against me, my lord, and
Don't want
my
to join.
parents.
please, your
You
lord.
don't want to join your husband.
No, subsequent to this, your lordship, when, both of them were living together, your lordship, that time there was an assault. And in fact, your lordship, she was admitted to hospital. All those records are there, your lordship. And an FIR was also registered, your lordship, madam.
No, you file it in the registry, whatever you want to file.
Yes,
File it in the registry.
that's
and
why
argue the
I was just, preparing the objection, your lordship. That's why I sought a 1 week time to file this.
So what is now hanging on your head?
My lord.
A
What is
week's
the
time
now-
only I am seeking.
Warrant, my lord.
On that 128 proceeding?
Yes, my lord.
Where is that warrant issued?
They are not.
Warrant thereafter, after filing this petition, my lord, warrant is issued, my lord.
Where is
NBW
that?
is issued, my lord.
Where is that order? No such orders passed.
No,
Order for subsequent to filing of this petition, my lord.
This is coming for the first time.
Second time, my lord.
after
Stay is
notice.
granted. Stay is granted.
No, my lord, no. After issuing, issued the notice, my lord, the last occasion, without hearing,
No stay is granted. I'll stay that order.
Some, direction may be passed to deposit some amount, your lordship.
See, whether right or wrong, you have participated in the
with
compromise.
regard to the children's, my lord,
Ah.
I am ready to pay, my
How
lord.
much is that?
5,000 is there, my lord.
The total
From the date of the
maintenance,
petition, my lord,
280,000 recovery has
2 lakh
been
80,000, that is not,
Where
from
is
the
that
date,
compromise? Which is that page? Page number 39.
39, my lord.
The compromise petition is at page number 32, your lord.
Compromise.
32, your lord.
What is the
Annexure
agreement in
B.
that which is in Kannada? How much is the
Page
amount?
number 39, your lordship.
3303, mister. How much is the amount awarded to you?
5,000, my lord.
In 33, it is mentioned.
How much is that?
5,000 to the petitioner, respondent, and 5,000 insofar as 3 children are concerned.
All right, you deposit that. From when is that? 2021, you have not paid anything?
No, your
My
lord.
lord, she is living with me.
How?
And with children.
No.
After 21
After that.
compromise petition, she is living with me. How can she?
After that, how long she lived with you?
My lord, from the date of this petition, my lord, criminal miss 198, 2024, my lord. They have filed on 23, 2024, my lord.
At least from 5th October
That
2023, she
arrears
is
I
not
will
living with.
undertake to pay, my lord.
Yavaginda?
October
children, my lord.
2023.
From when? 20th March.
43.
20th March. March.
20th March 2024.
He's not staying with you.
Yes, my lord.
So from that time, she is gone, vacated and gone to her parents' house.
Yes, my lord.
You pay from March.
Please, my lord.
No, as October 2023, your lords, as per the FIR, which is registered.
You walk away. Who asked you to go? Is there some assault? You
Yes.
filed 498A.
Yes, your lordship.
You have filed.
Yes, your lord.
We consider that.
Please.
Of course. There shall be stay of operation and implementation of the impugned order in criminal miscellaneous 9/11 of 2021, dated 16/11/21. Passed by the Principal Civil Judge JMFC at Shikaripura, by Annexure E. Full stop. However, the petitioner is agreeable to pay the maintenance amount to the minor children. 3 of them,
Yes, my lord.
3 children,
Three children, my lord.
minor children, of 5,000 rupees
Yes,
together.
Yes,
my
your
lord.
lords.
Minor children at rupees 5,000 together. Whether your client is working,
No, she is not working.
I will consider that on the next date, from which shall be paid from 20th March 2023,
24, my lord.
20th March 2024. And up-to-date arrears shall be paid by the next date of hearing. Call this matter after 2 weeks.
Please, my lord. Much obliged.
Take up that matter of the lady sitting. Yes, Praveen Kumar, Kalyan.
Point.
All right, she's here now.
The parties are. Your lordship directed me to speak to the respondent in terms of the settlement is concerned. I spoke to your lordship.
How old are you, madam?
28 years.
Sorry, 28?
28.
28. What are you doing? You are working? What is your education background?
Computer science.
MTech. What is your
I have done BTech.
information IT? And you are working in Singapore? So the only proceedings pending before the party is the GNWC.
One GNWC is pending. Subsequent to the order passed in GNWC, the respondent has initiated proceedings under PV Act. And also prior to this, complaint is lodged 498A, that is investigation.
All right. So you obtained bail in that. Bail. Madam, is there no possibility of you come with somebody? Father, please come here, sir. Mr. Vasudevan, you are comfortable in English? Madam Namrata and Mr. Vasudev, is there any possibility for you to settle with Chandrakant?
He has harassed me physically.
Now, when I say settlement, I'm not asking you to go and join him. I'm asking you whether one is either you join, number one. If you are not inclined, nobody will force you. If you want to stay away from him, is there any amicable method which you are proposing for only you both separation? And for custody, we will see how and it can work out based on the age of the child and other possibilities, because he's not resident here, he's coming from Singapore. That will be the next aspect. So if you have already decided for whatever reasons, how long you have been married?
From March 15, 2021.
In 21. The child is born in 23.
15, 10,
15, 10, 23. So you are married in 2021. So we are in 25. So 5 years are already gone by. So whether is there any scope, Mr. Vasudev and Madam Namrata, that you want to amicably resolve by sitting across with your counsel, with your father, his counsel, and him across the table, sit across, put forth what you want, what are the grievances, whether it is possible to amicably separate, and what is the proposal, what is the amount of maintenance you need from him for yourself and the child. Arrive at some settlement, put it to your counsel. They will decide what is feasible according to him and according to you, your lawyer, Mr. So-and-so. So thereby Praveen Kumar and Mr. Kalyan will sit across, taking your opinion and your suggestions, what you want, how to go about it. So that will be feasible and better for you because you are young now, 29 years, he is 32. So in case it is not at all possible for you both to reside and live under the same roof, you cannot deny the fact that he is the father of the child, you are the mother of your child. So that we will make separate arrangement how to go about that. All right, Mr. Vasudev, sit across, talk for settlement, however you want it, whichever method. You can also speak to the mediator. You can tell your Mr. Praveen, who's your lawyer. He will tell that to Mr. Kalyan, and Chandrakant also will speak to the mediator. Shall I refer it to mediation?
already twice it was referred.
Twice.
Twice it was referred.
What happened?
My lord, initially both were
Reluctant.
Not reluctant, were ready. They were not willing for separation initially. Subsequently, my lord, though the petitioner Chandrakant's wife, husband is ready and willing to join with her, but she started saying, my lord, she's not ready and willing. And subsequently, my lord, there was talks in my office with regard to the separation. Some amount, my lord, which they quoted, which, my lord, the petitioner did not agree for that. And subsequently, my lord, several developments had taken place. DV proceedings are initiated.
Yes, madam.
And I was
He's actually initially ready for the separation. He did not want the child also. He's just coming in front of the court to visit the child to just gain the sympathy of the court. I am not denying that the child deserves father's love as much as it deserves mother's love. The moment I asked for the child's expenses, he started a new drama that he wants wife and child. Till then, he never wanted the wife and child. He has applied for custody.
Yours is arranged marriage?
He has applied for custody of the child, and he has put so many applications that he wants to take her for a cruise vacation. He wants to take her out for her birthday. Any father in this world will miss first daughter's first birthday. He has not even wished for her, but I have blocked him because I am in no contact from 1 year because I was tired of the harassment. He is able to send unwanted video links to me, unwanted messages to me, but he could not wish the child. It is just a form of taking revenge on me by calling the child every week, or even like for the video calls. He never contacted. On like 5th Sunday, which was even not there, that day he will message me that he wants to see the child. He knows that day is not permitted. Only last week was yesterday was the first Sunday that he called. Otherwise, he did not. Last Sunday, I waited for him. I unblocked, I waited the whole day. He never called. So it is just a form of harassing from the child is 5 months old and the child was 1 month, 2 months. I have called him myself so that after he sees the child, let him develop some love and affection.
You are working, Madam Namrata?
I was working in Singapore. And after that, after the child was taking advantage of my vulnerability, he started demanding hefty money like 1 crore. He said, only if I get that money, he will accept. And it is a female child and they are not even happy because it is a female child. He literally told me, ತೆಂಗಿನ ಸಸಿ ಬಿಸಾಕಿದ್ರೆ ಬೆಳ್ಕೊಳಲ್ವಾ ಅವಳನ್ನೇನ್ ನೋಡ್ಕೊಳೋದೇನಿದೆ. This is the attitude towards a child when she was 1.5 months old.
Both of you are from which place?
We are from
Bangalore.
Tumkur.
Huh?
Bangalore, we are settled in Bangalore, but our relations, everybody is in Tumkur.
Tumkur. And you, Chandrakant, you are from
I'm from Tumkur, born and brought up in Bangalore.
Bangalore?
Yes.
So
Now
far as-
both are settled down in Bangalore.
Now, what respondent made with regard to the budget. We made an application before the family court. He wanted to take the kid along with the respondent.
All right, you come to my chamber in 5 minutes.
Please, please,
And I would like to speak only to the
only, please. only to the
petitioner
party.
and respondent. To the file chamber. All other matters you give date. You also come, sir, Mr. Vasudev.
Madam, court officer, court officer, court officer.
ಹೇಳಿ ಸರ್, ಹೇಳಿ.
Madam, oh, today it is over, madam.
ಹಾ, ಮುಗ್ದಿದೆ ಸರ್.
Oh.
Things ಇದೆ.
Whatever it has not reached, it will come here.
Sir,
When it will come.
which is your
Yeah,
matter, sir?
49 and 52, madam,
49,
and 52, final hearing.
it is not reached, sir.
Yes, correct, madam. But when it will come next week?
One ನಿಮಿಷ, ಕೊಡು ಒಂದು ನಿಮಿಷ. 49,
And 52.
next date given is 20th January.
Yes, Monday.
52, 25th January.
Okay, madam.